Oh, okay. Thank you. Oh, yeah.
I'm seeing signal on the first one. Okay. Good morning, Tali. Ili nafi niweza.
Faces look ugly when you're alone.
Okay, ladies and gentlemen, good morning and welcome back to the third and final day of our conference and dialogue on the Constitution. The ushers, if you can assist us to direct delegates to be seated. We will start with our first panel that I will hand over to the facilitator. Our facilitator, Bulelwa Makese Mabasa, who will introduce herself. And introduce the members of the panel. We were grateful for Minister Toko Didiza joining us online. She would have loved to be here with us, but due to other commitments, she made this sacrifice to at least be with us and leave. But there are senior officials from the department who will then be. There's a clapping of hands somewhere. We will then continue with the panel to answer questions and participate in the debate. Ladies and gentlemen, let's welcome Bulelwa to the stage as a facilitator to kickstart the discussion. And we also have Advocate Tembeka Ngukaitobi, who also has to join us online from Cape Town. So they will be part of the panel. Bulelwa will introduce them. Thank you very much. Start with the minister.
Good morning. My name is Bulelwa Mabasa. I am an attorney. I am director at Worksman's Attorneys. I am an author of Land in South Africa, Contested Meanings and Nation Formation, which was published by Mistra. I am also an author of My Land Obsession. I stand here, though, in my personal capacity. It is a pleasure and an honor to be in front of you this morning on a topic that has really dominated my entire career and possibly my entire life. I am honored that we have our Honorable Minister Toko Didiza, who is the Minister of Land Reform, Rural Development. We also have amongst our midst Professor Motshekga, whom I've also had the honor and privilege of discussing these issues with. We have Advocate Tembeka Ngukaitobi SC, who I believe is joining us online. And we have Ms. T. Kati from CALS, and also Dr. Y. Abrahams. So that would be the people that would constitute the panel that we'll be discussing, which is the road ahead for land reform. Now, I felt that it's quite important for us to give this road ahead question a little bit of context. So if you would bear with me, I would require about 10 minutes of your time. I've prepared a few slides just to remind us on where were the milestone events that have taken place that have led to the discussion today. So, of course, the issue of land reform cannot be separated from the discussions around our constitutional framework. Just to put a little bit of a personal touch to it, when I started my first year at university, at Wits University, to study law, it was in the same week that the Constitution was actually promulgated, which was 4th of February, 1997. And so, in a way, you could say that for most of us, or at least some of us like myself, the Constitution presented a process of opportunity and hope for me as a legal practitioner, but also as someone who considers themselves as a champion, or rather a voice for the Constitution. So we stand here today in 2023, but I think as a member of the advisory panel for land reform, it's important to chart a way to say when we say the road ahead, where do we come from? So as part of the Presidential Advisory Panel on Land Reform, we were appointed by President Ramaphosa on 18 September 2018. Our final report was submitted to the President on the 4th of May 2019. The report was published on 28 July 2019. All affected government departments were to consider the report and to submit comments and review the report 30 days from its publication. And the report that we did as the presidential panel was grounded on rural and urban linkages whilst addressing unique territorial characteristics. Land reform as a policy has in the past, what we said in that report, neglected its linkages with urban realities and also issues of housing. We in that panel were advocating for an integrated urban development and spatial transformation issues and a unitary system of equitable tenure. So really, that report was also grounded on not just the national but international framework as well. We were looking at the 2016 UN General Assembly adopted by a new urban agenda. We looked at Chapter 8 of South Africa's new development plan that agitated for a response to deal with entrenched spatial patterns across geographical scales. And of course, we looked at the relevance of the African Union framework and guidelines on land policy in Africa. So what were we supposed to do as the Land Reform Panel? Our work was grounded on terms of reference to provide a unified policy perspective on land reform in respect of restitution, redistribution, and tenure reform. We were to consider circumstances on which expropriation without compensation will be applied. We were looking at procedures to be followed regarding expropriation without compensation, institutions that would enforce it, assessment and diagnosis of the problems and limitations of laws and policies, and to consider policies on land distribution and the policy on compensation. So we looked at land as not just a piece of ground. We looked at land in its myriad of meanings. Land as a social and cultural ontological resource, land and politics, agrarian reform, land and gender relations, land and the youth, land and mining, land and water, land and climate change, and land as heritage and identity. So we were very clear that when we're speaking of land reform, we're not talking simply just about its simplistic meaning. We looked at legislative reviews, weaknesses in current law. We understood that the fact that we have a constitution does not on its own mean that we have arrived. It means that there was work that needed to be done beyond the promulgation of the Constitution. I'm not going to go through the pieces of legislation that we identified as potentially problematic, but I think what's important also for this discussion is the fact that the diagnoses, the research, and the experiences that we have known and learned from in the land reform discussion have proven to us that not all of them reside on Section 25 of the Constitution, that the issues around land reform, when we say the Constitution protects against arbitrary deprivation of property, we then need to unpack. When we say property, what does the meaning of property mean in law? How does it differ? How many people actually have that access to property? How do our laws interpret property? Do our laws interpret property to include informal settlements, to include people that are outside of the tenure system, to include people that don't have a right to land tenure and so forth? So really, we had made certain recommendations, and I'm hoping that we will start to unpack them as we have this debate with the panelists. And so mine is not really to provide you with a speech, but rather to tease out these concepts around the road ahead. What role does the Constitution have? What can this Constitution do, its beginning and its end? And whether the realization of an equitable land reform policy is dependent solely on what is contained in Section 25. My personal view is that the Constitution is in and on itself not a not the panacea of land reform issues. That land reform issues must go hand in hand with social, economic issues. So I think I will pause here, and perhaps before I bring in Minister Didiza, I will just remind the audience around what recommendations the land reform panel had made, and maybe to just tease out what are some of those progress areas that we might know about. So in the beginning, we had recommended a consolidated integrated planning and land information system. We recommended a development of a single national data portal, allocation of available land by state-owned land, abandoned buildings, absentee landowners, the development of a proactive targeted land acquisition allocation program, and availing land in the medium term, including land donations by mining houses, churches, and so forth. And then, of course, tenure reform as well. How do we recognize diverse tenure systems? And then when it comes to urban land reform, inclusive cities with equitable, secure tenure, land administration, we recommended for a recordal, registration, and secure rights for all, and also with institutional reform. So, Minister Didiza, I'm not sure if you're able to hear me, and if you're able to come in here as you provide us with an update on where we are since the publication of the Presidential Land Reform Report, if I may. Thank you, Minister. Over to you.
Thank you very much to you, facilitator today, and also thanks to the organizers of this conference for ensuring that as we celebrate our Constitution and reflect the road we have traversed, that the issue of land in South Africa is actually part of this dialogue. And it is so because the Constitution in itself does recognize the injustices of the past and the need for all of us to reverse that, and gives particular, mandate on what the state needs to do to ensure that there is land equity in our country. As you say, a lot of studies has been done. Lots of reports have been undertaken analyzing as to why we've had such a slow pace of land reform in South Africa. What are the challenges? Some ranging from, policy inconsistency in terms of application. Some of those related to high prices of land reform and the model that the state might have adopted in the beginning, which is market-based approach without it intervening and utilizing maximally the constitutional framework that gives particular mechanisms that the state can use in order to address land inequality in our country. Some of those studies are the ones that you have just referred to on the panel that President Ramaphosa in 2019 set up to look at the land and agricultural policy, but also the implementation thereof and what challenges are there that needs to be resolved. Some of that relates to the work that was done by Parliament in the fifth administration, in which they were assessing the impact of land, not only land, but legislation since 1994 and its impact in our society, which culminated to a report that has been commonly known as the Motlanthe Report, which dedicated sections on land reform, its challenges, as well as what, in their view, needed to be addressed. That also follows the Land Summit of 2005. So one can go on a number of assessments and critique that have been done in formats of commissions or panels, but some of those have been individual academics and land activists and practitioners who have looked back on the journey of traversed and said, what had been the gaps, what progress, if any, that has been made, slow as it might be, qualitatively and quantitatively, how far have we gone? Maybe just from a statistics point of view, the team of the department is there. one can say about 10 million hectares of land thus far, both in terms of redistribution and restitution, has actually been delivered. This does not include some of those matters which have been resolved by the Land Claims Court. It also doesn't include where people might have opted as individuals, given the democratic dispensation, to actually acquire land on the open market on their own, particularly those who were historically disenfranchised. It does also not include the acquisitions that have resulted either where people might have received awards of financial compensation in land restitution. So what has happened in the implementation of the recommendations that the President Ramaphosa's panel had made in 2018 and its final report in 2019? In terms of the land allocation and acquisition and land allocation policy, that has been done. A policy on land donations to allow churches and other players who own land to donate it for land redistribution, that has been done, including incentives by the state to induce such delivery. We also, in the process, have had consultations with rural communities, particularly on communal areas, or rather land that is under customary tenure system, to look at its administration, but also at the same time, how do those tenure rights become formalized and therefore becomes of the part of the system of our land tenure in our country. Legislation currently is being drafted. There has been a consultation in February where we brought in land practitioners, activists, lawyers, and academics to actually say what should be the direction that in terms of legislation we take. You will recall that in the mid-2000s, we tried this road through the Communal Land Rights Act, which was actually struck off by the courts and certain sections of it, not all. And therefore, there was no proceeding with that legislation. We acknowledged that we needed to go back to the drawing board with consultation so that we can find a balance that satisfies communities under that land tenure system to be able to utilize it for development. We've also set up a coordinated institution within government that involves all departments as well as headed by the Deputy President, which is the Interministerial Committee on Land and Agriculture. And the importance of this structure is to ensure coordination such that indeed that lopsidedness that was identified by the panel is actually addressed, so that our land reform is not only seen in terms of land reform for agricultural development, but rather satisfy the elements that we have identified earlier in your presentation, that it must address the issues of heritage and identity, it must also address the issues of human settlement and the rest. So that institutional framework has also assisted us to ensure that the state also releases from its portfolio land for the land reform processes. We are also reviewing some of those inhibiting legislation, such as the Act of 70, by having a broad legislation that deals with the protection of agricultural land, but not arbitrarily without understanding the needs for other land uses. We've also looked at the issues of implementation and the constraints thereof within the state, so that we can actually build the state capacity, which has been identified as one of the weaknesses. Equally, how we strengthen, our institutional framework such that you prevent corruption, but also you act on corruption where such has been identified, and be able to be responsive and proactive rather than waiting where matters actually become public. We may not yet be perfect on that front, but it's something that we're working on. We're currently working on the land redistribution legislation to address what the Constitution stated in Section 25, subsection 6, that those who have got insecure tenure must actually be addressed, meaning that the state needs to provide mechanisms so that each of us who might have insecure tenure, that can actually be formalized. So one can say, in tracking the progress on the road ahead, we have started. We may not yet be there, but there is the political will, and there is, in my view, willingness to work not only alone as a state, but with other partners to be able to address that constitutional mandate. For now, I will actually stop there to allow other panelists to come on board. And I must apologize in the beginning that I would be able to leave the session at 9:45. I have to do interviews. I had indicated to the DG that unfortunately the invitation came when already there were these interviews set up, but because of the understanding of the importance of this subject matter, I felt it was necessary for me to be present and that our team of officials be there at its highest level. Thank you very much to you.
Thank you, Minister. Thank you, Minister, for those remarks and reflections. I think they give us a basis upon which to take our discussion forward. As I mentioned, we also have Advocate Thembeka Ngcukaitobi SC, who is also an author of Land is Ours and also Land Matters. Advocate Ngcukaitobi, I know that you and I at different platforms have debated and discussed whether the Constitution, which is really the subject matter of this discussion, is enough of a tool to deliver some of the challenges that we have seen with the slow pace of land reform. And if it isn't a barrier, what your views are around some of the immediate actions that may be taken by the states and maybe the legislature as well, in ensuring that we can fast-track this land reform debate. Over to you, Advocate Ngcukaitobi.
Thank you very much. I'm not sure if people can see me. I'm in a hotel room in Cape Town, so if there's a problem with signal or visibility, I apologize upfront. All right. Thank you. I had logged in when you were giving your presentation, and I listened to the whole of the minister's presentation. So I apologize if some of the things I would say you've already touched upon them, because certainly in your views and mine, there is a lot of convergence in relation to how we see, especially on the broad constitutional framework, that we are both strong believers that the constitutional framework is actually very strong, and that there have been other problems in translating that framework into tangible outcomes. But it's not, I would say, the system, that's flawed. It's the translation of that system into action, and that's been the diagnosis certainly articulated publicly and in writing and elsewhere. But what I thought I would do today is to look at 5 topics which are structural in nature but not constitutional, which I think that perhaps we can unpack to make the legislation work for land reform. And I won't be too critical. I've criticized the minister enough, I've criticized the department enough, and the Land Claims Commission enough, and the Land Claims Court. Basically, everyone available in the land space has been criticized by me. So I won't do that today. I'll try to look at what can be done. And so the first one is to look at restitution. And so what happened in the transitional period was that there was a debate, and a lot of people say that they're looking for the CODESA minutes. The CODESA minutes are available, so no one is hiding the CODESA minutes. You must just go to the archives. So, but what those minutes reflect is that there is a strong debate within the ANC and outside of the ANC about the vehicle for land reform between redistribution. The RDP favors redistribution and restitution, And the ANC's model at that stage is that the only way to achieve sustainable land reform is through a redistribution model, although there are voices that speak of restitution. And for those who don't understand the distinction, restitution is a limited form of land reform that looks at people that were dispossessed of land from the 19th of June, 1913, up until the coming into effect of the constitutional system. And it entitles them to claim, if they can prove that they are descendants or direct victims of forced removals from the 1913 Native Land Act. Now, we know those numbers from different studies. Probably the most authoritative is the Desmond Cosmas study of 1985, in which he concluded that there were approximately 5.6 million victims of forced removals, right? So those are the people that were intended to benefit from the restitution program. But what we also know, and those are statistics I unpack in Land Matters, is that by the time of the closure of the application process in 1998, I think it closed in December, there were only 79,000 applications for land restitution. So if you look at the scale and intensity of forced removals, and you look at the people that were able to claim, you can see there that there's a big disjuncture. But even if you filled the entire land restitution program, you still would not even touch the surface of the problem. So what then happens is that at the beginning, the state focus is pretty much on restitution at the expense of redistribution, whereas the RDP is clear that the crisis of South Africa, 1994, is not necessarily the crisis of forced removals. I mean, that's still a problem, but the major crisis of South Africa is a crisis of land injustice, right? So, but the problem of land injustice, it was envisaged, could not be resolved by restitution. It could only be resolved by redistribution. State policy has tended to focus on restitution, even though if you implemented everything that had to be implemented in restitution, you simply could never resolve the crisis identified in the RDP document, being the crisis of land hunger. I think the term used in the RDP document is land hunger, which I've called land injustice. All right, so that's point one, is that restitution could never work to solve the problem of land injustice. It could only be a redistribution model. The restrictive nature of restitution was always intended to fix the problem of forced removals, and that number was always kept at around 5.6 million. But it was then exacerbated by the number of applicants for restitution that submitted in 1998. And that is why the ANC government, understandably, has attempted to reopen the process. And the reopening creates a crisis of its own, because every time you reopen without having resolved the previous claims, what you find is you find competing claims over the same piece of ground. And so the problem is just self-perpetuating, instead of resolving. And that problem ended up in the Lamosa case at the Constitutional Court, in which the government is being told that you can't reopen the process until you have fixed the existing land claims, because what you are doing, you are exacerbating a social and economic catastrophe. And there has been problems of capacity, etc. You can go through that list, but I'm talking now broad policy. Okay, so point one we have to resolve is the policy choice moving away from restitution into a redistribution model if we want to resolve the problem identified by the RDP document, which is land hunger. The second issue that I want to talk to you about is expropriation as a mechanism of the acquisition of land by the state. This is a hotly debated topic, and perhaps it should not be so. we've got to understand the origins of expropriation. The origins of expropriation lie in the government of the National Party trying to create Bantustans. And that is why it passed the 1975 Expropriation Act. It was intended to give itself the power to create the ghettos or to formalize the ghettos, the Bantustans, the reserves. So it needed to pass the 1975 Act so that it can override entitlements sometimes by whites or entitlements by blacks who would resist the formation of the Bantustan. So again, you can go and find this in Hansard, in the South African Parliament Hansard, and you look at the Hansard in the debate of the 1975 expropriation bill, and you look at the prior documents that are being prepared when it was still a bill. What you find there is that the Forsters and all of these guys, what they wanted to do at that point is they wanted a legal mechanism in order to give themselves authority and power to create Bantustans. So that was the purpose of that law. What it did, it then created a legal fiction. Let's understand this to be a legal fiction, and that's the point I make in Land Matters. The legal fiction that when you are expropriating for the purposes of state acquisition, you can also pay market value, right? And old decisions, 1910, 1913, old decisions always made it clear that there is no open market when it comes to expropriation, because the willing seller, willing buyer works on the basis that there is a person who is an owner, which can be proven by a title deed, who is then putting the land in the open market, and there is a buyer who has the money. They negotiate a price, and that price is reflective of what a similar piece of ground would have sold had it been sold on an arm's length basis. Now, that structure is inapplicable, right? It's inapplicable when it comes to expropriation, because expropriation, there's one buyer, one piece of ground. There's no comparison. One buyer, one piece of ground, and the buyer is the state. And it is not as if the owner is entitled to give the land elsewhere, because the state has identified that land for a specific purpose. So there's no open market, right? But the 1975 Expropriation Act created a legal fiction that when we take the land, and most of that land is taken from whites, that land is taken from whites because they're trying to get the whites out of Transkei. Most of that land is taken from whites, getting them out of Transkei so that they can create a Bantustan. When we buy the land from whites, we're going to pay them on the basis of a willing seller, willing buyer, but it's an entirely illegal fiction, right? So that's then built into, so that's the origin of the expropriation legislation, which the ANC government has continued to apply wrongly, but I don't want to get there today, has continued to apply post-1994. And there is a big debate then during the transition, again, about what is the role of the expropriation. We know the National Party refused to give the ANC government the power of expropriation because it had the fear of what the Black government is going to do to the property system. You know, they thought the ANC government would destroy the property system, right? And the property system had become part of a larger liberal market economy, you know, that they had established in this country. But all of this is artificial because it's not a proper market, because it's a racist market that they established by law, you know, and Blacks are excluded from this market. So in the last 29 years, the ANC has struggled to present a coherent piece of legislation that would replace the 1975 expropriation or give effect to the provisions of Section 25 of the Constitution, which is this idea of justice and equity. And up until now, that idea of justice and equity is still a very contentious idea, but what does it mean? How to translate it into practice? And one of the problems with it is that the people that ultimately determine prices, we've got to understand this, the people that determine the prices of land are property valuers. There's nobody else in this country that determines the price of land. They're property valuers. The property valuers tell us all the time that the only mechanism that you learn at a valuation school is market value, right? It's market value. And that is why the Office of the Valuer General has really struggled to come with a coherent method, right, of determining compensation, distinguishing it from price, distinguishing it from value, because all of these are different concepts. But that fight is still ongoing. It really requires resolution. But the big problem now with the expropriation bill is that its promise for land reform, wider land reform, is very limited. There are three reasons why it's very limited. Firstly, you've got to look at Section 2 and Section 3 of that Act about what precisely is the scope of property that will be covered within the provisions of that Act. Firstly, it makes it clear that the property that will be targeted is property that is required by the state falling within the minister's functional area, or I think the term it uses is the minister's mandate. And who is the minister? That's the Minister of Public Works. What is the mandate of the Minister of Public Works? We don't know, because it's not spelled out in the Constitution. But what we know for sure is that that is the minister responsible for state assets. So from the beginning, the Expropriation Act is limited because its intention is to help the state acquire property, including land, for purposes of state use, right? That's one problem with it. The second problem, of course, if you look at Section 3, subsection 2, is that it may potentially entitle the Minister of Land Affairs to ask the Minister of Public Works for land that may be available for wider distribution. But the problem is that the body that has the power to expropriate for purposes of the current bill would be the Minister of Public Works, and the Minister of Public Works would be limited to land and property for the purposes of state use. But that's not what we need in this country. What we need is land for private use. We need land in order to fill the land hunger problem. We don't need more land to the state. We need less land to the state and more land to the people, right? And the third problem with it is that, of course, I've debated this, is exactly its definitional problem. What exactly does justice and equity mean? What is exempted? What is not exempted? And the big problem is that they've tried to say, these are the kind of properties that may be taken without compensation, depending on what a judge decides, and then that leaves out certain other properties that would always require compensation, which is just and equitable. But perhaps we have to accept that that's a debate we can never resolve by mechanism of a statute, and that as the legislation comes into operation, the meaning will be clearer. But the big problem that will not be resolved right now is that the expropriation bill is not going to help us as landless people to get land. It's going to help the state to get more land, but not landless people. So if you are serious about getting land to the hands of the people that need it, it will not be through the expropriation bill. The third issue I want to talk about is communal land. The minister touched upon the issue of communal land. The big problem we've had with communal land, has been chiefs. Let's face this, it's been chiefs. And what exactly has been the problem with chiefs? The problem with chiefs is that they have had a relationship with the state that enables them to claim ownership over the land, to contradict the interests of the people. So one of the things the chiefs have been pushing for very, very hard is that community-owned land, which is all registered in the name of trusts, must be registered in the name of the chief as custodian, etc. So that conflict between chiefly power and communal ownership is not being resolved by the current communal bill. In fact, it's being consolidated and perpetuated, right? But this now contradicts the Freedom Charter, right? The Freedom Charter's provision on land is that the land will belong to those who work it. right? So it doesn't say that the land will now be given to the chiefs. It says it will be given to the people. The vision of the Freedom Charter has been bottom up. It's never been top down. The problem you have with the current model of the communal land is the calcification of chiefly power through the mechanism of the state. That is now creating a lot of conflict in villages and in communal areas, right? The minister knows the case of Ingonyama Trust, where Ingonyama Trust is fighting with the communities because it is imposing arbitrary rules on communities. Women are not able to apply for stands until they bring a male relative, right? And that is said to be in the name of custom, right? Chiefs arbitrarily decide that they're going to extract rentals, right, on land that people have occupied for generations and generations, right? Commercial entities are invited on community land. They come and open shopping malls. The rentals are not paid for the benefit of the communities, but they are paid for the benefit of the trust. All of this is done in the name of trusteeship and in the name of custom. So it's a perversion of custom. So what we have been, certainly I've been arguing for, is that even if you were to try and do this through a customary mode of imagination, right? It's a distortion and a perversion of custom. It's a perpetuation of the custom as per what the white European colonists wanted, where they imposed chiefly power from the top as a mechanism of control over the communities. But what we wanted with the constitutional framework was to break chiefly authority and chiefly power and decisively change the trajectory of development so that it is in the hands of the people. So the criticism with the communal land bill at the moment is the over-concentration of power and authority on chiefs in circumstances where it's plain that the chiefs somehow have found accommodation within the structures of the ANC. What we are asking for is the ANC to change its model of development so that it's based on the needs of the people. The fourth issue I want to talk about is to resolve the problem I spoke about in relation to the expropriation bill. If we want to make progress, right, we have to locate the mandate of land reform in the Department of Land Affairs. I'm not saying this because the minister is here, but she has to say in cabinet that you cannot locate the expropriation power in the hands for land reform, not for state ownership, but you cannot locate the expropriation power for purpose of land reform in public works. You have to locate the expropriation power for purposes of redistribution of land in the Land Affairs Department, right? And maybe that is not going to happen through the expropriation bill. That is fine. That is why you need a land redistribution bill. The resolution of the ANC conference now, the ones that were published in February this year, are very promising because they don't fixate on the expropriation bill. They talk of a new idea of a land redistribution bill. But for that land redistribution bill to work, it needs to give the Minister of Land Affairs the power to acquire the land, including the power to expropriate the land, not for state use, but for private use. Now, when I debated this point about expropriation as a mechanism for acquisition for private use, you are always met with this idea that under the common law, expropriation is a mechanism for the state to acquire property for its use, right? But I say in response to that, under the Constitution, you need a mechanism to acquire property for purposes of wider redistribution. You are not going to achieve that if you take a blinkered, narrow approach that the expropriation bill focuses on at the moment. And I've made this criticism in my book. I've made it in my written representations to Parliament. But I see that the current versions of the expropriation bill do not change. But that's all fine, because perhaps if they change, they would create a mandate conflict between public works and land affairs. So my argument here is that you've got to entrust the authority, the political authority of land reform within the right department and within the right statutory instrument. And what we don't have at the moment is a land redistribution bill that entrusts the power of acquisition and redistribution statutorily. I know there is a policy, I saw they published a policy the other day on identification of beneficiaries, etc. It's not going to work unless you have a statutory foundation for it, you see, which you are entitled to do under the Constitution, but you have not been able to do so far. The last thing I want to say is around the private sector dominance. The problem we have right now, one of the problems we have right now, is when you want to acquire land, right, you have to go to the open market. Maybe you can go via redistribution if you are lucky enough to get one of those farms that have been bought and warehoused, or you may have to claim under restitution. But we know both redistribution and restitution have got the limitations I've spoken about, which means that most land transactions are taking place in the open market. But what are the problems with that? The problems with that is that that market is dominated by landowners. Landowners decide the price, right? They set the price. Either buy the land on the prices they have chosen, or you forgo the transaction if you don't want to. They also decide which land is available, even for purposes of redistribution, by the way, where the state acquires land for purposes of warehousing with the hope that in the future it can redistribute. If you look at how that land is acquired, it's decided primarily by landowners. Now, I saw an interesting research by Stellenbosch University, or I can't remember, Stellenbosch or UWC, it could have been PLUS at UWC, but they make the point that the result of the control of the land reform value chain by landowners is that 99% of land acquired for purposes of redistribution has been grazing land, just grazing land. And so high yield agricultural farms are not available for sale. It's not available for sale. It's either low yield or alternatively just open grass grazing that becomes available, because the government has yielded a lot of authority to private sector and its control over the land. So they decide the price, they set the price, they will tell you, we want so much. You can bargain about that and maybe you can take them to the land valuation, but ultimately they tell you what the price is. They also decide which land, right? So if they have not put the land in the market for sale, you've got no mechanism of going to them and say, I'm taking this land, right? They also decide the uses of the land, the uses. So they decide, okay, well, if I have got four or five farms, 3 of them are high yield, maybe I can afford to part with one. Now, what that does is that it disables the state from meeting its land reform goals, right? Because it yields a lot of authority and power to the private sector, and it restrains itself from intervening. Now, I don't say that it can arbitrarily do so, but I have set out above what the statutory instruments that the state needs, which are all permissible under the Constitution, in order to make these interventions that I'm asking for. There is some positivity in the story that I've been trying to present. For the first time, or not for the first time, but at least in the last 5 years, the ANC has abandoned the useless rhetoric of the Constitution as a stumbling block. It's finally embraced that the Constitution is its friend. The Constitution is the instrument to drive change. What we now need is that it must translate that recognition into real statutory force. That does not mean there will be no pushback. It's better that there is pushback, and the Constitutional Court can decide whether the pushback is valid or not. But it's better that there is pushback than what we see right now, which is stagnation. Thank you.
Thank you very much, Advocate Nguratobi. I like this idea of looking at how the formal property market interfaces with the world of land reform, which vests in informality. In chapter 2 of Land in South Africa, in my chapter, I write there, the formal property sector consists of 4 segments: the user segment, the financial segment, the development segment, and the land market segment. These segments have specific players in interest that are connected in a manner that reflects socio-political frameworks in which the property sector operates. The availability of property and land in the formal property sector is based on the surveying of specific urban and land, and so forth. So really the idea, which I think needs to be developed, and I think that idea that you speak of in your last point enables the discussion to move forward beyond rhetoric, and is that inherent in the formal property market is the role for government and institutions to they can either promote or frustrate the aim to ensure that land patterns begin to represent all people in an equitable manner and in a spatial sense. And I think that piece leads me to introduce Dr. Yvette Abrahams. I'm not sure if she is sitting as part of the audience or if she's online. I believe she is online. Dr. Abrahams is an organic farmer and activist and a feminist scholar. And I would like for you, Dr. Abrahams, perhaps to unpack your experiences from a gender perspective on the availability of land and whether there's been a focus or not on the issue of gender and where you think women fit into that discussion. Thank you.
Thank you very much. Can you all hear me?
We can all hear and see you.
Wonderful. Thank you so much. Thank you for introducing me as an organic farmer. I've been a practicing farmer for about 18 years, and I guess the first point of my presentation would be that farming has to be practiced. I mean, I've had ongoing concerns about how land policy and agricultural policy are made by people who aren't farmers. And so I would really like to thank you for inviting me to hear, a practical perspective. All protocol observed, I'm very honored and pleased to be invited, and I'm glad that this important sector is being represented here. I'm not just an organic farmer, I also a former commissioner for gender equality. So I did spend 5 years in the constitutional law side, working on issues of land and poverty. And I'm currently interim director of the San and Khoi Center at the University of Cape Town. So I will conclude, in my conclusion, I will make some remarks around issues of land restitution, particularly from the Khoisan perspective. But let me start by saying, now I'm not a lawyer, I'm a historian by training and a farmer by profession. But of course you can't work at a Chapter 9 institution for 5 years without having some idea about constitutional law. And I want to say from my perspective, there's nothing wrong with the Constitution. The Constitution is great. It doesn't need to be rewritten. There's no need for additional bills because the Constitution provides already everything we need. And the reason why I say that is because I think we fail to read the Constitution together with common law. The property clause in the Constitution protects private property. It states that no law may be written to imperil the right to private property. Now, if you look at the common law has as a principle that theft is a crime that never prescribes. There is no prescription period for theft. In other words, if the original title deed is based on theft, then that property, the right to that property is protected by our constitution. It is protected by our common law. It doesn't matter if the theft happened in 1657 or in 1852 or in 1914. It does not prescribe. So in that sense, I see the Constitution as protecting indigenous land rights in a very strong manner. I think the problem is how we read the Constitution, how we fail to read it together with our existing common law, and how it is implemented. So that was just my remarks in relation to the Constitution and the property clause. A lot of fluff is talked about expropriation, but the fact is the state has more than enough capacity to expropriate as it is. Where there's a problem, possibly at policy level, but certainly not at the level of the legal framework. And I'll be happy to hear, obviously, much more experienced lawyers talking on this matter. But what does the Constitution tell us when read together with the common law? That would be my question. Now, as a practicing farmer, I think there are two things which policy needs to be aware of and which policy needs to address. Now, I've managed to be a fairly successful organic farmer for 18 years. I've never had a blue cent in government subsidies. Obviously, I have a middle-class privilege. I'm able to consult. I'm able to take day jobs. So whenever the farm needs capital, I'm able to raise it. I was able to pay for it that way, and I continue to capitalize the land as I go along through my day job. But I do think it says something when your successful farmer is somebody that has never had anything to do with government support at all, zero. They did find me during COVID. I want to say I'm 29 kilometers from the Western Cape Department of Agriculture headquarters at Elsenburg. And eventually, after 16 years, they found me during COVID and wanted to deliver some seed. And I said, no, thank you, it's fine, keep your seed. And I said that for very good reason. When I started farming, the Provincial Department of Agriculture would only subsidize you, provided you were provided with a mentor. And when you looked into who this mentor was, it would be a white commercial farmer who usually was not making a profit on his own farm. As you know, over 80% of white-owned family farms are under unsustainable debt burdens and getting worse every year. And that is the reason why they look for consultancy work with the Department of Agriculture. So I said, no, thank you. I hold a PhD in Indigenous knowledge systems and Indigenous plants. I don't think I need you to mentor me. And as a result of that, I got no subsidies. It seems to have worked out. And that, I think, lends its own comment on that particular policy. As a climate change activist, obviously, I had huge problems with the approach to mentoring and with the kind of mentorship that was being offered, for the simple reason that white capitalist farming is not sustainable. It's never been sustainable. And we are now seeing the results in climate change, in droughts, in floods. You know, I've written extensively on this, but literally one could consider commercial farming as a means of mining the soil of carbon using carbon energy, which of course in turn emits carbon. I mean, our levels of soil erosion exceed our levels of food production. We lose more money in soil loss than we make in producing food off that land. And this again has been very well shown by Vandana Shiva and others. Our energy input to produce food under the current system exceeds our energy output in terms of food calories. And you do 100, 150 years of that on a piece of land, it starts to show. In the Western Cape, we have an area called the Swartland. It's called the Swartland because the soil was black when the colonizers came. It was black and fertile. That soil is now gray, and really we should be calling it the gray land. So 250 years of mining the soil for carbon is now having its effect. So my point is this: what kind of land are we restituting? For what? Are we going to continue to do what has failed so miserably as we sit and look at the KZN coastline and the, water shedding in the Eastern Cape? Is that really a role model we want to follow? And so again, this is not a legal problem. This is an implementation problem. But if the law could address it, I mean, as we're sitting now, we're trying to tax carbon emissions, where we're trying to have a national climate change policy framework. And I really think the issue of carbon emissions in agriculture is a key point, because at least people should pay for the damage that they do to the environment. When I took over my farm, it's just 1 hectare, about an hour out from Cape Town. It's not a big farm. There was nothing on there. It was a plant desert. All that we had was alien plants, you know, Port Jackson, Kikuyu, which I had to remove in order to farm. I then had to restore the 18th century ecosystem that was there before it was colonized. I had to literally rebuild the soil from scratch. I had to replant the trees. I had to rebalance the ecosystem. It is now 18 years later, a fully functioning ecosystem that feeds me and about another 4 people. So I've proven that it can be done on 1 hectare. It could only be done using indigenous.
Thank you, Dr. Abrams, for those reflections. Just to recap, what we have spoken about this morning, we gave a historical context of where this land reform topic has morphed, the different conferences, the summits, the different panels. Minister Didiza gave us her reflections on what has been done. Advocate Nurantobi has given us his views in terms of what could be, I would call them the low-hanging fruit, to try and fast-track land reform processes, land reform beyond rhetoric and things that can happen now to implement it. And we've just heard from Dr. Abrams around the importance of indigenous knowledge systems when we think about how we can, land reform can exist along with climate change obligations. And of course, the challenges that come with access to land, especially for farmers and in particular women. And I think this brings us nicely to our next panelist, Dr. Mathole Motshekga, who is sitting behind me. And I think he'll be speaking in his capacity as co-chairperson of the Constitutional Review Committee. Dr. Motshekga, placing this whole discussion this morning around the Constitution, whether it's an impediment or not, and having undergone the ad hoc joint constitutional review process with the EFF motion that was introduced then, and then it failing in Parliament because of obviously conceptual and philosophical differences, whereas the ANC stance was looking at a possibility of custodianship for land reform purposes, and where the EFF was looking at a complete nationalization of land. Dr. Motshekga, where are we right now, just in terms of the work that you've done with the committee, and where you think the constitutional debates around expropriation without compensation sit? Thank you. Over to you.
Our distinguished moderator, Mabasa, who is also my educator, though young she is, because she has written on this question and has mastered it better than I think I have done. But allow me to defy you this morning and say that I have come to the conclusion that Parliament has become irrelevant for the purpose of resolving the land question, because you have people quarreling amongst themselves who clearly don't seem to understand the nature of the land question. And my view, as we reflect on the Constitution, is that the greatest threat to our constitutional democracy is the failure of government to resolve the land question, which is at the heart of the national question. Now, therefore, I want to approach the matter, with your permission, differently. Maybe just to say that in 1986, when the ANC established the Constitution Committee and the Department of Legal and Constitutional Affairs, I was the first lawyer in the country, while I was senior lecturer at UNISA, to be appointed to serve in those structures under Professor Jack Simons, who was the chair of the Constitutional Committee, and Dr. Zola Skweyiya, who was the deputy chair and also the head of the Department of Legal and Constitutional Affairs. Now, when I was serving in those structures, I had studied with Professor Johann van Westhuizen in Germany, and he knew of my underground work with the ANC because of the work that I did in Germany. So he approached me and said, as the ANC, I want to talk to them about a conference on human and group rights. I arranged that meeting for him. He met with the ANC. That conference took place on the 1st of May, 1986. That's how far back my involvement with the land question goes. At that conference, I'm happy to see here that there are many law students, and I took their numbers, I want to work with them, because law students will help us out of these problems, because they have fresh thinking. Now, at that meeting at the University of Pretoria, organized by the Center for Human Rights, founded by Professor Johann van der Westhuizen and Johan Haynes, I worked with law student councils. We formed what we called Anti-Bill of Rights Commission. And Professor Albie Sachs, who was a member of the Constitutional Committee, did not agree with us because he thought we were against the Bill of Rights. But we were against the notion that human rights go with group rights, because in our view, group rights were meant to introduce apartheid through the back door. So we opposed that. And then the ANC called me back to Lusaka to say, no, come and explain yourself. Why did you say this? I agreed with them. I explained to them. Then they gave me money to run other meetings with the youth, the law students. And the work that we did contributed to what the ANC statement on negotiations of 1987, which rejected group rights. And then in 1988, the ANC adopted constitutional guidelines for a democratic South Africa. In those guidelines, the ANC said 87% of the total surface of this country is in the hands of a minority, and the majority has only 13%. And the guidelines said, unless the land question is resolved, African people will remain trapped in poverty forever. And where we stand now, the biggest problem is poverty, unemployment, and inequalities, which have led to the deepening moral degeneration and social ills. Now we are even told that South Africa is the most unequal country in the world. How can a country that produces gold, diamonds, platinum and all this. A country that has the richest arable land be the most unequal country in the world unless there is an original sin. And I want to agree with President Ramaphosa that the original sin was the violent dispossession of African people of their land and the natural resources. Unless that becomes our starting point, it means we are nowhere nearer to resolving the land question and securing our constitutional democracy, which was achieved through the loss of lives, blood, and limbs. So I'm addressing this matter not on behalf of a parliament which has failed the people of South Africa because of hooliganism and other things. I want to address this question informed by what I believe to be the best interest of the people of South Africa and the future of South Africa. We all have no doubt, and we know, that in 1652, a man called Jan van Riebeeck arrived, and his Dutch followers, they violently dispossessed the Khoisan people of the land and natural resources. Thereafter came the British. They conquered the Dutch, they took over, they ended the slavery which was introduced by the Dutch, and the Dutch got angry. They moved into the northern provinces looking for land and natural resources. And then they violently dispossessed the people of the Free State, the Transvaal of land and natural resources, and they established the Boer republics. Now, after establishing those Boer republics, there were minerals which were discovered. Now the English wanted the minerals. Now they fought against the Boers or Afrikaners for the minerals. Now there was a first Anglo-Boer War in 1880 to 1881, and African people fought on the side of the British, hoping that in the event of victory, they would regain their land and its natural resources. So Africans never gave up the right to their land and natural resources. They went to war on the side of society established by Cecil John Rhodes, appointed Sir Godfrey Lagden commission to investigate into the racial and territorial segregation. And the Ethiopian movement and the native congresses of the time opposed that, but they were overruled, and that's how Selborne, the successor of Milner, then started the unification which brought the Republic of the Union of South Africa. In 1986, I said at the University of Pretoria that the Union Act was illegitimate because it was adopted by the settlers and then ratified by the British imperialists, contrary to the will of the majority of Africans. And therefore, I say, what was done under the Union, the South Africa Act and the Union Act is illegitimate. And I said that at a conference of the ANC called the World United Against Apartheid in Arusha, Tanzania, and the whole international conference supported my thesis. And Professor Kada Asma wrote an article in Sechaba supporting that article. But now, 1913, the illegitimate union government adopts the Natives Land Act 27 of 1913 But an illegitimate government adopting an act that affects the life of the majority of the people without their consent cannot be a legitimate statute. So my argument is that the South Africa Act that established the Union and this native land were illegitimate. And I want to come therefore to the conclusion that for CODESA to accept that 1913, June 1913 is the cutoff date for land claims was wrong, because by 1910, Africans had about 7% of the total surface of South Africa. And if that is the case, are you saying Africans must only claim 7% of their land? In 1936, that was increased to 13%, which was native reserves or locations. Are we saying that African people must claim only 13%, which is the area of the Bantustans? So I'm saying all the arguments that the minister is making, that Nukaitobi is making, are actually not dealing with the situation that we need to save the Constitution. Because you can see that they are talking about views, plans, and things like that, which have not materialized for the next 30 years. Now, if we are going to wait for what they are saying to materialize, by the time they come back to report to us, there will be no South Africa. Because I can tell you that there are demagogues emerging in the country who are going to go for national elections next year on the basis that the governing party, the ANC, has failed to address the land question. And those demagogues who have no plan and no understanding of what the people need are going to win the elections and throw this country into chaos. Now, to avoid that chaos, I want to commend the organizers of this conference, commend our government for allowing this to take place and giving us a platform to reflect on our Constitution. Because unless this conference comes out with a plan that is going to address the impediments to the achievement of social and economic transformation, then South Africa is doomed. And I don't think that we can allow that to happen when hundreds of people died to achieve this freedom. So we can't be the ones who make this freedom not to work. But let's come to the processes leading to the adoption of the interim constitution, the final constitution. The governing party was in a weaker position to negotiate because they have lost support from the frontline states with the signing of the Nkomati Accord. So they needed to accommodate, which was reasonable, accommodate the Nationalist Party. That's why there were sunset clauses, other confidence-building mechanisms. So, but I disagree with some demagogues that Mandela sold out. Mandela did not sell out, and I think our negotiators were seasoned politicians, because when they adopted Section 25 of the Constitution, they crafted it in such a way that it does not exclude expropriation of land without compensation if it is needed for a public purpose or in the public interest. But I think Advocate Nukaitobi and others have demonstrated that it is not the Constitution that failed to deliver the land. It is the institutional incapacity in government. And therefore, if government is not capable of delivering, it's good that we are meeting here so that we can help the government to deliver, because delivery is overdue. Now, if you look at the statistics in a book written by Memabasa and also Mugaitobi, you will see that Africans own only 4% of South Africa. The Indians, 5%, the colors, 15%, and the whites, 72%. That cannot be normal. That cannot be normal. And maybe the Department of Land Affairs, we can excuse them because they don't deal with justice matters. But the Department of Justice and Constitutional Development must look at the matter through justice lens to say, if we have got to deliver justice to all the people of South Africa, both black and white, that situation is a time bomb that will actually explode our constitution and our democracy, and therefore we need to do something differently. Now, I want to go to the proposal. I want to deal with the proposal. I am involved with the Community Law Center, which was established in 1986 and funded by the ANC. And then we also, Tambo established also something called the Center for Development Studies. Now it's called Dalla Omar Institute at the University of Western Cape. But some progressive lawyers established what we call National Institute for South Africa, which is an incarnation of the Center for Democratic Studies. Now, what the Community Law Center did is that it has tons and tons of cases, land claims, dating back to 1998. And there are lawyers who were handling these matters unpaid. Even today, they are unpaid. And they mobilize experts to help them find a solution. Now, these lawyers under the National Institute called NISA have developed a proposal which says that we actually need a litigation unit within the Department of Land Affairs, and that Treasury must make money available for that litigation unit, which will include other relevant ministers like Minister of Justice, Public Works, and so on. And that there must be, in the Land Claims Court, which is using part-time judges, we must second as many judges as possible. And if we don't get enough, we must even get senior law students, because senior law students are working in the legal clinics, and sometimes they are more knowledgeable than some of us who are tired, so that we capacitate the Land Claims Court to deal with these matters. What Advocate Mugaitobi was saying is very disturbing. When he says there are so much backlog of the cases that it will take so many years before they are dealt with, and that also there should be no opening of the new cases because the land claimants who have the knowledge are dying. The younger children are in the cities, they know nothing about the land. So that means that unless we take radical steps to deal with this matter, then this will be the end of South Africa. I don't want to go into detail of this proposal. I'm going to submit it to the organizers of the conference and then request that we have an in-house workshop in the Department of Justice involving Public Works and the Department of Land Affairs to consider these proposals of patriotic South Africans who have decided that they want to help the government to come into this crisis, which some people say is a constitutional crisis. I reject that. There's no constitutional crisis in South Africa. There is an institutional incapacity to resolve the land question, which is key to the resolution of our triple challenge of poverty and so on and so on. So thank you for your understanding, and I hope that I did not create problems for you, because you have to maintain order and authority over me.
Thank you, Dr. Mochega. I'm very much aware that we've taken a lot of liberty with time. Our panel discussion was supposed to be over quite a number of minutes ago, but I think I would be remiss if I did not acknowledge our Chief Land Claims Commissioner, who is here with us, and the senior officials from the Department of Land Reform, Ms. Nomfundo Ntloko Gobodo. I'm not sure if you want to reflect on some of what has been said so far, but I think just to comment on, because I don't think it would be fair to conclude this session without engaging with the audience. I'd like to see if Ms. Nomfundo has any reflections. I am going to note some hands. I'm going to note some hands. I think this is how we can do it. I'm going to take 5 hands at a time. But before we do that, if Nomfundo Gobodo is here, if she wants to reflect on what was said from a restitution point of view, and if she isn't here, I will note people who have their hands up, 5 at a time, and then they will tell us who they're addressing the question to. Okay. Sir with the blue shirt, I've noted you. And then the same person who's sitting next to you, the lady in pink, and the gentleman at the back, yeah, that gentleman will be the 4th question, and the 5th question will be the lady with her hand up sitting on the extreme side. So if we can take questions that way, and then you will please introduce yourself, and please ask to whom the question is addressed to. Thank you. Please go ahead, sir. Very much. So if we can have roving microphones to give the delegates an opportunity to ask questions so we can hear them, please.
Yeah, thank you, Program Director. Mark, my input is ready to the entire panel because I disagree with virtually all of them here and there. But on each one of them, I differ. I differ, for instance, with the fact that there's nothing wrong with the Constitution. I think there's something wrong, and I'll point it out. I also differ with Advocate Ngai Tobi over the location of the work that's being done by the expropriation bill, as it were, and I'll explain this. So the first point really I want to make is that what's wrong with the Constitution? We have a Constitution here. I think Professor Mochega has pointed out that as we sit here and now, the 1913 cutoff, which is there on section 25, subsection 7, makes a mockery out of talking about restitution or redistribution if the cutoff is 19 June 1913. But the disappointment with Professor Motshekga is that he was leading a committee in Parliament, a constitutional review committee, where he had an opportunity to correct this. But instead, within the ANC caucus, they distorted the entire thing, and they came up with all kinds of things that caused that thing not to be, that bill not to be adopted to amend section 25. As it was. So indeed, when you say the ANC has failed to address the issue, it is factual. The ANC has failed. It had the task, had the mandate, had all the resolutions to make it happen. And the ANC failed to amend section 25 in line with the submissions that the people had made in the various public consultation processes that Dr. Motshekga was spearheading. If you look at the issue of the expropriation bill as it currently stands, not sure why Advocate Ngcukaitobi contends that it just talks to use of expropriation for the state use only. If you look at that bill, the purpose of the bill, just the very first sentence, the matter is addressed on the purpose of the bill, on the very first sentence. And the very first sentence talks to the issue of why you need this bill in the first place. And the two purposes are highlighted there. One is public interest, and one is, what's the other one?
Public purpose.
Public purpose, yeah. Public purpose and public interest. If you go to the detail of the public interest, you then find the issues that you can read redistribution on, because there it talks about equitable dispensation and all of that. So indeed, I think we can do, and that purpose for equitable use will then talk to all kinds of things that you need in the land reform program. In fact, in the bill itself, the issue of land reform is there, as it were. So I think we are unnecessarily making too much of an academic argument between restitution and redistribution. I honestly think so, because if you say restitution, what then restitution for what? If you look at why people were removed from their land and all of that, these people were farming. Africans were farming when they were removed. Africans were doing all kinds of things. So when you do restitution, it does all the things that Advocate Ngcukaitobi wants to read only in redistribution. So I think we are just creating an imaginary fundamental difference between the two and all that. So lastly, as I sit down, I also want to say that because the Freedom Charter was mentioned, that unless people read it as lawyers, I'm not a lawyer, but if you look at the Freedom Charter, I think the Freedom Charter itself actually started for lack of a better phrasing, a sellout position. The Freedom Charter says the land shall be shared by all those who work it. Now, how do you work what you don't own, what you don't have? How do you work that? I mean, how does that work? If you say today, let's implement the Freedom Charter, it says land shall belong to all those, must be shared amongst those who work it. So how do you work what you don't have? So I think it's fundamentally flawed.
Thank you, Mr. Mang. You didn't introduce yourself, but I think that's who you
Zanele
are.
Manyi
Thank you.
is the head of policy for African Transformation Movement. Thank you.
Thank you very much. I'm hearing that we are at a point where we need to renegotiate the contract, social contract that culminated into the Constitution, especially around the 1913 deadline. I think that's what is the talking point that I'm taking away from Dr. Machecha's and also from Mr. Manyi's remarks. Thank you for that. I do believe that there is another roving mic on the left-hand side of the stage, but I can already see that there's a queue, if I'm not mistaken, of the questions on the right side. So if you want to have a question, please join the queue either on the left-hand side or on the right-hand side. Please, sir, please introduce yourself and go ahead. I see you're already you're already on the microphone.
Good morning, fellow South Africans. My name is Golden Miles, but that is not my real name. I'll tell you someday what my real name is. I, in fact, now suffering from self-inflicted and selective amnesia. That is why I don't know anything about land. I wanted to say something because I heard Ngugai Tobi talk about the land, and all of a sudden I decided that I must say something here right away. You see, when Minister Louis Farrakhan came here in 1996 to visit the late Holy Hlahla Nelson Tata Mandela, at the behest of the late Benny Alexander, who died called Malcolm, Mr. X, Khoisan X. When Minister Louis Farrakhan came here, he said, when he reported back to his Nation of Islam, Zimbabwe, Mugabe, he fought and he won, but did not take away the land from the Caucasians. And those who fought with him came to him and said, look, brother, we have joined you in war. We fought in the war, we won, but the land is still in the hands of those who came here and stole it from us. You got to give back the land to us. But before Mugabe giving back the land, he was the darling of white people. You always said they are best friend for as long as you're not a friend of your people. For as long as you let them do what they wanna do to us, you are an all right nigger. But when Mugabe said we have to take back the land from the white farmers, I mean, who had thousands and thousands and thousands of acres of land, and the black people have none. All of a sudden, England and America turned down on Mugabe. If you go to South Africa now, the land is still in the hands of the whites. The diamonds are still in the hands of the whites. Everything of value is still in the hands of the whites. He even went and met President Mandela. And the late President Mandela promised the people land, electricity. The electricity people are now fighting to get either free of charge or there must be a flat rate. He promised them houses and water because white folks promised him. They never fulfilled that promise. That is why we are in this quagmire. And Winnie Mandela said it is the former husband, but the former husband was made promises and the white folks didn't fulfill that promise, and that is why we are still in this quagmire. He said that everything of value is still in the hands of the whites. Diamonds and gold and platinum is still in the hands of the whites. The power of the military might is still in the hands of the white, although since the dawn of our democracy, it was black ministers, black deputy ministers, the whole administration is black, but still, even the soldiers are black, but still the might of military might is still in the hands of the whites. And then he said, in conclusion, the white world has to pay. And one of his longtime praise singers from the backbenches stood up and said, it's right, man, that's right. So I'm not sure, must they pay back with the land or must they consider paying the compensation or reparations for apartheid? And I thank you.
Thank you, Mr. Panda.
Yeah, thank you very much. My name is Mnashe Mtasa. I'm coming from Black Lawyers Association student chapter. First, I would like to readdress how I was addressed yesterday. I was mistakenly addressed as a Zimbabwean. No, I didn't come to this conference as a Zimbabwean. I came as a legal student. And foremost, I'm an African. I'm also a Pan-Africanist. So whenever I'm speaking, I don't need a South African ID in order to speak about the injustices of South Africa.
Mr. Mtasa, I'm so sorry. We are pressed for time. I'm looking at time.
Thank you.
Please get to your point and your question or proposal as quickly as possible.
Yeah, I want to first read this statement. Yeah, when a plunder becomes a way of life for a group of men in a society, over the course of time, they create for themselves a legal system that authorizes it and a moral code that glorifies it. Yeah, I understand. I heard the other speaker saying there's nothing wrong with the Constitution, but I want to reread the Constitution. Maybe it's our different understanding. Chapter 1, Foundation Provisions, Supremacy of Constitution. It states that the Constitution is the supreme law of the Republic. Law or conduct inconsistent with it, it is invalid, and the obligation imposed by it must be fulfilled. If you go to the Bill of Rights, which talks about the property, it states that, chapter 2, Bill of Rights. It says that property may be expropriated only in terms of law of general application for a public purpose or in the public interest and subject to compensation. We must remember that it's saying subject to compensation. Remember that when settlers came in Africa, they did not pay for the land. They grabbed the land. So if you are now saying for the subject to compensation, are we saying that for the land that was wrongly taken from the rightful people, now the rightful owners of the land must pay back the settlers or the colonizers in order for them to get back the land? Is there any justice in what the Constitution is saying? I thank you.
Greetings, everyone. My name is Koketso Manku from the National Movement of Rural Women. By default, I'm a born free. The immediate neighborhood at my workplace is Hyde Park. But here's the thing. I don't afford land in Hyde Park. I don't afford a house in Hyde Park. And I don't afford rent in Hyde Park. My question is, why is it that most of the time when we discuss land issues, we tend to focus on the 13% of the land that black people were confined to during apartheid, instead of focusing on the 80-something% that our black people were denied to? Thank you.
Thank you, Ranku. I think if you were listening earlier to my earlier remarks, I don't know if you were here, but the main focus was on the urban land need. And if you also listen to some of the debates, it was also on the redistribution of land, which is addressing land need as opposed to restitution. So I think that is a major issue that needs to be resolved around land need, land for housing, land for commercial use, and so forth. And this is precisely what a redistribution bill should be dealing with if and when it becomes promulgated. Sir, please can you introduce yourself and ask your question or make a remark?
Thank you. Greetings. My name is Michael Ptelezi from the University of Zululand. I just want to make a comment on the presentation by Advocate Ngugai Tobi. My comment is on the communal land, or specifically the land that is owned under the Ngonyama Trust. I'm saying that what is the problem is to have outsiders commenting on that or identifying problems without consulting people who live there. I've lived under Ngonyama Trust for over 40 years, And I've never seen anyone interviewing me, for instance, about the problems and challenges there. But then they say that there are problems. We even have organizations like KSAC taking Ingonyama Trust to court, but they don't understand the issues there. So before we can say that there are problems, let us consult people who live there and then address the challenges. Like one of them is that women, for instance, cannot own the land unless they have a male person who can represent them. That is also a misrepresentation because I live there. I know of widows who own land there, and they don't need any male representative. And then also, we don't even pay rent there, but people are saying that people pay rent there. So we must consult the people who live there and then address problems accordingly. And whatever legislative mechanisms are proposed regarding land redistribution, they must take into account that communal land is distinct from urban land, and then they must be structured accordingly. I thank you.
I think what I want to say to you, sir, is that the Land Reform Panel report was actually grounded. If you read it, the very beginning is an interview with the late Mam Sizani Ngubane, who herself was a woman who herself had challenges of accessing land. And as a practitioner, I can tell you that most of the cases that come to us, whether it's commercial developments or mining companies that want to access land, communities are excluded, particularly excluded by some of the traditional leaders. So I don't think that is an issue that is not grounded. The view is not grounded on conjecture. It's actually grounded on actual experience. And if you, as a man, does not have an issue accessing that land, I think what's important is to hear from those that are continually marginalized in that system. Can you also, sir, can you approach the microphone? Are you still with us, Advocate Ngcukaitobi? Because I think a lot of the issues were directed at you. I don't want to deprive you of an opportunity to respond. Those were the fact that, the issue that was raised by Mr. Manyi was a conflation between restitution and redistribution. He believes that the outcome is the same no matter where you focus on. And I think he also mentioned, there was some mention around the 1913 deadline being unconstitutional. So I'm not sure if you're still with us online. If you can just address those, I think, because those are the key issues that have come out. And also the fact that the social contract that gave rise to the Kempton Park negotiations was, I think, to use Mr. Manyi's words, a sellout position. So can you just maybe opine on that? So if you can hold on, because I think we have to give Mr. Advocate Ngcukaitobi an opportunity to respond to those issues that were raised directly to him. Thanks.
Yeah, I mean, you know, it's always interesting to listen to the sort of people complaining about 1994 as a sellout position. I always wonder, you know, about the sacrifices made by, you know, people like Nelson Mandela and Oliver Tambo, and who were actually in the struggle, and that it's so easy to look back and say, you know, Nelson Mandela once called this thing being a peacetime hero, a peacetime revolutionary. It's very easy for us now, you know, to look back and say we could have done better. And that, you know, if we were the ones driving the process, we would have given more sort of radical solutions. It's a very easy thing. I don't say any of those things lightly. I think that there's a real danger in the sort of romanticism of the present, assuming that, you know, we could have been better than the Mandelas, who in fact, you know, spent 18 years in prison and at Robben Island, the balance of the period at Victor Verster, and people that were driven out of this country to exile, and people who actually took arms to fight against apartheid. And so when they fought for this constitution, I mean, they wrote in the Constitution their aspirations of freedom. And it shouldn't be easy for us to just literally piece on those struggles. There are things that have to be held in a particular reverence in history as Black people in South Africa. And there are things that have to be treated as sacrosanct. I think this idea that people today who could have been in the struggle, could have been in exile, could have been in MK, suddenly today are telling us that there was a sellout by someone like Nelson Mandela is an unfortunate position to take. There was obviously complexity in the transition, but it's very simplistic to claim that there was a selling out. It's very simplistic and actually ahistorical. That does not mean there is no transition that is easy. Transition is complicated. So that's my reflection on the sort of dismissive notion of a sellout, which is not grounded on any history and which is based on some sort of, I could have done better myself. But the question is actually at the time, I don't know. Luckily for me, I was too young. But it's very difficult. I actually have a lot of resentment for people who make that claim. Truly, truly, truly do. The younger ones I understand because they could not have been in the struggle as a result of age, and that it's understandable for them to sort of imagine a different past. But none of that matters. Nelson Mandela is dead. Oliver Tambo is dead. Chris Hani is dead. We have to figure out the future for ourselves. We are not going to create that future by blaming Nelson Mandela and by blaming Oliver Tambo, blaming Walter Sisulu. We're not going to create that future by blaming the people that were part of the transition. We have to figure out what the future will be like, not for Mandela, but for ourselves and our own children. And that is why this conference is actually a salutary moment. This is not a moment to shine, it's not a moment for individuals to shine. It's a moment for deep reflection about the possibility, right? The possibility of a different future and the mistakes that have been made in the last 29 years and how those mistakes can be fixed under a rule of law system. I hear a lot of skepticism and dismissal of constitutionalism as a concept, sort of embedded in some of these remarks. Now, I want to take them seriously, that there is a sense of constitutional skepticism. But I want to consider a possible alternative to the constitutional nihilism, right? It's constitutional nihilism. Consider a different perspective. My own experience, having studied and lived in this country, is that if you destroy the rule of law, what you are left with is a state of chaos. People who benefit from a state of chaos are people with money and guns. A state without the rule of law never benefits the poor, but the promise, the promise of the big man, the big man who promise you a different future if you destroy the rule of law is always that things will be better, but they never are. So we have to sustain the rule of law for the poor, right? But not any kind of a rule of law, but a rule of law that's grounded in justice, right? Not to sustain it for the rich, sustain it for the poor. And we've got to understand that if we destroy the rule of law, we destroy it primarily for the poor, and we benefit the elites who pretend that they are acting for the poor, but they are simply exploiting the poor by deploying their language. But ultimately, what they are interested in is themselves, So we always, whenever someone uses constitutional nihilism as an entry point in the debate, we have to be very, very concerned about what their true agenda is. So I am very skeptical about claims about selling out, and I'm very skeptical about claims for constitutional nihilism.
Thank you.
But that does not mean there's no scope for critique. I just want to make one more point. That does not mean there's no scope for critique. There's of course scope for critique, but it's got to be progressive, and it's got to be well informed, and it's got to think about meaningfully for the future. I think the last point around this Ingonyama issue, it's also strange, when men, just defend the status quo, which is inequitable. It's just inequitable. And when women come to us as lawyers, there is a case, this entire story I was telling is based on a judgment, a case I argued, And so it's very easy to be dismissive of these concerns because they don't affect you individually. So even that needs to be, reconsidered meaningfully. I'm afraid, I would have loved to discuss more, but there is a gentleman waiting outside driving
No,
an
thank you.
Uber
I
who
think
has to
you've
take
been
me to the
you've been
airport.
very generous with your time. Thank you so much. I think that does answer the issue. Just before you go, I think Mr. Mann, you wanted to clarify that the sellout issue was really in relation to the Freedom Charter position, not necessarily Nelson Mandela. But thank you, gentlemen and ladies, for being patient. Please, can you just walk towards the microphone? We will handle your questions and remarks, and then I think we will close this panel, which has been very vibrant, I think. Thank you.
Greetings to all this morning. I'm Bishop Bernard Kupasamy, and I'm deployed from the KwaZulu-Natal Christian Council of Churches. I want to commend the organizers for this meeting, but I also want to bring into remembrance during the old apartheid days, there was provision made for churches and religious institutions, and that is not permissible anymore due to new bylaws and new constitutional rights. The problem is most of the bishops, apostles, and pastors, especially I'm relating to the Abafundises who are in the townships, they have their applications that is actually lying in the municipal offices who are the gatekeepers of the government's land. So I want to raise that concern, especially because we do have now a lot of female African pastors that are struggling in the townships, and they need land so that they can worship God. So I'm saying that please, if Constitution can consider the religious sector, and please give us land to worship God. Thank you.
Thank you, sir. That issue was touched upon in the panel's report when we spoke about land donations and so forth. So let's see how the issue progresses. Thank you for that.
Hello, my name is Tana Makhoka. I just want to make one comment and one question. Bulelwa, you and I, we've spoken about the fact that actually the concept of property within the law and its definition itself also needs to be looked at, and how our current definition of property actually still reflects a Roman Dutch understanding of what property is, and which is why it's making it so difficult to deal with the property system as a whole. I don't think Dr. Yvette Abrams is here, but whoever wants to respond to this can respond. Section 25(4) of the Constitution says, for the purposes of this section, the public interest includes the nation's commitment to land reform and to reforms to bring about equitable access to all South Africa's natural resources. And B, property is not limited to land. And I really want to zoom in on this idea that property is not limited to land. I know that today's session is about land reform, but land reform itself is linked to other issues. So if you look, for example, with the Khoisan issue, and I am, a great-grandchild and a grandchild of Khoisan people who were from the West Coast, who were dispossessed there. You look at a case or an agreement that was concluded in 2019 between the rooibos industry and the Khoisan Council, where it was agreed that 1.5% of the profits from the entire rooibos industry would be given to the Khoisan Council. Now, it was not decided through a judicial process. It's essentially a contract and a share benefit agreement, which is itself problematic because we know that the Constitutional Court doesn't intervene as much in those sorts of things. but it doesn't lead to changing the property relations, right? 85% of the Rooibos farms are still in white hands. And if you think about the fact that it's the Khoisan people that identified this plant and its medicinal and food properties, right? The fact that as knowledge holders, or at least this is what the government has called them, knowledge holders, that they benefit so little from something that they essentially, it was the idea, shows us that actually we need to be linking this land reform debate also to the idea of intellectual property, because they're not just knowledge holders, they should be seen as the owners of intellectual property. You see the same thing with Khoisan communities along the ocean who still farm, or still fish, sorry, with fish traps that they've been doing that for centuries, right? But who have been excluded from being able to benefit from fishing licenses and that sort of thing. So we need to think about intellectual property, we need to think about the ocean and not just physical land. And we need to think about the fact that when we're thinking about land, it's not just about the value now, but the ongoing benefit and the livelihoods that need to stem from that. So when we're excluding people from these resources, it's not a once-off thing, it's an ongoing harm that is actually being perpetuated. So yeah, I would just like to get some comments on that, please.
Thank you. Thank you for that, Tanya. I think I relate so much with the Rooibos story because in my book, My Land Obsession, I actually set out a case study of a community in the Eastern Cape that came for assistance because they were the knowledge holders, indigenous knowledge holders for a plant that was proven to have sunscreen properties, and which would, if the community were to be proper stakeholders and properly engaged, would probably change the course of the entire generation of that community. That community was the Ndabakazi community. And the major issues are the issues that we're speaking about that are part of the land reform programs, but they fall outside of the Constitution. So they battled with finding lawyers who are qualified lawyers, qualified IP lawyers to represent them, because we know that lawyers are expensive. Two, they had fundamental issues that are linked with land tenure systems because the land on which the community was sitting on was not surveyed. And so therefore they couldn't claim themselves as owners of land. But those are some of the challenges that we know and that exist. I think there's one last question. That Tanya, we can carry on, offline on this because I think it's quite important. I think we are out of time. So if you can summarize your issue in seconds, literally, that would be great.
Okay,
we are out of time. I was told to close. Thank you.
My name is Tamsang Ngapala. I'm from Titorans Advice Office in the Western Cape, in the Cape Winelands. I'm not a lawyer. I'm a paralegal, a human rights activist. And last in our session here, there was a issue of relating corruption, the fraud into a constitution. And then on my point of view, we have got no problem with a constitution. We have got a problem with a person, a human, that is assigned to execute what is in the constitution. We have missed it, that person. And then the other thing that I wanted Minister Thoko Didiza to look for us, the audit of farms or land that have been already been given to black people, because there are land that have been given to black people. And then if it can be made to know who are they, what makes them to qualify, what criteria was used in order to get that land. Because I'm taking this, there are lands that have been farms, abandoned farms, which were meant for black empowerment. And then my question on those farms is that who was this person whom the government have bought land for him and abandoned this place, whereas there's a majority of people that need that land to use, and what the Department of Minister Thoko Didiza is doing about that abandoned land, because it's the money of state that is there. Thank you very much.
Thank you, sir. I'd like to take this opportunity to thank you all for your patience, the delegates, the panelists, the organizers, the Minister, Dr. Muchecha, Dr. Abrams, Advocate Nguratobi, SC, and everyone in the room. Thank you so much. I'm sure this discussion needs to be taken further, and I'm sure there will be opportunities for that. Thank you very much.
February 2nd, 1990, the news came as a shock to the world. The new president had unbanned political organizations, called for an end to apartheid laws, and lifted the state of emergency. Prisoner 4664 walked free, and the fighters from exile returned home. Sworn enemies sat across the table from one another. They signed an agreement and talked about talks for a new country. But peace always has an enemy waiting around the next corner. Wave after wave of violence spread across the land. A shadowy third force carried out attacks and fueled tensions between political groups. 700 funerals in 8 months. But across the land, there was a new commitment to peace. Political and civic groups signed the peace accord. 19 political parties sat around a table under the banner CODESA. Some refused to come. Some refused to sign the declaration on the way forward, but the rest talked. The old regime wanted to share power between different ethnic groups and draft a new constitution and send it to the people to vote for. The ANC and its allies demanded that all South Africans must be equal and that a new constitution must be written by a democratically elected body voted for by the people. We held our breath. For the forces of hate and division still poisoned the land. The talks collapsed. We embarked on mass protests. Peace wept. Compromised hostel dwellers crept through the township of Boipatong and murdered 49 people in their homes in the dead of night. At Bisho, the army of Ciskei opened fire on a peaceful march, 80,000 strong. From grief came a breakthrough. Both sides were shocked back to the negotiation table. It was agreed that for 5 years there would be a government of national unity elected by the people. There were storm clouds in the sky, but the sun was coming through. The number of parties that sat down to carve.
Thank you very much for that clip. Good morning, ladies and gentlemen. I'd like to just go straight into it because I think time is of the essence, and I do not want to delay you any further. I'd like to call upon the next panel, Panel 8, Governance and Electoral Reform. Said panel would be facilitated by Ms. Mashego, Project Director of South African Electoral Reform, New Nation Movement. She will then be joined by 2 panelists, Professor Mchunu, Executive Director at Africo Group, and Mr. Lawson Naidu, Executive Director of CASEC. You may please come up.
Good, is it morning or afternoon? I think it's still morning. Good morning, Sanbonani Molweni, Absheni, Goeiemorgen, and all the other languages duly respected. To the Director General of Department of Justice, as well as all the organizers from the Department of Justice who helped to put this August event together, as well as the workers, security, SAPS, the chefs, the cooks, everybody who's basically made this experience hospitable for us. Thank you very much, and thanks for allowing us to grace this occasion. My name is Mandisa Mashego, as previously explained, and I'd like to thank you in advance for paying attention and participating in this. I'm going to try and make it as interactive as possible so that we're not preaching to ourselves or preaching to the converted, because we come here as various activists. Yes, I'm the project director for the South African Electoral Reforms component of the New Nation Movement, an organization that has approached the courts several times, and ultimately on the 11th of June in 2020, we managed to secure a victory on behalf of the citizens of South Africa for the current Electoral Act and all related regulations and policies that go along with it, of course, to be declared unconstitutional, duly so, and we managed to score that victory on behalf of South Africans. And I am honored and pleased to be joined by fellow panelists in this panel discussion. The very esteemed, and if I'm not wrong, the first IEC CEO or chairperson, one of the two, in South Africa, Professor Mkhunu, who's also Executive Director of AFRICO. I'm sorry, I'm going to have to ask Professor Mkhunu to introduce himself as soon as I'm done with my intro, because I didn't have enough time to actually prepare a respectful enough introduction of your profile and all of that. And so I'll give you a minute to do that during your time slot. Thank you very much for making it, and I look forward to an engaging discussion with you. I'd also like to welcome Mr. Naidu, my fellow activist in this space, who's also the Executive Director of CASAC. And I'd also like to ask you, please, Mr. Naidu, to do your own introduction and just give a little bit of meat to exactly who you are for the members of the participants in the conference who may not be familiar with your profile. Thank you very much. I'd like to just set the scene in relation to a little bit of the background about, concerning the Electoral Act of South Africa that governs our entire democratic framework and electoral system, that has essentially, whether you agree or not, led us to the situation that we are in today, wherein there's a dropping number of South African citizens who are eligible to vote, which means they have a South African ID, they're South African citizens, they're 18 years and above, or at least I think 16 or 17 you can start registering, who choose not to actually register to participate in democratic electoral processes. Added to that, we have another growing number of South Africans who are eligible to vote but actually register to vote, but somehow don't make it to the voting stations. And by and large, an overwhelming majority of them are obviously still alive. Because as you know, the voters' roll would start off with people who are deceased, so you'd be able to tell which South African citizen was registered and as deceased. That's a very negligible amount, a number of people rather. So in the context of the historical situation that has led us to situations such as what I've described, I'd also like to add on, I'm not sure if Mr. Ibrahim Fakir is still around, but yesterday in his session, he shared statistics of a study that was done to show that the confidence, the levels of confidence that South African citizens have in the governance system, the democratic system, political system, and government as a whole, represented by parliament, has actually dropped to an extent that confidence levels in these governance systems and electoral democratic systems has dropped to around the mid-20s in terms of percentage. And the picture, I do have statistics which I'll share later on when we get into a more interactive discussion with the panel, but the drop of people who register to vote and don't vote is actually quite alarming and high when you look at the voting population that actually was registered and turned up in 1994, 1999, 2004, 2011, 2019, up to the recent 2021 local elections. When I mention the years, I'm mentioning only elections that took place for general elections, which are provincial and national elections. Now, looking at that situation and also considering a second very important issue, which is the growing extent of poverty, inequality, which essentially makes us the most unequal society in the world, and that's not news to any of us in the room. And also the horrendous extents of growing abuse of women and children, and in particular African women and children, and I specify that because if you look at the crime stats of South Africa and you consider that white women, colored women, and Indian women do not face the same extent of violence from society, whether in their own communities, residential areas where they live, workplaces, etc., as African women do. And I know there'll be an argument about the demographic, the figures, meaning that majority would be African and therefore majority incidents would be also African. That argument doesn't really fly when you look at other considerations. But when you consider this dire picture, and of course all the discussions that have happened around land reform, landlessness, growing landlessness, growing extents of inaccessible property that is increasing in terms of cost to acquire either land or a completed property. If you consider all of these dire situations, and of course the last one is the decrease in education quality in South Africa. I think there's a professor from UKZN, I forget his name, who has recently pronounced that it is an actual fact that the South African government has reduced the extent of quality of mathematics. For example, if you're using mathematics as a yardstick of measuring education outcomes, that the quality of mathematics, and I'm not talking mathematical literacy, the quality of mathematics in South Africa officially and legally dropped under the current government when government decided to reduce higher grade pre-1994 on mathematics and removed it and used the pre-1994 standard grade to become the higher grade of the modern day, so-called modern day South Africa. So with that in mind, I'd like to invite the panelists to come forward and introduce themselves, like I said. And then after the introduction, we'll get into a discussion. I'm going to follow the format of asking questions. I think I don't want to rehash what everybody already knows, which is one, the Electoral Act is unconstitutional. Two, that issue cannot be, taken back to the Constitutional Court unless, of course, the President decides to assent, as we all understand, the bill-making process, which involves members of Parliament only passing bills, amendments, and repealing acts, and not citizens. If the President decides to assent to the current bill, of course, I assumed we all are up to date with that information, but we know that there's a draft bill that has been presented, passed through NCOP and National Assembly, and presented to the President to assent to, and as we all know, that the President may not by law assent to any act, bill, amendment that is unconstitutional. And of course, the bill is unconstitutional. It remains unconstitutional, and various other organizations, not just the New Nation Movement, agree on this assertion. Of course, the actual test lies only in the Constitutional Court, because what the President does have an opportunity to do is, one, send it back to Parliament and say, fix it, it's still unconstitutional, or it's more unconstitutional than the original one that was unconstitutional, which is our opinion from the New Nation Movement. Or he has an option of sending it back as well to the Constitutional Court and say, listen, help me to figure out the constitutionality or unconstitutionality of this draft bill that's been presented before me before I can actually assent to it, and then take it from there. But he doesn't have the privilege, nor the right, nor the authority, nor the power to actually assent to an unconstitutional bill. Mr. Naidu, I'll start with you. Thank you very much for allowing me that introduction. I'll start with you to give your intro, and then we take it from there. Thank you very much.
Thank you very much for that. I don't want to waste time with the elaborate introductions. My name is Lawson Naidu. I'm the Executive Secretary of the Council for the Advancement of the South African Constitution, which many of you may know as CASAC. We've been involved in the issue of electoral reform for some time now, having recognized that the existing closed party list PR system is inappropriate to serve the needs of our democracy. And I think the question that we need to really focus on in this discussion today is we need an electoral system that is fit for purpose for South Africa in 2023 and for the next 50, 100 years. Societies very rarely get the opportunity to change an electoral system. It doesn't happen very often in any society. We have an opportunity now, as the facilitator said, as a result of the judgment in the New Nation Movement case almost 3 years ago, to effect that change. And I'll come back to that in a moment. In starting, I want to remind ourselves of what the Constitution says about the electoral system. And there are only two aspects of it I'm going to highlight here. First, in Section 1, which is the founding provisions, one of the founding values of our Constitution is a system of universal adult suffrage, a national common voters' roll, regular elections, and a multi-party system of democratic government to ensure accountability, responsiveness, and openness. The other provision is Section 46, which deals with the composition of the National Assembly, and it says that the National Assembly consists of no fewer than 350 and no more than 400 women and men elected as members. In terms of an electoral system that, A, is prescribed by national legislation, which is the Electoral Act and the amendment bill that we will come to in a moment. B is based on the National Common Voters' Roll. C provides for a minimum voting age of 18. And D results in general in proportional representation. An Act of Parliament must provide a formula for determining the number of members of the National Assembly. There's a similar provision in Section 105 that deals with provincial legislatures. As you well know, there is a very different electoral system that we use at a local government level, which is a mixed ward and PR list system. So when you vote in your local government elections, you will vote for a ward councillor in a constituency, which is the ward, and one person gets elected to represent that ward, and then you vote on a second ballot for a PR list, and that constitutes the remaining members of the council in the municipality where you live. So that's not the system that we're going to focus on today, although I will touch on that as well. So coming back to the fit-for-purpose notion of an electoral system, I think one of the stark things that came out of the various reports of the Zondo Commission, and you don't need to read all 5,000 or 6,000 pages of it, but it highlights a huge problem in South Africa. We have a fundamental accountability deficit. Members of Parliament, members of provincial legislatures, perhaps even members, our councillors, are disconnected from people. There is no accountability mechanism that you as a voter or a citizen can exert. And we see that manifest itself in the hundreds and thousands of protests that we see around the country on a daily, weekly, and monthly basis. These protests happen because people have no other recourse to get to their councillor, their member of provincial legislature or MP in the National Assembly. And they express that democratic right through protest. And it certainly says to us that the electoral system is therefore fundamentally flawed and not able to deliver on that. So to start with the 94 election, we had the 94 election on the same system that we're using now, where except in 1994, obviously we did not have a common voters' roll. So you could go and vote through producing what was then the green barcoded ID or any other recognized form of identification, and you were able to cast your vote in 1994.
But that was very much a transitional arrangement, and the final constitution in '96 said that there needed to be a new piece of legislation to govern the electoral system. So that system that we used in '94 and that we're still using today was essentially a transitional arrangement. But we've allowed that transitional arrangement to endure for 6 elections already, coming into our 7th. As a result of that, in his final address to the National Assembly in 1999, before leaving the stage of politics in South Africa, former President Nelson Mandela said this. He said, and I quote, "We need to ask whether we need to re-examine our electoral system so as to improve the nature of the relationship as public representatives with the voters." There was an early warning sign from Mandela that that electoral system that we used in 1994 was not going to sustain us through our democracy. I'm afraid we did not heed his warning or those that came thereafter. And there have been several other recommendations over the years that the electoral system must be changed, and these have all also, until now, been ignored. These include the Independent Panel Assessment of Parliament in 2009, and I think Preg's Govender is still around. She was headed that panel, and they said that the view of the panel is that the current electoral system should be replaced by a mixed system which attempts to capture the benefits of both the constituency-based and PR electoral systems. Next came former President Kgalema Motlante's high-level panel in November 2017. And again, I quote from that where it says, "Effective parliamentary oversight is dependent on members of parliament acting in the best interests of the people without fear, favor, or prejudice. In that context, the panel has considered the role of the electoral system in moderating the extent to which the public are able to hold their representatives to account. At the heart of whether government delivers on its constitutional mandate and whether Parliament legislates to bring about change and exercises oversight effectively are issues of accountability. The panel proposes ways to deepen the relationship between constituencies and their representatives so as to assure more direct accountability to the public." And then most recently, we had the State Capture Commission itself, where Chief Justice Sondo said, "Parliament should consider whether introducing a constituency-based but proportional representations-based electoral system would enhance the capacity of MPs to hold the executive to account, and that consideration be given to the majority recommendation of the electoral task team," being the Van Zyl-Slabbert report. So we had that Van Zyl-Slabbert report early in 2003 because of the provision in the 1996 Constitution that the 94 model was a transitional one. And unfortunately, government at the time ignored the majority report of that panel, which proposed that the country be split up into 69 constituencies. We now have a system of each province being a constituency, so we have 9 now, but they proposed breaking it down into 69 constituencies, with each constituency electing between 3 and 7 members of parliament. That would give us a total of 300 MPs elected from those constituencies, and then a further 100 elected through a PR system to satisfy the constitutional requirement that the electoral system must result in general and proportional representation. The majority view was ignored. 8 members of the panel were in support of that majority view. 4 members of the panel suggested that the existing system be retained, and government at the time decided to follow the minority view and entrenched the current system into legislation, and that's what the system that we still have today, which has been highlighted by our facilitator, has been declared unconstitutional, but only to a certain extent. So bringing us to that New Nation Movement judgment of June 2020, my problem with it, and I differ somewhat with the facilitator on this, in that the case was framed in a very narrow way. it asked the court to declare the Electoral Act unconstitutional to the extent that the Act and the electoral system does not permit independent candidates to contest national and provincial elections other than by being members of a political party. That's the nub of the decision of the Constitutional Court. It's a very narrow judgment, and the Electoral Act was declared unconstitutional only to that extent. The whole Act was not declared unconstitutional, and therefore what we've seen in a response from government subsequent to that is what has been referred to as a minimalist approach, to say, okay, we'll accommodate independent candidates, but basically within the current system. So we retain the 9 provincial constituencies, and an independent candidate can contest against a whole political party in that provincial constituency. Now that's inherently unfair, because the chances of an independent candidate, given resourcing constraints and so on, being able to challenge a political party across a province is unfair. So we have the situation before us. But the choice of an electoral system is ultimately a political decision, not a judicial one. And the courts cannot and should not determine or dictate the kind of electoral system we have. It's part of the fundamental rights that we derive from the Constitution. And as the electorate, as the voters, as the citizens of South Africa, we have the right to determine that electoral system. And Parliament, when it passes legislation, must ensure that it engages with us in a meaningful way so that the views of organizations, of ordinary South Africans are taken into account in framing that electoral system. That is something that has failed to happen as Parliament has sought to amend the Electoral Act to bring it into line with the judgment in the New Nation movement case. There's no perfect electoral system in the world. That's another important point to bear in mind. You can't just go and import something from somewhere else. It's got to be an electoral system that serves the needs of South Africa, that reflects the complexities in our society, and still delivers a result that is free and fair, results in general proportional representation, and enables citizens to hold our elected representatives to account. Just before I finish, on the Electoral Amendment Bill, as I say, the process, in my view, was a failure of parliamentary public participation. It did not engage in any meaningful way with any other electoral system that may be more appropriate. So although the judgment in the court case was narrow, Parliament had an opportunity to broaden this on the basis of all the reports that I've highlighted earlier, President Mandela's parting shot in 1999, to say, maybe this is an opportunity for us to really review the electoral system and see what's best. Parliament failed to do that. They simply took what government presented and processed it in a way that they hope is going to pass constitutional muster. And again, I think I might disagree with my facilitator. So I think the bill remains fundamentally flawed because it doesn't deliver an equitable electoral system. It's not an electoral system that's going to enhance accountability. It's not an electoral system that's going to give a meaningful role for independent candidates to play in our politics going forward. But that does not necessarily mean that the bill will be declared unconstitutional either by the President or indeed even by the Constitutional Court. But there have been some concessions that have been made in the bill, small ones perhaps, but I think the significant one is there was a lost opportunity in this process, as I've said. The Minister of Home Affairs established a ministerial advisory committee chaired by Comrade Vali Musa, who you will have heard speak here on Wednesday. I wasn't here, but I'm sure he spoke about the electoral system because he's very passionate about it. His advice to the minister, the majority of his panel recommended that a hybrid constituency and PR system be put in place, with 200 members being elected directly from single-member constituencies across the country and 200 from the PR list. Again, The minority view in that Ministerial Advisory Committee recommended essentially what I've called the minimalist option is we'll keep the current system and simply allow independent candidates to contest within it. A second and potentially more far-reaching concession in the bill is the proposal for the establishment of an electoral reform consultation panel. A panel that will be publicly appointed through a call for nominations. It will report to the minister, who must make that report available to Parliament. And this is with a view towards further amending the electoral system so that we do hopefully have a fit-for-purpose electoral system that enhances accountability, brings our elected representatives closer to communities and to people. You know, I may sound naive in saying that, but given that government has on 2 previous occasions ignored the majority recommendations from the Van Zyl-Slabbert report and more recently from the Vali Moosa panel. But I think there is an opportunity there to really advance the discussion, and I hope in what we're going to say today, in the discussion that follows, we'll be able to unpick some of these issues and begin to design an electoral system that's going to address fundamentally the question that was posed at the end, is decreasing voter turnout levels, alarmingly, in particular amongst young people. And I think that's something that we need to address. We need to turn that around, because the future of our democracy is premised on an electoral model that has legitimacy, credibility, and public support. That's something we cannot fail our country and our future. Thank you.
Thank you very much. You're absolutely correct, Mr. Naidu. The president cannot actually declare the bill unconstitutional. Only the Concord can do that. And so I did describe the conditions under which the president should be treating the bill like he does any other bill. And on that note, thank you very much for all your inputs. We'll engage further after Professor Mchunu's presentation. And I hope that the organizers have his presentation ready to beam for us on the screens. He did make it available, Professor Mchunu. Thank you.
Well, humble greetings to everyone, ladies and gentlemen, distinguished guests, and to our facilitator, our program director. Thank you for inviting me to this very important conference. The program director asked me that I should introduce myself first. I have a presentation that my colleagues, I think, will help me with as I go through my own presentation, which I believe will be broader than the NNM case, but on electoral reform and governance. You know, for my sins, I was part of the 1994 Electoral Commission, where we organized the elections within a period of 5 months and delivered it. And then I was called back and became the CEO of the current IEC. You know, served my term, you know, and then left, and I've been on a democracy crusade in the continent of Africa, establishing democratic systems in Nigeria, Zambia, many other countries. So I didn't leave electoral democracy. Perhaps I might have left my country, but I saw that what we've done here in South Africa ought to be extended to the continent of Africa. So without further ado, I would like to start with my presentation. If we go to the second slide, perhaps I should start by, you know, articulating that what I've seen coming out of this conference, you know, perhaps it was unintended, but it's a great thing that most of the speakers, contributors, presenters, they're my peers. You know, some of them are older than me, but they were there, you know, when the Constitution was drafted. They were there when events leading up to the drafting of the Constitution were occurring. So, and they've shared a lot of the historical context. I think particularly Comrade Matole Motsecha here, and Vali was here, Mujanku was here, quite a lot, Pregs, many of those characters that I would have known from the time that the Constitution was drafted. I was also a TV facilitator for a program called Constitutional Talk, where the very members of the Constitutional Assembly would come to SABC and would go through issues, land issue, all the rights and so on. I was part of that as well. So I have that intimate knowledge of it, but I must admit here that I'd walked away from the debate, the discussions and so on, because I felt I've done my bit. This is a baton. I've handed it over to somebody else, they will take it along, which has happened, I think, by and large in electoral democracy. So with those opening comments, I want to endorse what Comrade Vali Musa said last year, I think today, last year. You know, he was saying that we can't tinker with our electoral democracy because we'll disturb the lifeblood, you know, of our democracy, our constitution. I couldn't agree more. He's very right in that, you know, but I think also we cannot imagine the history, as I think Advocate Ngugai Tobu was saying. History has happened. You know, we just have to understand it. If we regret it, it's okay, but it has happened. We need to understand it, I think, from a point of view that it tells us what happened before this Constitution. It reminds you. You know, when I think of how much of a mission it was to get to study at the University of Natal, which was a white university at that time. It was a big mission, ministerial concerns and many things. Bit of lies in between why I'm not going to University of Zululand and all of that. A big mission. But those who are here today who are much younger, you can't imagine it. You know, it's like having been in a war and living in times of peace. It's two different things. So I think it's our duty as the elder people to continue to talk about this historical context, to remind ourselves about it. I think all of us saw how emotive the land matter is. You know, very emotive matter, you know. And it has to be shared, discussed, and known so that whenever along the journey, you know, you lose sight of where we are, just look back, just check where we come from, and then perhaps we'll be aligned with what this Constitution is about. What I want to do is just to share perspectives on these four bullets that you see there. State of our electoral democracy, just generally highlights and lowlights, and then the NNM case, of course, which is at the center. Apathy and participatory democracy, the voter apathy story. What are the numbers, you know, what's going on, what can be done, the road ahead. But you know, just maybe one comment. If you read the Constitution, it's been quoted quite a lot in this conference. There's lots of unwritten text in our Constitution, you know, which is sort of buried underneath. You know, one of them is that it's a long-term program. It sets out a long-term program. So it means we have to think like that in a long-term way, not in a short-term way. A lot of things that we've heard here are calling us to react, you know, to certain things. And when you react, you can be caught, you know, into that grind of reacting. But the Constitution says long-term. So a very important principle, think beyond our own lifetime. It's not an easy thing to do, you know, if you've lived in the ghettos as we have, because we were concerned about today, now. Now we're being asked to be concerned about the time during which we won't be alive. You know, that's quite a challenge, quite something. It also relates to electoral democracy. What kind of democracy do you want to see today? What kind of democracy? If this is the kind of democracy you want to see today, how will it be in 50 years' time? You know, and so on. So we have to think like that. That's what it says. And it really says we have to be diligent, you know, collectively and individually. You will see that the Constitution is littered with a lot of provisions where it says the state must do this, the state must do this, and so on and so on. So almost like they are directive. That's the reason why I've referred to Section 41.1, which is really cooperative governance chapter. It spells out, you know, in very clear terms what the state should be. You know, whether if it doesn't do that, whether there's any constitutional demeanor or not, I am not sure. But it spells out that government, all spheres of government must preserve peace, national unity, and the indivisibility of the Republic. They must serve the well-being of the people of the Republic. They must provide effective, transparent, accountable, and coherent government for the entire Republic. Must respect the constitutional status of other institutions and their powers. And they must also maintain or operate within mutual trust and good faith. Quite a number of things. Section 7 in the Bill of Rights talks about what the state must do regarding the Bill of Rights. Section 237 talks about what the state must do regarding the constitutional responsibilities. Very, very directive. It says all these things. But whether, if the state doesn't do that, is there any remedy that you can put on the table to push the state to do that? But if you want, therefore, to do an inquiry comparison with whether the state has fulfilled all these obligations, just use these sections I've referred to, 41.1, 7.2, and 237, and check. And I think from what one has heard here, there is a gap, you know, and how is that gap going to be breached over time? The next slide, I want to talk about the state of our electoral democracy. You know, just to say, well, there are highlights, you know, so it's not all doom and gloom, you know, because when it comes to electoral matters, there's been a lot of achievements. I think other presenters here have said, look, don't take for granted the fact that we've had 6, you know, general elections, results accepted. And you will understand it better, you know, if you deal with continental matters of elections. Even outside, or, you know, of Africa, you have strange countries that are there where it seems like it's a democracy. But when elections are being managed and delivered, you get a sense that this is contrived. I've been in many elections as an observer, you know, where we have a chance to interface with different interlocutors, say the head of police, you know, and so on, different public servant leaders. You get a sense in some of the meetings that no, these folks are not talking from a position of independence where they are. They are really hamstrung in many ways. So then let's not take that for granted, the independence, the space allowed to the IEC to run the elections and for the results to be accepted. We haven't had a similar case like it happened in Kenya recently, where elections were actually declared null and void, and they had to go back and do them again. We haven't had that. So we also, I also know personally that the IEC has got this amazing international and continental image. In fact, a lot of countries send their staff members in the new electoral commissions to come to the Electoral Commission in South Africa. So they are really considered in high esteem. You know, that's, for me, something that one really needs to share. The awards they've won much more than what I've listed here because of their proficiency, their ability to do the work. I'm not sure, though, about the issue of independence because, you know, when you listen to what Mr. Nad was saying here earlier on, you know, how this new act is and so on. So I asked myself, what was the role of the IEC with regard to that? Were they free enough, you know, after the Van Zyl-Slabbert report? Were they free enough to actually say, hey, wait a minute, this is how this thing should be done? Advise government, come out there. I don't get that. I really don't believe that it's a leadership style. I would have done that if I was there. I would have gone there because the IEC has to be seen to be leading electoral democracy. And if that happens, although it really, the final decision is Parliament, I agree, but the IEC is supposed to bring in a measure of objectivity in the situation because, you know, political engagement is about positions, you know, and so on. So they need to come in there and make the whole process not to be too polarized. You know, I would have done that, in fact, starting from 2003, because it's the interim constitution that said you have to look at this. And I would have thought this is a legislative responsibility of an electoral commission. I'm not of the view that electoral commissions should be these beautiful, technical mechanisms, delivery systems. They have to get into the constitutional aspects of their role. I'll talk more about that later. However, they're a great institution, and what they've done so far is quite marvelous. The lowlights, from my own personal experience in 1994, I'm sure you've heard about the IFP matter, that we had to deal with ballot papers at the last minute, because the IFP was threatening not to join the elections. So we had then to paste Prince Mangosuthu Buthelez's picture right at the end of the ballot paper, like stickers, because we wanted him. I think it was about Ingonyama Trust that was mentioned here. It was delaying the entire thing. That was quite a cliffhanger, for that particular election. And then 1997, when I rejoined the IEC, before we could have this amazing voters register that we have today, there were lots of fights which caused the then chairperson to resign, but we got the money to do the voters register. So there's a case that was actually delivered, a judgment, Concord judgment delivered by the late Chief Justice Pius Langa on the financial independence of the IEC. And then you remember also the Tlokwe cases, of the IEC, where it was sued by people in Rustenburg area. And then in 2015, leading to the 2016 elections, the IEC had to approach the Constitutional Court to ask that it has some kind of a facility to run the elections without all the addresses on the voters register, which they got. But what's missing for me during all this time is that from 1994, I think to 2022, nothing about democracy development, nothing at all, and I think it concerned me because, I was coming from an NGO university base, so for me, going out to the people to teach them about democracy was second nature, so I would have thought that they would take this one and run with it, because at that time we knew that knowledge was only centered within the IEC political parties, very small circles, that we needed to take this out. And when I inquire, I was told that it's budgets, and then didn't want to push any further because I thought we'd crossed that bridge of financial independence, that they must be able to get their money so that they're independent. But nothing then happened on these democracy development programs. It's been quiet. We've heard earlier on Comrade Vali Musa calling for constitutional education as part of this, because it has to be done. So if we go to the next slide, electoral reform and the NNM case, I think my colleague has covered all these reports. I think the only point I can make here is that it's strange when you read this, in preparation, you say, but how did they miss this opportunity? Because the NNM case really looks like an own goal, that when this, in fact, from the interim constitution, they should have, Parliament should have said, look, we need to look into this. Yes, then they formed the Van Zyl-Slabbert commission. And when it comes forward, they must engage it, because it's an imperative that has to be. And I think during that time, the patterns of non-accountability were starting to show, but sort of dismissed it, never did anything, shelved it. And all the others that Mr. Naidu pointed out, there is even a CORDA report, which is an earlier report in 1999, about the National Assembly, standards of independence, institutional independence, and accountability, shelved, So you get a sense, I heard also from Comrade Matole Matsecha, I think it unnerved me a bit when you were speaking about Parliament like that, because Parliament is at the center of everything else, but it seems as if Parliament is without any ability, to actually do what it is supposed to do. So the problem is somewhere else. I don't know where the problem is, but there is a problem there. If all the reports are commissioned, but nothing is done. A colleague was telling me even about a recent report, on a matter, a sensitive matter, where a team was brought together, they filed a report, and then Parliament votes against this report. So it's confusing. It really is confusing where Parliament is coming from, and why are we where we are today. So I'm not surprised that the NNM, broke this. They broke the mold. They went to the Constitutional Court, they got their decision. that, as it was explained, insofar as, the Electoral Act does not permit for people to partake, in politics or to stand for office without being members of the political parties. There it is. It has come out now, and it's a Constitutional Court judgment. It has to be fulfilled. So whether the president will take sufficient time, facilitator, to consult, to get the right minds around this bill before he decides to assent to it or not. For me, what's also at play is timing, because if you think about it from a technical point of view, you have to prepare for elections, and you have to prepare for elections well ahead of time. So I don't know whether this time is sufficient for the IEC to produce these 2 ballots and to get ready for this particular system. At least, I should say, I haven't heard them. I haven't heard their voice about practicalities of this particular election. And I think the bigger issue being, will they really reach the people and explain to them how they should vote, and that this vote stands for this and this one stands for this? I'm not sure about it. And all the criticism that was leveled against the bill, I think some of it is still there, still valid. It has not been really dealt with. So I see the electoral amendment bill as, something that is still going through a tunnel of consideration. Whether it will be implemented next year effectively, successfully, I'm not sure. I know that the purpose of the Constitutional Court was to make sure that it gets ready for 2024, so that it is actually implemented. There seems to be a lot of barriers, in the amendment, in the act, in the bill, about how you can become an independent candidate. You get a sense that commoners, just commoners won't be able to do this, because it involves money, it involves getting signatures from people who support you. The regions are 9, I agree, different from the regions suggested by Van Zyl Slabbert. So let me leave this, because we'll talk about it maybe when we have the discussion. Let's go to the next slide, just quickly on voter apathy and participatory democracies. There's the numbers. The numbers are talking for themselves. What the facilitator spoke about was true, that I have voter registration in the column. With me, it's on my left. I don't know how it shows with you. Voter registration. These are the numbers that we have. And then voter turnout. I think the really critical one for me is that 48.86, that the voter turnout seems to be going down. We'll tease it out as to, how do you perceive this? How do you deal with it? On the last column on the right is about intentions, voters. There was a survey that was done, 3,005 voters and non-voters, telephonically, just asking them from these metros, why are you not participating? Some are citing individual barriers, economic situation, being able not to go, administrative barriers, my ID is lost. Complaints about service delivery, disillusionment, disinterest also was one of the things. The next slide. The last slide that I have is a bit of the road ahead, what do we do? So I start just by reminding ourselves that, look, as the philosopher Maboho Pesimore, reminds us, we're just, a process of transcendence, that we haven't arrived there. I cannot quantify the number of years it will take us to achieve all the wonderful goals in the Constitution. So it will always be like, we're changing, we're reviewing, we're changing, and we're going forward. Because we've had this conference and we're looking back 25 to 27 years, doesn't mean that we failed, and therefore there's nothing that could be done. Always changing. But within that, I'm saying, let's prepare for the 2024 elections quite well, very well. I think that is, for me, is a fundamental, and try to reach the voters as much as possible, put effort towards doing it. And that the IEC must be supported as a custodian of electoral democracy, always, and their independence. They must also assert their independence, because once they are seen, then the election gets that kind of legitimacy, objectivity, and so on. For me, I think sometimes they are too much in the background. They must also, I recommend that we must go back to these commissioned reports, in Parliament, because there are thoughts there. We can't be just piling up thoughts every year without really implementing any. And then the evolution of the Electoral Amendment Act, I don't have to add anything there. And then the mid to long-term strategy for youth constitutional education, democracy education, which the IEC has started. I've seen that they signed an MOU with the Department of Education last year to bring it into the curriculum, which is wonderful. And I would like to close by just James Baldwin's exhortation, where he says, know from whence you came. If you know from whence you came, there are absolutely no limitations from where you can go. So historical context is, for me, a punchline. Thank you very much.
Thank you so much, Professor Mchunu. But unfortunately, we need to get participation from conference delegates. We can't be preaching to ourselves. There's a lot that's been said, and thank you very much to both panelists for your inputs. I also wanted to make a few comments, especially in relation to accountability, in relation to voter education, which Professor Mchunu touched on. If you can just please indulge me, and then I'd like to open up the floor in 3 minutes for questions from participants. The IEC, Professor Mchunu, as you know, has what is called voter education, and it is a budgeted for line item under the IEC. In the interest of transparency and accountability, especially financial accountability versus what the finances of government do once they've been deployed, there's absolute deafening silence on what has been happening with the voter education budget of the IEC for maybe two decades or more. Save for the last voter education campaigns that most of us are aware of, that tell you where to put the X next to which box that you prefer. That's not electoral education. That is not democratic education, especially in a country where majority people do not actually communicate in English as a first language. There's no mother tongue instruction about what democracy is, what elections mean, and what the constitution means, and the Constitutional Court, and the entire democratic system of governance. And so that's the biggest, you're absolutely correct, I wanted to agree with you there. On the question of accountability, I'd just like to also add that I think that when people are defensive and they want to protect their own spaces and their own power bases and authority, and that's quite understandable as human beings, once we gain power, we don't want to let go of it. I can understand the hesitancy and the perspective that the New Nation movement is out of line, this, that, and the other. But the reality is that proportional representation and party list systems only exist in all the parts of the world where there is inequality, violence against women and children, extreme and growing poverty. You can go and do that research on your own, you're all legal persons, and come back and challenge me if what I'm saying is wrong. The system that we have, which has been declared unconstitutional, is existing in third world countries, which means there's a very big relationship between the corruption, financial maladministration, lack of financial governance, lack of accountability, lack of fear of the people, lack of accountability to taxpayers, and everything that goes with it. There's a big relationship between this that we are experiencing in terms of our lived reality and material conditions as South African citizens, and the electoral system that was adopted in 1993, understandably as an interim measure. But I also want to add that we should be very honest about this, and it shouldn't be about old people trying to defend their position, protect the things that they did. It should be about what needs to happen electorally, democratically in South Africa in order to pull us out of this quagmire that we have also as citizens. We need to take responsibility that we have allowed ourselves to be dragged in for 30 years. The final thing on my side that I really wanted to add is that it's very important to understand that you can't call it a participatory democracy, an inclusive democracy, if, Mr. Naidu, a citizen of the country is not allowed to contest political office as an individual, and they can only be forced to do so under the ideological framing of political party systems if they feel that the political parties are way too divisive because they focus primarily on ideological positions, get stuck on ideological positions, fight over ideological positions, and we see the result of fighting over ideology. It has not achieved the prosperity that the Electoral Act in 1993, interim as it was agreed to be allowed to operate the electoral system. Even former President Nelson Mandela himself said it, that the reason the Electoral Act was then rushed and had to be approved was because the country needed to deal urgently with the issues of inequality, poverty, underdevelopment of South Africa as a whole. And so if the Electoral Act has then delivered the opposite of prosperity for the majority, the reality is that defending old views is not going to take us forward into this brilliant future that we all want to go into. And on that note, yes, it's not all lost. We won the case in the ConCourt on behalf of the people, and I love the intentions from Professor Kunu's comments and his presentation, that none of us knows how much time we have individually on this earth. But we know for a fact that the children we have left here is representing posterity. And when we think about future generations, our children's children and their children, and so on, and we consider the trajectory that we are on right now, are we all comfortable that what we are allowing ourselves to be participating in, called a democracy and a constitutional electoral democracy, will be able to carry our children qualitatively and their children and their children's children into the future? And so on that note, I'd like to open up for questions, please. I think we've all become accustomed to the process of presenting questions to the panelists. The microphone that I see is the one on my right, on my far right. But if there is someone with a roving mic, I'm not sure if there are, sorry, the light is very dim. Let me acknowledge a hand here, 1, 2, 3, 4, 5, 6, 7th row on this side. Please come forward, thank you very much. I don't know if that's a hand that side, I don't see a hand, but if there's a hand and I'm not noting it, please stand. There's a hand here in front, 1, 2, 3, 4. Please come through. And follow the queue there. Yes, there's one person who's already there up front. Please proceed and stand in front of the mic as the first engager in this discussion. Sir, you'll be third after the lady who's coming down the passage. Let me note all other hands for inputs, questions, discussions. If there is someone I'm not noting, please stand up. Thank you very much. You can go ahead.
My name is Mambule Tumele. I'm living with disability. I want to ask a question that's relevant. People living with disability, they don't have a voice. If ever I have to go to school, I have to wait in a list. I must be assessed and go into the school. If ever I have to find a job, I have to assess and find a job. Where's my vote? Where's my right as a youth? We are getting killed, we are getting raped. We can't complain in the position. But what's in? When you go to the court, the case ends up nowhere. Because we don't have a voice. As a person living with disabilities. They are killing our brothers and sisters. They are getting raped every day. In our house, kill feminists are but they didn't say nothing. Where is our right? Where is our voice? As youth of South Africa, we don't have. Even to go to school, we don't have land. We don't have enough school for school living with disabilities. We don't have the hospital for people living with disabilities. We don't have the center. Disabilities. If ever you get a center, you have to lose your SASSA grant money to pay in the center. Where? If you found 2,000, Batho ba phela ya ka diphologolo ko strateng. Ba re ke ditseno tsa ko strateng. Raise our voice as the voters. We also vote in this parliament. We also vote in this economy, but we don't have voice. Where is our right? I want to know, sir.
Okay, yeah, thank you, Program Director. Nzwanele Manyi, Head of Policy, African Transformation Movement. Unlike for the previous panel, this panel I agree with both of them, everything they've said. I want to agree with Professor Mandla Mchunu on two issues in particular. On the one issue in terms of the role the IEC could have played in bringing neutrality, because this whole thing of this electoral reform is counterintuitive to political parties. So therefore you needed a neutral voice. So indeed, I think if IEC is here, they must please rise to the occasion. The issue I want to raise is just one issue. The issue I want to raise is the risk that is not addressed by any of these eminent panels. And the risk is who becomes the president of the country. In terms of the Constitution now, Section 19, every citizen can participate and all of that can end up in Parliament. And as we know that the election of the president only happens in Parliament. So basically what you have here, you can have a let's say you have a drug dealer in Mexico that has got a 20-year program. So this drug dealer in Mexico can find a way to get someone to come to South Africa and just be a citizen. You make all the necessary requirements, 5 years or 10 years, whatever is the case, and then you're a South African citizen already. Then you can be elected to be a public representative in Parliament, and once you are in Parliament, you are eligible to be nominated for being the president. I think this is wrong. So I think what needs to change in the electoral system is also who becomes a public rep. I think South Africa should jealously guard who represents. I have a problem with the fact that even in the Parliament as we speak, there's somebody from Asia. How can that person represent me in Parliament? I have no problem with anybody from anywhere in the world working anywhere in South Africa doing whatever. But the public representative role should be for people born in South Africa and nobody else. Thank you.
Thank you very much. Sorry, my microphone was not working earlier. I'm going to have to just check. There were two ladies who had raised their hands first before everyone else. I'm not sure if the other lady has decided to step down from her question. I'd rather give that lady, sorry ma'am, was that you? Please can I ask you to give her the opportunity duly, because I only noted 3 people and I see we now have more people and we don't have any time. So I'm going to limit all of you to 1 minute. Thank you. Please proceed.
Thank you. And thank you for the presentations as well. It is said that the true health of a democracy is the ability for citizens to elect who they want to lead them and also to remove. But it seems like the issue is also rooted.
Electoral reform is something that should have been done a long time ago during the heydays of Van Zyl Slabbert, but it is never too late. You see, prisoners do have a right to vote, but they cannot vote and don't want to vote anymore because they are intimidated, they are victimized, and they are told all sort of things. And this happened in the full view of the IEC. You know, you cannot vote because you don't have an ID. And if you want to get an ID, you must pay, a temporary ID, you must pay 110 or 80 rands. Where do you get all that money? And this voter apathy come as a result at the Department of Correctional Services, where we have a situation where nobody wants to talk about these potential voters because none of us sit here has ever been to prison. None of us who sit here don't have a relative in prison. None of us who sit here will ever talk about their relatives and friends that are in prison. Can the IEC and this new arrangement of voter electoral education look into what is happening in our prisons? Because those are citizens of this country.
Thank you very much. Thanks a lot. I've given you a little bit more than a minute. Thank you very much. Next question, 1 minute, please.
Okay, thank you, Facilitator. Yeah, I just wanted to give points that were raised by other students that are sitting there regarding the governance and the law electoral reform of South Africa. Students are saying free and fair elections since 1994. Are we ballots saying that we have never had votes being stolen, disappeared, or being influenced from the inside? It's a statement, it's a question that was raised by students. On my side, the issue of governance and electoral reform is an issue which is bigger than what we are thinking, because it affects all sorts of life. Talking about the regional, now Zimbabwe is about to go to elections. We are facing the same issue of governance and electoral reform, which is the main reason why most Zimbabweans are in South Africa. At the same time, I'm appealing to the ANC government to do the right thing on these upcoming elections and stop endorsing their friend, ZANU-PF government, so that they can create better future and better life for Zimbabweans, and also so that Zimbabweans, they can stop being a burden of South Africa, and also South Africans, so that they can also live in South Africa peacefully, because we realize that Zimbabweans, they are now taken as a burden to South Africa. So, but the problem is the ANC government, because it keeps on legitimizing the ZANU-PF government, which is the same government which people are running from. Thank you.
Thank you very much. Thanks a lot. Thank you for that question. Thank you, ma'am. You have 1 minute, and can I ask that we don't get any further questions because of time pressure? We have to conclude now at 12:30. So I'm also going to ask my fellow panelists to use those 4 minutes sparingly. Thank you very much. Thanks, Mami.
Thank you very much. My name is Ethel Khatebe. I'm a citizen of South Africa. I just want up front to agree with Mzwanele on the issue of really going seriously, as Professor Mandla Mchunu said. We need to move forward now on the issue of who must stand for public representation in our country. The last point I want to make is about voter education. We have seen the stats, voters, the numbers are declining for all political parties. But it's not only about not being dissatisfied. There's a lot of ignorance in our country in reinforcing the rights of every citizen to have access to vote because he will be informed. Can this conference look at that very seriously? Thank you.
Thank you very much. Let's give all the participants a big round of applause. Panelists, I'm going to ask you to choose which questions you want to handle. I'll make my inputs towards the end, and I'm going to limit you to 3 minutes each. Please, if you can come this side, because I'm not sure if the microphones are working. I tried it and it wasn't working. Oh, there's one that's working. Thank you.
1, 2. It's working. It's working. Can I see it? Yes. Okay. All right. Thank you. Maybe let me start from the end. The voter education matter. You know, this thing of voter education gives you a sense that it's a narrow program. It's just teaching people how to vote, you know, and it's easy to vote. It's very easy. So I think we're not talking about that. We're talking about democracy education. We're talking about what we didn't do. You know, this was an error that we committed so many years ago, the first administration. We should have invited people into this document that we call the Constitution. I've always thought over the years that each and every household must have a copy of the Constitution in their own vernacular language, so that the old ladies, when the kids are in school, the grannies or gogo and others, they'll be reading this Constitution and saying to the kids when they come back from school, do you know that we have a right to do this? Do you know that? So that the Constitution lives. So voter education for me is almost like something that you do periodic, just to re-invite and re-energize people. You know, I know that in some countries, like in South America, I think it's Chile, when there's a national election, the schools, the kids at schools also have a mock election. You know, so when parents get home and the kids get home, they've also voted, but of course it's a dummy election in the schools. That's the engagement. That's what we should be doing. But as I said, long term in mind, so that it becomes a culture. So I don't know what the IEC is going to do now, but from what I've seen from their reports, they really have moved into this particular space. You know, they've got a schools democracy program. They've got.
Thank you, Professor Mchunu. I'm going to have to be rude.
Okay.
And yeah, because I've been strictly requested to keep time. Apologies for that. It's just evidence of how much time this discussion requires really on the ground across communities, including the experts on the various issues. Mr. Naidu, any of the 7 or 6 inputs from questions that you'd like to respond to?
Yeah, just very briefly, if I may. I mean, I think on the issue of the money in politics, I think, you know, it's an important question. It's something that we really need to keep an eye on. The Political Party Funding Act has been in operation for only a year now. We'll get very soon the audited financial statements of the political parties, which the IEC will process and make available. Only then will we really have a clear picture after a full year of how effective the act has been. And I think we must look at the act as a starting point. Because I think the critical issue here, as the Constitutional Court has said, is that having access to the information about who funds political parties and also who funds independent candidates is an important component of the right to vote. So it cannot be divorced from that. So the more information we have, the better we are able to exercise the right to vote.
Thank you so much.
I just want to also make a point about the IEC. Professor Mchunu dealt with it earlier.
Please wrap
but
it
I
up
think
in
the
20
credibility of
seconds.
the IEC is that it has delivered free and fair elections in South Africa for 6 elections, and I have no reason to doubt the integrity of the IEC.
Thank you so much. Thank you. Let's give a round of applause to our fellow panelists and thank them for their inputs and their valuable experience shared here today. My parting shots is like, firstly, I really would like to sympathize and empathize with Umama from the disability, people living with disabilities, communities, because it is a fact. It's not the only constituency that is suffering under the current constitutional democracy of South Africa, but there are many, many, many millions and millions of South Africans who belong to various sectors and groupings of demographics in South Africa that are really suffering and are completely ignored, and except for voting, they basically see no benefit from the democratic electoral system that we have. I'd also would like to empathize with Mr. Budu from representing the constituency of people who are in prisons. And of course, we can't really comment too much on what the South African government will do in relation to Zimbabwe. Safe to say that if we can share our own private opinions, is that Zimbabwe is a country which should have its own sovereignty, pretty much like South Africa. I would really like to just abuse my position on the podium here today and say that do the way we do in South Africa. We listened to former President Nelson Mandela when he said, when the ANC does to you what the National Party did to you, do to the ANC what we did to the National Party. And even though we have the Constitutional Court as an option, we do have other options democratically that we pursue. I'd also like to acknowledge all the speakers who spoke about, the speaker who asked the question about removing a public representative. That's exactly it. You don't have any authority, power, influence to remove anyone. They have to be removed by the political party. Essentially, what you have in South Africa is what we in the New Nation movement call a democracy or a dictatorship, a democratic dictatorship of the minority. A political party identifies a candidate on your behalf, in your ward, in your province, nationally, and puts them on a party list based on their own criteria, which is allegedly democratic, but not overseen really by anybody, as long as they submit reports to the IEC and the IEC just agrees to it. I know one political party currently, which since its formation about 3 years ago has never gone to a conference. And the Electoral Act is very clear that if you form a political party within a year of forming it, you must go to a conference. That political party has representatives in councils, and there's nothing from the IEC. And so you don't have, your right is to vote. That's where it ends. You don't have any rights to hold them to account. They account to other political parties in parliament. The law says that. You do not have a right to recommend anybody on a list. You do not have even the ward councillor that you're voting for is actually not your nominee. That ward councillor comes from, for example, a political party with 300 members in your ward. If you stay in Gauteng, an average ward has between 15,000 and 20,000 registered voters and a population of about 50,000, give or take. And so a political party with 300 members in that ward of about 50,000 people in the population meets, has its own quorum, democratically elects or nominates a councillor candidate, and those 300 people then impose that candidate on the rest of you. That is not democracy. Thank you very much.
Thank you very, very much to the esteemed panel, facilitator, and panelists. Thank you so, so much. I think the issues that have been traversed is actually quite telling that, you know, the issues that we still need to, you know, address and deal with requires to continuously be pressing on and putting effort to discussions, debates, and the like. So thank you very, very much. Colleagues, without wasting time, I really want to sincerely apologize. As you've seen that we have been running over time. We do have one more panel to go to, and we'd like to go straight into it. And I'm actually going to command that the facilitator of the next panel ensures that we end at 1:30, because we need to take a lunch break at 1:30. There are one or two other items that need to be done thereafter. So I'm going to be quite strict on that one. So let me introduce panel 9. Panel 9 is the panel on the Constitution, international law, and international relations. I think we're quite aware that we are not an island as South Africa, but also our Constitution does provide that, you know, we need to embody, you know, international law in the work that we are doing. So I'd like to welcome on stage the facilitator of this panel, Dr. Lekaba. And the panelists, we have Professor Maloka. Please come up. And then we also have Miss Ndashe. We are also joined in this panel online by Professor Sarkin of Nova School of Law in Portugal, and Mr. Chris Givers, an international law expert at UKZN. Thank you very much. If the panelists could just join us, please, on the stage. I believe that the two panelists online have already joined, so they will also get an opportunity. Thank you very much.
Thank you very much, Chair. Good afternoon, ladies and gentlemen, all protocol observed. I looked at the constitutional provisions of how South Africa should engage internationally, and specifically Section 39, subsection 1, paragraph B and C, and it is further elaborated in Section 231. Subsection 2 and subsection 3. So the Constitution is very clear. South Africa must consider international law and other foreign laws as it engages in international affairs. But there is a way that the statecraft is arranged when we look at that engagement in international affairs. In our case, we say our foreign policy is a foreign policy of Ubuntu from our white paper of 2011. And in that white paper, we are very clear as a republic that as we engage in this statecraft internationally, we are guided by two major tenets, which is multilateralism and Pan-Africanism. I'm not going to elaborate more on this, but just to say, the realities in the global affairs are completely different from domestic affairs. And I would want to adopt the realist notion of what international relations is, particularly two notions from the realist perspective. They say states act in international relations out of their own interests. That is one. Two, the international system is anarchical but not chaotic. So I want to further elaborate on this aspect of anarchy but not chaos. Anarchy means there's no government above government. There's no government above South African government that will say, South African government, you have erred here in your foreign policy. And to manage this anarchy, over years, since the First World War, there's been an establishment of multilateral institutions to minimize the anarchy in the international affairs, so that it doesn't get to a level of being chaotic. So these are some of the issues, but I would want to quote our former President Nelson Mandela, because he gave a very interesting entry point of our foreign policy as we were transitioning from a pariah state in 1994 at the OAU summit. He said, I quote, "Finally, at this summit meeting in Tunis, we shall remove from our agenda that consideration of the question of apartheid South Africa. Where South Africa appears on the agenda again, let it be because we want to discuss what its contribution shall be in the making of the new Africa. Let it be because we want to discuss what material it will supply for the rebuilding of the African city of Carthage." Close quote. So, this has generated a lot of debates. I see Professor Zondi here. They entertained this debate on whether is South Africa a pivot state or a regional hegemon. So as we discuss these constitutional provisions of our foreign policy, these are some of the things, and I think Professor Eddie Maloka will help us to then understand how has South Africa performed multilaterally in the region of SADC, in the continent, and globally in as far as upholding human rights in this foreign policy of Ubuntu. And also South Africa's obligations within various multilateral and bilateral treaties. I saw I think in the first day, the panel that was discussing the transformation of our constitution touched a little bit the issue of the warrant arrest on President Putin, but they were not really willing to entertain the issue. So it has been a very big issue for us, and there are two cases that I want to quote which would help us to guide how the Constitution has, to a certain extent, regulated our engagement internationally. One, it is the al-Bashir case, where South Africa was said it did not uphold the principle of the, I think is the ICC Charter. South Africa did not uphold the principles. It did not enforce the arrest of al-Bashir. Whereas South Africa argued using an international customary international law on the Immunities Act. And the ICC and the courts in South Africa said South Africa was wrong to do that. That is one that is very instructive. And then the second one was the issue of the former Chief Justice Mogoeng on his comments on Israel and Palestine. He was made to apologize, and he indeed apologized. This now breaks the notion that foreign policy and domestic policy are two divisions. But it brings us the understanding that foreign policy and domestic policy should be considered within the context of public policy, one thing. So, I'm not a presenter, I was just laying out the nature of discussions we want to have here. Specific questions we would want to have is South Africa's foreign policy, especially in advancing national interest, are there dividends that we can see towards South Africa's economy, Prof. Maluka, I know you're a Pan-Africanist, you won't agree with that notion. And is there harmony between our constitution and the prescripts of international law in interpretation and in application? I think Madam Dashe and our colleagues online will help us to answer some of these questions. Without wasting time, Professor Maluka, I'm not going to introduce you, just to say, Professor Maluka is the CEO of African Peer Review Mechanism of the African Union. With a round of applause, Prof. The stage is yours.
Thank you very much, Mr. Chairman, moderator, and also let me take this opportunity to thank my friend and dear brother, the Director General, and fellow panelists. Good afternoon. And Mr. Chairman, you have asked me to comment on South African foreign policy. With your permission, I wish to take advantage of the license that the President gave us when he opened this meeting 2 days ago, to think outside the box about the 25 years of our Constitution, the lessons we have learned, and what we need to do for the next steps. I want to take advantage of this license given to us by our President to attempt to do two things. The first thing, to draw lessons from relevant history, and two, to place the experience of South Africa in this comparative historical context. I will argue that we are at the end of our post-1994 transition, and that it is now time for South Africa to reconstitute itself into a second republic. And I will be drawing from a few lessons, particularly comparative historical lessons, particularly post-revolutionary experiences, the decolonization exercises across the world, and of course the post-decolonization transitions, and of course also relevant case studies from recent history. Mr. Chairman, just to say that there are three things I need to start with. The first thing is about the nation state. South Africa is a nation state. We have a country with borders. It's supposed to be sovereign, it has citizens, etc., etc. But to say that the nation state is very recent and it has been created and can be recreated and uncreated. And then the second thing is that the state itself, which is the institution, a set of institutions that we've been referring to, it exists for a purpose, not as an end in itself. And in our case, it exists to transform society. That's why revolutions, when they are fought over the control of the state. So the revolutionaries, they target the state because you need the state in order to achieve the objectives you have for society, which is to transform the society. And therefore, it should be reconstituted, the state, if it no longer serves the stated purpose. And then finally, to say the third thing also in the starting point about constitutions, that the constitutions are not in the same category as the Bible and the Quran. Their scribes are fully conscious that all humans are fallible. Hence, when they write these provisions, when they write this constitution, they make provisions for how they can be amended and under what circumstances. Mr. Chairman, South Africa is, we know that South Africa was created in 1910. And Professor Matolo was talking earlier about South African history. And it was created by the British. To say that South Africa, in its emergence as a modern state, could have gone into four possible directions. The first one, which is what happened, which was the union of four colonies, two British and two so-called Boer states. The second, it could have been a federation, not a union of four colonies, like the British did in the case of Australia and Canada. The third one, which was provided for in the Union Act of 1909, was for a union of South Africa that would have included the so-called High Commission territories, or the BLS states, Lesotho, Swaziland, and Botswana, were in the vision of the British supposed to be integrated into South Africa and part of the Union of South Africa. And this was abandoned in 1961 when the Boers declared the Republic in 1961. And then, of course, the fourth option, which we saw in many parts of the world, was for the four colonies to remain separate and decolonization to happen in each one of them. So we'll have had four, instead of one union, we'll have had four independent nation states in this part of the world. And what was the 1994 dispensation about, and the Constitution we're talking about? The first thing is that the 1994 dispensation was a decolonization treaty for the transfer of power from the colonizer to the colonized. And at the time, the colonizer was strong and entrenched and could destabilize the country and prolong the apartheid condition. Today, the colonizer no longer has the presence they used to have in 1994. The second thing about the 1994 dispensation, it was a decolonization pact among competing nationalist groups over conflicting visions about what sort of South Africa they wanted. Over the future of South Africa, some unitary state, federal state, the land question, language, religions, and so on. And history shows that the absence of this pact could lead to civil war in some cases, and even the breakup of a state. That was the case of India and Pakistan. They split over the issue of religion. And the most important thing to say is that these nationalist groups that were at the head of negotiating and bringing about this 1994 dispensation, most of them some have disappeared, many have changed, and the leadership and the ruling party itself has significantly changed, even in its leadership, personnel, and ethos. And the third thing about the 1994 dispensation, it was a mechanism for the management of the hopes of the people. But these hopes have now been replaced today by hopelessness, apathy, disillusionment, anger, xenophobia, increasing racism, alienation, and increasing distance between the people and the political leadership. And finally, the 1994 dispensation was a mechanism to effect the qualitative leap from an old order to a new order, to effect a transition. Today we are now at the end of this transition, which is 30 years old, and it has now, in my argument, reached its point of saturation. And I just want to say a few words about historical transitions. That the South African transition has three elements to it happening simultaneously. It's a transition from a conflict society to a peaceful society. It's a decolonization transition, and it's also a transition from an authoritarian to a democratic state. And we know, those who are familiar, that each of these transition typologies have been studied, and each has its own dynamics, and all of these dynamics are happening at the same time in the South African transition. And the issue, the second thing is about transition, is that historical transitions can take very long. The current situation, the Ukraine conflict, is due to the unfinished business emanating from the end of the Cold War. We say the Cold War is long over, more than 30 years ago, but the expected transition from the Cold War to a new historical order is not yet complete. And then finally, that the unfinished business of historical transitions can come back to haunt you, as is the case of the Ukraine conflict. And then the unfinished business from the 1994 transition will affect us and will come back to haunt us. And I just want to cite very quickly a few of them, because we don't have time. The first one is the national question. There was some sort of a sense of automatism in how we constructed or we thought about national question when we put together our 1994 dispensation. Of course, it's reflected in the constitutional declarations and some of the state objectives, but there was a belief that the leaders who were leading this construction of the post-1994 dispensation will remain the same, static and unchanging. But it's also the same thing with political will. So political will works when it's there, but when it's not there, then we have a problem. So the question is the automatism upon which we relied for the construction of the post-apartheid dispensation relating to the national question is no longer able to sustain the rainbow nationhood that was expected. The first question relating to that is the indigenous question. We have not adequately addressed the issue of the Khoi and the San people, the most indigenous people of South Africa, in fact, Southern Africa, because the Bantus came into this region around 500, around the period 500, and they have now become a dominant force in this part of the world, and we have spoken about this a lot. But we see this in the composition of leadership across the state, even in some elements of how we define nationhood, how the Khoi and the San people have been left out. And it's something we have to deal with. The Australians, if you read today in the news, you'll see that Australia is still dealing with that issue of how to include and recognize the indigenous people in its sense and definition of nationhood. And in South Africa, this is a very, very important portion. We have defined the Khoi and the San people. Sometimes we say they are colored, they live in the margins of society, maybe their languages are not fully recognized even in the constitution, and they have been given a house of traditional leaders, and so on and so on, but they've not been included, and maybe also in the National Coat of Arms, there's some reference to them. But they've not been included and given the central place they deserve in the definition of South African nationhood. And then the second issue around the national question is the so-called minority question. It has been politicized by the opposition parties, but we do have a reality that we have Indian, colored, and the white South Africans who in 2023 feel left out of the South African nationhood project. The late Deputy Secretary General of the ANC, Comrade Jesidwa, spoke about this herself, even in the ANC. And it's a question we cannot leave unattended, and it needs to be addressed. How we address it, I don't have a solution myself, but it's an outstanding issue from the 1994 dispensation. The second outstanding or unfinished business is what I want to call the 1910 question, when the British constructed and created South Africa as we have it today. Of course, the British have always been dealing with the issues, even in the 19th century. Are we going to create a federation, a confederation, or a union? They even wanted to bring even Zimbabwe and everybody, even up to Tanzania. And of course, in 1910, they settled on the union. But this question is still not resolved. That's why we have provinces today. We have provinces which are entities created by a constitution, and those provinces are more costly to us than the value they add to society. And it emanates from that indecision on what we want. Do we want a unitary state, a federal state, or something in the middle? What do we do? How do we constitute ourselves in this part of the world? And then the second question emanating from the 1910 question is Lesotho. Lesotho is the only country in the world that is so totally surrounded by a neighbor. It is untenable. The situation is also untenable for the people, especially of the Free State. Because most people of Lesotho, they live and work in South Africa. They use the social services here, they shop in South Africa, their insurances are in South Africa. It's untenable. We have to deal with it. So in terms of what the British wanted to do, of incorporating Lesotho, Botswana, and Swaziland, South Africa, maybe Swaziland is different, maybe Botswana is different, but Lesotho is entirely surrounded. And even themselves, they know that as long as they continue to be in this situation, the question of South Africa is not addressed adequately. So even ourselves, it's something that at some point, some leaders have to deal with it and deal with it decisively in the interest of the two people. And then the last point, of course, around the unfinished business is what the previous moderator was talking about. We thought we were creating in 1994 and building people's power. But really we created a system, a political system of elites. They contract and transact among themselves. They choose leaders and so on and so on. And that system, say, really is something that we have to address, and is an issue that was addressed in the last panel of the electoral system and so on. And as to, at what point do you come to, as a society to a point that we have to re-envision ourselves, we have to reconstitute ourselves? I want to argue, Mr. Chairman, without taking a lot of your time, that there are four examples I want to draw from. The first one is that countries come to that conclusion normally after a traumatic event, a war, an interstate war, civil war, or some long period of dictatorial rule. The second situations, and this is I will give some quick examples, is when an existing dispensation leads to crisis after crisis. We have three cases here that I don't want to mention the name of countries. There they have a dispensation where the parliament can overrule the judiciary, ministers enjoy immunity, so people steal money. There are outstanding questions of decolonization. So that country currently, as I'm talking to you, it's even in the news, they have a mass-driven bottom-up process of reconstituting their country. They want to change how they were constructed by their former colonizers in the 1960s. They want to change how they constructed the state, the constitution. So there is a whole mass movement happening in that country in West Africa. Because the current dispensation leads them leads them from one crisis to the next. Then they realize we can't live like this. We must get out of this, but we can't use the normal door. We have to jump out of this. And then the other country, this one is in East Africa, they've completed this exercise. Every time after an election, they fought over ethnicity. Then they realized, why must we continue this way? We have to change things. So they went in, they overhauled the entire system and created counties, governors, and so on and so on. And then the final one is not far from us. This one is a reconstitution of the state imposed by neighbors on this country. Because this country, they have a constitutional system where parties get elected into office. When they are there, members of parliament can cross the floor, but when you cross the floor, you leave with your position. So what happens then is that you have a government in power, and a government in power now is no longer a majority, is no longer leader of the coalition because somebody left with it. So they are also in the process of reconstituting the state. And then in the case of South Africa, I think that we are in the third category. This is when the institutions that we have created, or the dispensation that we have created, is now, there is a mismatch between what we wanted to achieve with this institution, with the actual. So there is a misalignment between stated purpose and the actual, with what our constitution wants to achieve and so on. So in our case, we wanted to decolonize. We wanted to build an unracial society. We wanted to eradicate poverty. We wanted to build an equal society, etc. And 30 years later, we have not achieved much in this domain. In fact, it's getting worse. So it's a sign that something has to happen. And you can see, Mr. Chairman, that we have reached a stage in our country where we have to reconstitute our state, the foundations of our own society. And I want to say that there are a few signs already here. One is that we have reached a stage of regime instability that should worry all of us if we are to prevail as a nation. And the signs of this regime instability is frequent changes to government administrations after ANC elective conferences throughout the 3 tiers of the state. And the second one is every parliament after elections is now like we're starting afresh because of dynamics within the ruling party. Thirdly, the opposition is very weak, but while the opposition is very weak, within the ruling party itself, there are opposition elements that want to annihilate each other. And their instability in the party is now spilling over into society. And there is a frequent restructuring of government departments, provinces, and municipalities. And the PR, of course, as it has been said, the PR electoral system has resulted in unintended consequences. We thought we were creating people's power, a democracy, which we did, but we created the power of elites that transact and will act among themselves, and so on. So the next steps, Mr. Chairman, and I'm concluding. I think that, DG, you are here, my brother, that to commend the department for this initiative. But to then say that we need to go beyond this. We need to constitute some sort of a constitutional reconstitution process of some sort. I can't say something similar to the Freedom Charter because Advocate Mujanku was very critical from reading Rusty Bernstein's book. But we need something that is mass-driven, bottom-up, not some transactions among elites in parliament on the act, on this, borrow me this, and some elements of the elite in the judiciary that, no, this one, paragraph 3 is wrong, change this one, and so on and so on. We need something that can mobilize our society and be able to lead our country to a new dispensation. We need to find balance. I don't want to be misunderstood to be saying that if a state doesn't work, you must always change it. I'm finishing, Mr. Chairman. If a state doesn't work, you must change it. No, you must find balance. There are circumstances when societies have to be reconstituted. And when you are confronted with those circumstances, you must have the courage to make sure that you accept the reality and move to change. So you must be bold, courageous, but more importantly, you must be creative. because you need your creativity for problem solving. But at the same time, you must find balance between that and another important imperative, that successful societies need three things. One, certainty, secondly, continuity, and thirdly, stability. It's not unusual, Excellencies, colleagues, for post-change societies to experience a period of stress or decline. Like in our case, it happened in the US, they had a US Civil War. It happened in China afterwards, it was followed by the Cultural Revolution, and the Russian Revolution itself was followed by a civil war. But the important lesson to learn from this period of stress is that it has to come to an end, and come to an end very soon. And for this to happen, it requires bold leadership. So that was always the defining factor in all these situations that you study. A crisis moment, but it's leadership, that always. And India, if you don't have leadership coming in boldly, creatively, solving the problem, you will have one challenge, and one of them is millenarial movements and false prophets. People will tell you that, no, if you shoot me, your bullets will turn into water. They give people false promise. They tell you, oh, come to my church. I pray for you, you become a millionaire. And we can see the millenarial element in South African politics at the moment. It's a sign that we need leadership to take our country to another level. Thank you very much.
I won't summarize. I will just make notes and send to the conference organizers of what was the key issues. Next on our program is Ms. Bongile Ndashe, Director of Initiative for Strategic Litigation in Africa. Round of applause, please.
Good afternoon to all, everyone present in the room. So my intervention focuses on the work that I do at ISLA, which is litigating before the African Human Rights Mechanism. This panel today focuses on international human rights law and international relations. These two things are related, but they are different. International human rights law lays down obligation for states which they are bound to respect. And so by becoming parties to international treaties, states assume obligations and duties under international law to respect, protect, and fulfill human rights. Whereas international relations, it's the study of these relationships between, the relations between these entities and the connections between economics, law, and politics in the global environment. This is a field that can get very murky at times because the interest, which the chairperson talked about, is what is at play. The intersection between international human rights law and its foreign policy, how they act in international relations, is where South Africa has consistently found itself in a fix. We have international human rights mechanisms. On the continent, we have a number, but I am going to focus on two. The African Court on Human and People's Rights, and the African Commission on Human and People's Rights. These spaces came into existence, the international human rights system of protection came into existence when there was a recognition that sometimes nationals or people who have been violated by a state may need to seek protection elsewhere because sometimes states are not able to provide that protection to their citizens. But this does not happen in a vacuum. We know that states are sovereign. Then there is this principle of subsidiarity, which says even when states have accepted the jurisdiction of these supranational bodies, there is still a recognition that they must first try and solve the problem, because subsidiarity recognizes that the people who are best placed to solve these problems are the member states themselves. And that's why, even after they have given a remedy, the states must still implement that remedy. So, when we engage these mechanisms, one thing that we know very well is that they are as weak or strong as the people who set them up want them to be. And these are our governments. So when South Africa leaves and go and engage on our behalf internationally, we want to believe that our values is what informs that interaction and nothing else. But we also know that in the field of international relations, there are many interests which go beyond human rights that the states have to take into account. Seeking to understand the nature of these interests has become key in understanding why South Africa does the things that it does when it engages internationally. Now, South Africa has engaged with the continental mechanisms in different ways. There are different periods, and the first period is when there was a period of meaningful engagement with the continent when South Africa returned from isolation and joined what was then known as the Organization for African Unity. It played a strong role in the foundation of the African Union when there was a transition from the Organization of African Unity into the African Union. It's played a very important role in this intense period of norm setting from around 2002, where about up to 15 legal instruments were adopted by the African Union. But the position seems to have shifted from around the 2010s. South Africa has moved from being an active participant to a position that others are calling nonchalant about what's happening to the mechanisms. It has taken the stand of playing big politics without necessarily investing in the viability of these institutions. This has led to a perception that South Africa is playing what is known as South African exceptionalism, that we have got our legal system, we have our constitution, we have our judiciary, and everything is working, and we are not going to invest so much in the continental mechanism. So, one of the questions is, if South Africa is to engage, what is it that would require South Africa to recommit and to re-engage? In the African Commission on Human and People's Rights, this commission was established and it came into force in 1986. And it was inaugurated in 1987. South Africa seemed to have abandoned its role, in its initial active role in protecting the African Commission. In 2006, when a number of rogue states started to attack the independence of the African Commission, saying that they are making findings against them because they have been paid by civil society organizations like Amnesty International and others, it was South Africa that got up and defended the mechanism and did not only stop there, they sent seconded people to the African Commission to help. South Africa argued that the Commission can't be blamed for receiving funds from other organizations if member states of the African Union were not doing enough to support the Commission. But to tell the story of how South Africa is engaging now with the African Commission, I start with the story of South Africa's engagement in March of 2011 at the United Nations. South Africa showed up with a draft resolution that can only be described as a distortion of international human rights law. South Africa had a draft resolution which was called, I think it's one of the draft resolutions with the longest names, but it was called the imperative need to respect the established procedures and practices of the General Assembly in the elaboration of new norms and standards and their subsequent integration into existing international human rights law. What they were trying to do, the issue of sexual orientation and gender identity, had become a lightning rod at the UN as it continues until this day. So South Africa said it wanted to help resolve this issue. So one of the things that it was saying was that the way in which the issue of sexual orientation had been incorporated into the United Nations has really been contrary to how international norms are adopted. And so they proposed the creation of a single modality, which meant that all mandate holders and mechanisms of the United Nations will stop working on the sexual orientation and gender identity issue and then put it into this one basket until there had been a resolution on how the United Nations deal with sexual orientation and gender identity. But this was a distortion because sexual orientation is not a norm. It is simply an identity, right? So there was no new norm. So all the rights that exist in the UN and the protections were now being extended to a particular group. And the way in which international human rights law has worked is that protections have been extended to different groups. I'm mentioning this because, well, South Africa did go through a process that I would call cleansing, because in June they came back with a decent resolution that really turned against this position that they adopted, and it became the first sexual orientation and gender identity resolution at the United Nations led by South Africa. Over the last decade, there have been attacks against the African Commission by members of the African Union. And South Africa had not stepped in to help. But what is consistent is that the language that South Africa used at the United Nations is exactly the same language that rogue members of the African Union are using to attack accountability mechanism. They distort international human rights norms in order to dismantle or weaken the mechanism, and once again, they use the lightning rod. But issues came to a head in 2018 when the Executive Council of the African Union adopted Decision 1015. First of all, they said that the African Commission does not enjoy independence, and this is a quasi-judicial body from the same organs that created that body. First of all, the African Commission is created by a treaty, not by the organs. And any judicial or quasi-judicial body has to be independent from member states because it is not there to mirror the bigotry of member states, but it is there to hold those states accountable. So how states define human rights is not how the African Commission should interpret human rights. They proceeded to say that the African Commission must first verify all allegations before putting them in the report, and also ask them to observe confidentiality at all stages of the work of the African Commission. This is not confidentiality that they have been asking for, this is secrecy. It is secrecy in that they do not want to know whether there are cases lodged against various member states. In fact, the African Commission in the world remains the only body where you do not have a cause list, and people who are litigating before that mechanism cannot talk about the cases that they have filed against their governments. This is notwithstanding the fact that the mechanism has got rules of procedure that allows organizations to be friends of the court, which is an impossibility when people do not actually know what kind of cases are pending before that mechanism. There's a lot of things that happened in that decision 1015, and one can look at it. I am raising this thing here to say that, unlike the United Nations, we don't have a process where we see how states vote on particular issues. AU decisions are adopted by consensus. What we know is that on that day, South Africa was present in the room, but South Africa said nothing. The distortion of international law is what happens at the Executive Council when it comes to the African Commission. But it looks like the African Union has won, because in December of 2023, the African Commission rejected the observer status of 3 NGOs on the basis that sexual orientation was not an expressly recognized right in the African Charter. And once again, there is no right to sexual orientation in any instrument. It also said that protecting and promoting sexual and gender minority rights was contrary to the virtues of African values, adopting the language of African member states. It is quite clear that their independence have been threatened. Now let's quickly go through the African Court. The African Court adopted in July of 1998, when we were still very present, enters force in January of 2004. 12 countries have accepted the competence of the court. 4 have since withdrawn. 8 are remaining. South Africa is one of the countries that have not accepted the competence of that court. For South Africa to make that declaration would be part of strengthening the court, particularly in a context where a number of other countries are leaving. There is this view that by refusing to subject themselves to continental mechanism, that it helped to create, South Africa is saying we're so special, we don't need to adhere to these mechanisms of human rights. South Africa's behavior in relation to the African Court can at best be described as contradictory. It participated in the establishment of this court, hosted the negotiations for the establishment. It continues to participate in the monitoring, sits in the Permanent Representatives Committee, and does a whole range of things in terms of reviewing the reports of the court, but it will not subject itself to this court. The same court, South Africa was also part of this, was given another mandate, so a new protocol came into being, which merged the African Court of Human Rights with the African Court of Justice. Although this was adopted in 2008, it has not yet entered force because they haven't collected the number of ratifications that are needed. And finally, there is a protocol that added another mandate to this court, so basically 3 different mandates, and this was the criminal mandate, what is known as the Malabo Protocol. When South Africa was pushing for ICC withdrawal, this was a shock to many African countries because South Africa had fought for this not to happen. South Africa had said withdrawal was not an option because the Malabo Protocol has not seen the light of day. So if African countries withdraw, then there will be a protection gap. But let me just end with a list of things that I believe or we should urge the Department of International Relations to do in order to strengthen the regional mechanisms, because we do need them. And these are very low-hanging fruit. There is a mechanism at the African called advisory opinion, and you don't have to have deposited a declaration that South Africa can use to clarify. There are provisions of the African Charter that can benefit, that can be strengthened, like this issue on confidentiality. South Africa has entered a reservation in the Maputo Protocol. It's not good for any state to enter a reservation, and they can do an advisory opinion even there. South Africa can take a position to defend international human rights standards whenever there is a distortion at the African Union instead of sitting silent. They can resolve to lead when it comes to the efficiency and the effectiveness of this regional mechanism, because we do need them. But more importantly, they can lead the creation of a group of what's known as friendly states, because someone has to lead the fight for human rights on the continent. And at the moment, that is what we are not seeing at the African Union. So I will stop there.
Thank you. Our next two speakers, they come from the same discipline. Is Professor Jeremy Sakin and Christopher Gevers. So I would want to urge the two gentlemen to go on a coalition here, because they come from the same discipline, and show us how power sharing can be well managed. And they are both online, so I think they can do us justice. So I will give over to Mr. Gevers, who is a lecturer and international law expert at UKZN, and then will be followed by Prof. Sarkin.
Mr. Gevers and I share a lot more than being from the same discipline, but we also come from UKZN, from Durban, even though at the moment I'm in Portugal. So thank you very much for the opportunity. I want to talk about the role of the Constitution directly as far as international law is concerned. And I want to place it in the context that the Constitution is an embodiment of memory and promise. And what I mean by that is the Constitution reflects our past. It's the memory of what happened, but it's the promise about the future. And that's particularly important in relation to human rights issues. So I'm going to couch my discussion largely within the context of taking up human rights challenges. Certainly, if we think about our past, deeply littered with massive human rights violations, deeply littered with the impact of apartheid, deeply affected by detentions, by enforced disappearances, by a whole range of issues, many of which have not really been resolved and are still part of the issues that need to be taken up. We also need to see it in the context of the role of many countries in bringing the end of apartheid. How many countries contributed to the liberation struggle to bring change and to bring about our democracy. And as Professor Mkhunu said in the last panel, we need to know where we come from to know where you're going. And I absolutely agree with that. And the Constitution is a reflection of that. It's a reflection of the issues relating to our abysmal human rights record in the past. One thing I want to mention in relation to what the chair said in the beginning, and that is South Africa is in a process of oversight. There are processes, and that's where international law is important, which is to give guidance to South Africa about its international obligations. And international law has largely two parts. Those which South Africa is obliged to follow because international law is binding, regardless of whether South Africa is a voluntary part of that international law. And those two parts, I'm not going to go into all the details, is customary international law. So, for example, even if we didn't agree that torture was a norm which we did not want to comply with, international law is clear that one has to do so. The second part is when one joins an institution like the United Nations or the African Union, one has to follow those rules. And one of those important rules in the United Nations system is universal periodic review. And universal periodic review says every 4 or 5 years, South Africa is reviewed in terms of its human rights history and where it's come along and what it's doing to determine where it's going and whether it's complying with those particular issues. Second part are its treaty obligations, like, for example, the Rome Statute. We haven't mentioned that, and obviously this is a big elephant in the room. What will happen to Vladimir Putin if he comes to BRICS summit in August? Will he be arrested, as South Africa is obliged to do under its obligations in the Rome Statute? But that's a voluntary membership. South Africa didn't have to join the Rome Statute, but now it is a member, it has to comply with those particular issues. So that's the context that I want to talk about this, because South Africa is not given a great deal of guidance about how to follow international legal principles in its constitution. The constitution says in a few places procedurally what has to happen. And as was mentioned, particularly important, Article 39, the interpretation clause of the Bill of Rights, says that courts must consider international law. Processes of how international law can be adopted, who signs agreements, who ratifies, what's the role of the executive and what's the role of the cabinet is laid out. But the principles of what we do and how we do it is not laid down in the Constitution. So the Constitution is largely procedural, but not about substance as far as those issues are concerned. So for me, one has to look at the principles which are embedded in the Constitution to determine how we need to be laying out our foreign policy in those particular issues. The fact that, for example, we come from an apartheid background means that apartheid and its legacy is a deeply critical part of our past, and we need to deal with it. So, for example, the one issue which I think is deeply surprising to many of us is that South Africa has not ratified the Crime Against Apartheid Convention. South Africa is saying that it will do so in the future, but it still has not done so. And in fact, recently in a report to the Universal Periodic Review of 9 March, in other words, 2 weeks ago, South African government says we'll get around to it, but we will be doing other treaties first. So the context is important, understanding where we've come from and how we need to react to that. Another treaty that we haven't ratified yet is the International Convention on Enforced Disappearances, something I know very well. I used to be the chairperson of the United Nations Working Group on Enforced or Involuntary Disappearances. South Africa has not ratified, and again with the Crime of Apartheid Convention, says it will be doing that ratification. And the question is, when will that happen? And these are issues where 25 years into our democracy, we would have thought that those particular crimes would have been ones that have been taken up much more. So we have to look deeply into our Constitution. And I want to touch briefly on the preamble. The preamble starts, and this is the very first few words of our Constitution. We, the people of South Africa, recognize the injustices of the past, honor those who suffered for justice and freedom in our land, respect those who work to build and develop our country. And that means deeply within our contextual part of our Constitution is the nature of our past and our need to ensure that those things don't happen again. The preamble says we want to heal those divisions. In other words, we want to deal with disappearances that were the legacy of the apartheid system. We want to establish a society based on democratic values, social justice, and fundamental human rights. Those are core issues within the context of our Constitution. We want a government based on the will of the people. And finally, in the preamble, it says, we want to have a South Africa able to take its place as a sovereign state in the family of nations, linking us to our place in the world and moving us in the direction that we are a useful member playing our part and being obliged to follow those particular issues. But what we can see over the last 30 years is complete change in how we've addressed those particular issues. During the apartheid system, it was a one dimension. During the Mandela years and into the Mbeki years, there was somewhat of a different position even from what has happened more recently. So we've seen changes. So we've seen changes which have not always reflected our constitutional values, largely from the perspective that we are a deliberative and consultative democracy. And what I mean by that is that we're meant to deliberate and consult on the issues which are important. But that's not always happened. So we're not going to talk yet about the substance of the issues, but the process by which it is done. So let me give you one example. When South Africa decided to withdraw from the International Criminal Court in 2016, there were no discussions about it. There was no openness and transparency. South Africa deposited its instrument of withdrawal at the United Nations, and nobody knew about it until it'd been done. And this is often the case. So my plea would be, let's look at the constitutional values in terms of openness and transparency and have greater debate on the content of our discussions. It shouldn't be that these decisions, whether we withdraw from the ICC or stay, whether we decide to take up LGBTQ plus issues, or whether we disagree on the stance on the war in Ukraine, or whatever the issue is, there ought to be greater discussion and greater ability for public engagement on these particular issues. So we need to see these in a historical context, first of all. South Africa's background in terms of its link with the international legal system and with the United Nations and with the international legal framework has had, as I said, different periods. We had an anomalous situation where South Africa was a pariah state during the apartheid years for obvious reasons. It had difficulty complying with international law. And the way it was viewed by the international community and the way it was seen by international justice was deeply problematic. This is despite the fact it was a founder of the League of Nations and the United Nations. It was given a mandate over Southwest Africa, as it was then and is Namibia today, during World War I. But it lost the support of the international community over Southwest Africa because of its apartheid policies and its refusal to give up that particular mandate. It was a decision of the International Court of Justice in 1971 that said to South Africa, your mandate is ended, but South Africa refused to apply with those particular issues. As far as particular instruments are concerned, South Africa joined a range of instruments during the apartheid years. For example, the 4 Geneva Conventions, which it ratified in 1952. But it refused to ratify the 4 additional protocols of 1977. Unsurprisingly, the African National Congress did. And in 1980, the ANC signed a declaration, which it didn't have to because it was a non-state party and only states can ratify instruments. But the ANC said, we are willing to accept the Geneva Conventions and their protocols. Surprisingly, South Africa took more than 15 years after 1994 to accept the Geneva Conventions and the protocols. And those were only domesticated in 2012. But the years from 1994 saw South Africa joining many international treaties, including, for example, the Genocide Convention. And that was what I call the honeymoon period. The 1994 to 1999 period saw South Africa signing and joining many institutions, ratifying a whole range of processes. And one of those, and South Africa was one of the forerunners and one of the major players in the development of the International Criminal Court. It was the first country, one of the first countries to sign the Rome Statute, which it did in 1998. And particularly important, it was the first African country to do so. And then it joined the treaty in 2000 and domesticated the Rome Statute into South African law in 2002. But we see a shift after the Mandela years, where South Africa's foreign policy being less human rights focused and more in the pragmatic realm. So we've seen issues of economic and politics play a more important role than the human rights agenda. We've seen South Africa wanting to promote itself in the African Union, in BRICS, in a range of institutions. And I would concur with the last speaker that has said, South Africa has often stayed silent on a range of particular issues. It remained silent when the SADC tribunal was gutted. It remained silent on a range of issues in the UN. It refused to vote when it was a member of the Security Council in 2007 on Zimbabwe. It has taken stands often where it abstains on particular matters. It says that, well, the wrong procedure has not been taken up as far as those particular issues. I would also concur with the previous speaker who said South Africa has played a key role in the development of the African Union, the design of NAPAD, the development of the African peer review mechanism. The APRM remains largely invisible. And the question is, how can we make it more apparent to people around the world? How do we take those particular issues further? I agree with the previous speaker as well. The consultative status of organizations, both at the AU and at the UN, has been problematic. South Africa often has had to be pushed into playing a role in issues such as on land reform issues in Zimbabwe, where the government has refused to take a stand, but the courts took a particular position. So there are many issues which are important in terms of how do we ensure a stand on particular issues around the world, which are a reflection of our past, which are a reflection of our abysmal human rights issue. How do we move those issues forward, understanding that South Africa is also having an important position in relation to political developments and economic issues. But we've seemed to have lost some of our critical previous positions in relation to those particular matters. So how do we take forward the particular matters relating to our fundamental human rights matters, which are important to us? And then just to end off, I just want to mention the forward-looking issues which are important. As I said previously, South Africa has signed and ratified a number of human rights instruments. However, it's not ratified some of the important ones, which are, for example, the Apartheid Convention and the Enforced Disappearances Convention. Those are critical, in my view, to take forward South Africa's history and its legacy and the issues which are important. It also needs to develop its national preventative mechanism. In the last few weeks, the subcommittee of the prevention of torture came to South Africa, and at the end of its mission, which it did in terms of the Convention Against Torture, because South Africa ratified the optional protocol in 2019, was quite critical of South Africa's lack of development of its national preventative mechanism, which is there to ensure that torture cannot happen in security institutions, in prisons, in police cells, etc., etc. While there has been a process to design such a process, which started from 2014, there has been a lack of development as far as that issue is concerned. And those issues are important to try and ensure that we deal with massive degrees of torture and massive degrees of abuse, which happen in a range of institutions in our country. The SPT was very critical on South Africa's position in not creating an independent mechanism, and that's particularly important. South Africa has committed to creating a mechanism called a national mechanism for review and follow-up, or reporting and follow-up. And this is a mechanism unknown to South Africa. And that is basically a mechanism which will review whatever processes happen externally and what South Africa is meant to do to comply with those. The new name that is given to those institutions is a national mechanism for implementation, reporting, and follow-up. In other words, South Africa has many obligations, whether they come from treaty body, the Universal Periodic Review, from the African Commission. There are many, many mechanisms that have oversight over the South African legal system. And these new national mechanisms for reporting and follow-up, which have now been developed in 60 or 70 countries, and most countries are moving towards creating that. While South Africa has said it will be creating that, there has been almost no debate in South Africa about how it should be done, what mechanism should it be done, what model ought to be followed in that regard. I know quite a lot about this because I've been in other countries in creating those particular mechanisms, and I've been writing quite extensively about those particular matters. So we have to look, to end off my presentation, is to understand that our Constitution gives a lot of positions about what we need to do as far as international issues are concerned. Procedurally, it lays out some of them, but the values are contained all the way through the Constitution. Our Bill of Rights is seen to be some of the best creations in the world, but we haven't always lived up to how we actually go about ensuring that those values are actually concretized, that we actually do what is necessary to make sure that our promise of a human rights culture actually comes to fruition. I thank you very much for the attention.
Thank you very much, Prof. Chris, ladies and gentlemen, I've negotiated with the DG to give us a little bit of reprieve. So I would request sincerely that we take notes of the questions we want to pose to the panel. So we'll take the last speaker. After the last speaker, I'll go for lunch. And then we take 30 minutes lunch, we come back, and then we engage for 15 minutes, and then we are done. So Chris, please, Prof has said a mouthful, just endorse and subtract few points from what he said. The panel, the floor is yours.
Thank you, Chair, and thank you to everyone for being here today. So I want to speak a little bit about international law and my understanding of where international law sits within the South African Constitution. So it's often said that South Africa has a particularly international law-friendly constitution. As the Chair said when we began, international law has a prominent place in our constitution, both in Section 39, but in also Section 231 and 232 and 233. And that role of international law within our constitutional dispensation has only continued to grow since 1994. So our courts have been very keen to adopt and implement international law. Our executive has brought various treaties into our law, and our parliament has ratified them. And I think in the process of being a country that has a very dynamic and engaged approach to international law, and a very friendly approach at that, we may have forgotten to ask whether international law is itself friendly to South Africa. So to paraphrase briefly what the Chair asked, which was not whether South Africa comports with international law, but whether international law comports with the goals of South Africa and the South African Constitution. And I want to suggest that, in actual fact, where we stand today is a good time to think critically about the role that South Africa has played in international law, but also the role that international law has played within South Africa, both past, present, and future. And I want to suggest that, in fact, when we look at our Constitution, we can see that there is a particular approach to international law that reproduces a myth about the role that international law has played in our past. So if you allow me to briefly set out what I understand to be the myth of the role of South Africa in international law and international law in South Africa, and then to make two brief observations about how that continues to disfigure or complicate the way we think about South Africa's role in the international order. So first, in 1997, John Dugard, who many of our audience may know was the most preeminent international lawyer in South Africa, set out what has become the central myth of international lawyers in the post-1994 constitutional disorder, captured by the claim made by one of our international lawyers that international law was the progressive other of apartheid, the adequate, civilized, and principled response to all the illegalities and indignities that resulted from the systematic racial discrimination that was apartheid. In the years following the adoption of the final constitution in 1996, this myth was commonly employed by South African international lawyers and courts to justify the very special place that that international law enjoyed under the new constitutional order. However, this myth that international law opposed apartheid performs a double erasure. First, by beginning in 1948, and I pay tribute to our previous speaker who spoke about the Constitution of 1910, but by beginning in 1948, the myth obscures the longer relationship between apartheid and international law, namely the origins of apartheid in early 20th century political policy of racial discrimination, the ideological and political framework out of which apartheid was constructed and refined, which was enabled, if not encouraged, by the white supremacist international order of the day, without which further settler colonialism and then minority rule would not have been possible. That relationship between international law and white supremacy is exemplified by the prominent role of Jan Smuts in the establishment of both the apartheid order and the international order. In fact, Smuts himself argued in 1929 that the new policy of segregation that would later become known as apartheid was itself, quote, enshrined in the Covenant of the League of Nations. Notably, this understanding of apartheid as a continuation of colonialism was adopted by African states and international legal scholars alike at the time, who understood the struggle against apartheid as related to and animated by the wider anti-colonial struggle for self-determination. Only after the admission to the General Assembly of Third World States did the United Nations begin to employ the language of self-determination and emphasize apartheid as an inherent violation of that right, equating the rights of those subjects to a regime of racial discrimination and domination with those subject to colonialism and foreign occupation. By foreshortening the relationship between apartheid and international law, this myth also forecloses a more complex account of that relationship between colonialism and international law more generally, and the discourse of the other premised on European cultural supremacy and a presumed racial superiority that animated both apartheid and colonialism and international law. Notably, as third world scholars have consistently pointed out, the production and management of others by international law as non-Europeans did not end with formal decolonization, but continues today in the guise of development, of combating terrorism, and of humanitarian intervention and the like. In this exclusive focus on post-1948 apartheid, the international law myth draws on and reinforces another misconception that operates at the domestic level. As Professor Ramosa has taught us, the international campaign against apartheid, especially in the West, had the infelicitous effect of misleading the gullible into believing that apartheid in South Africa was the fundamental problem, and that once it was abolished, all shall be fine. This, as Professor Ramosa has shown, had the effect of reducing the question of freedom in South Africa to the recognition of constitutional and civil rights for the conquered people through an all-inclusive constitution. The result of that was a formal vacuous justice that not only did not restore full, integral, and comprehensive and unencumbered sovereignty to the indigenous people conquered in the unjust wars of colonization, as Prof. Ramosa puts it, but left intact the morality and political legitimacy of the right of conquest of the colonizers and their successors in title. This international myth not only draws on the spectacularization of apartheid and the erasure of colonialism, it also reinforces the ongoing reduction of the question of freedom domestically by misrepresenting the broad-based and ideologically multifaceted international struggle against apartheid to one as for civil and political rights alone, and downplaying its more radical social and economic demands, exemplified by Pan-Africanism. All the while, the intimate role of international law and the unjust wars of colonization falls further from view. The second erasure that this international myth performs is more complex, but equally significant. The claim that from 1948 onwards, South Africa was in conflict with both the international community and international law, at best oversimplifies the opposition of international law to apartheid, and more importantly, understates the continued role of international law and institutions in the maintenance of apartheid. To the extent that the international community is simply shorthand for the West, as it so often is, the claim requires considerable qualification to be plausible, as the West opposition to apartheid was late, partial, and contingent. Western governments were latter-day converts to the anti-apartheid cause and were motivated as much by a desire to protect their economic and strategic interests as they were by a concern for the basic human rights of South Africa's majority. Moreover, the intervention and sanctions helped to structure a moderate liberal transition which aided in securing civil and political rights for all South Africans ostensibly, but effectively reduced the emphasis on addressing the social and economic rights through a more radical political and economic transformation. More importantly, the claim that international law was as a whole opposed to apartheid is simply wrong. For one, what John Dugard labeled as the old Lord state sovereignty continued to be international law's central operating principle throughout apartheid. And even at its peak pariah status, South Africa enjoyed the sovereignty in its fullest sense, in a way that formerly colonized states did not, and arguably, as scholars from the Third World have pointed out, still do not. Moreover, as of 1945 and for some time thereafter, apartheid was not contrary to the law of the United Nations, nor was colonialism for that matter. And when it did become recognized as such, it was at the prompting of Third World states. In fact, much of the efforts at the UN level against apartheid were undertaken, if anything, in spite of the provisions of the UN Charter, which preserved the anti-democratic political prerogatives of the so-called great powers of the West, and continues to do so to this day. Third world pressure succeeded in organizational settings where majority voting prevailed, such as the General Assembly, but not in the Security Council, where Western permanent members voted comprehensively to defeat sanctions regimes. Even in the International Court of Justice, South Africa was able to avoid effective sanction despite the considerable efforts of African states. Finally, much of the success that was achieved at the UN Special Committee on Apartheid involved the circumvention of the international legal order by appealing directly to domestic civil society groups and constituencies in order to pressure the governments from below, as it were. All the while, the international economic sphere, whose governance Western powers had separated from the UN's political structure in 1945 and placed under a much less democratic regime, where South Africa's allies ensured its continued access to international loans to the World Bank and the International Monetary Fund, institutions that were both institutionally dominated by Western governments and insisted on established financial standards of membership, which meant that countries could be excluded only if they had not fulfilled their financial obligations, which South Africa was not. In fact, in the 1970s, while the states and international lawyers of the Third World were trying to restructure the global international economic order in order to refashion or revolutionize that order, international laws which led to the reproduction of relations of domination and exploitation, as one put it, apartheid South Africa was enjoying its golden years, with the economy growing faster than almost any other capitalist country, and white living standards going through a veritable revolution, as one scholar put it. With the continued capital infusions from the West in spite of the political upheavals in South Africa in the 1960s and the 1970s.
2 minutes,
the most generous reading of this international myth would be...
Sorry, Chris, sorry to interrupt, but 2 minutes, please.
Sure. The most generous reading of this international myth would be that it idealistically conflates international law with international human rights law, crediting the former with the efforts of the latter insofar as opposing apartheid is concerned. However, even this generous reading demands significant qualification and differentiation. For one, the opposition of international human rights law to the apartheid regime did not begin in 1945. After all, references to human rights in the UN Charter's preamble were at the hand of none other than Jan Smuts. So the reason I point out that history to think about the relationship between South Africa and international is twofold. The first thing to point out is that this ongoing myth or this misunderstanding of the true relationship between international law and apartheid creates a disjuncture between our political elite, or what we might call our international intelligentsia, and the government position, which is so often driven by relations of the global south. And that our international or our intelligentsia of the global, or our domestic elite has a misunderstanding of the relations of domination that continue to persist today. And it enables, or disenables, I should say rather, our domestic elite to be able to contribute to the role that South Africa might play on the continent through international law. The second is that it disables South Africa from playing a role in not only our own domestic foreign policy, but in the contributions to a truly African tradition in international law. And we can see that this disjuncture is so often expressed in relations, as our Honourable Chair mentioned, in respect of Bashir, but we can see the same emerging in the context of the relations in respect of Putin. And so our continued inability to grasp the true nature of the relationship of international law to white supremacy, past and present, and the true relationship of international law to apartheid means that we continue to misunderstand the place of South Africa in the international legal order. Thank you, Chair.
Thank you very much, Chris. Ladies and gentlemen, please let's come back after we eat lunch. There's one more panel that is very critical. But please note your questions. You may even want to engage the panelists, but please don't be rude as they eat there, to try to minimize the time, to manage our time when we come back. So we'll just have about 15 minutes when you come back. Now we have 30 minutes of lunch. We'll be pushing you back. Thanks.
Recording stopped.
We are resuming. Okay, thank you very much. As you can see, we already have the last panel already taking their seats, which will be looking at the way forward. Okay? I'd like to
Recording in
introduce the panel.
progress.
The facilitator of this panel is Professor Mathebula, with discussants, the following discussants: Reverend Chikana, Chairperson of Kagiso Trust; Professor Zondi, Director of IPACT at University of Johannesburg; and of course, we also have Ambassador Makhubela. Let's give them a round of applause, ladies and gentlemen. I now hand over to Professor Mathebula. Thank you.
Good afternoon and good after lunch. The work of facilitating this session is always very interesting and tempting, but mine is to facilitate the distinguished gentleman here to get us into a mode of saying, what next? If I put it in Zulu, bese kwenzekeni, sikhulumile, bese kwenzekeni. You know? Sikhulumile, bese kwenzekeni. Ibulaburile, and then say, yakwi. You know? I think we are at that stage where I'll give them an opportunity to come, they're distinguished as they are, because we don't have time. I will make my contributions as I facilitate in and in between. So I'm going to, because the last session was more an international one, and as we are recovering from Eddie Maloka and the other teams, from an international perspective, let me open up with our former head of protocol, Ambassador Makhubela, to to come and deal with, say Yakui, Papa. Say Yakui, you know, thank you.
Oh, that'd be great then.
I just said to him, if he doesn't mind, he can do it from there, if he feels comfortable there. Thank you.
No problem. This is going to be inconveniencing for me to navigate through this and have the mic in my hand. Thank you very much. Maybe, Prof, if you allow me to really abuse the podium for a minute. You know, during the last discussion on international relations, this question of Putin's invitation to attend the BRICS here came up again. And I thought I would have the opportunity to say something about that. But the issue is that we as a country have migrated international law into our domestic law. Now that the warrant of arrest has been issued out, that warrant of arrest is as good as being issued out by our own courts. So what it would take, it's any South African who will go to court and say there's a warrant of arrest for this person, and this person must be arrested. So the courts will be obliged to compel the executive to do that. I hear people speaking about the problem of al-Bashir and so on. My only worry is that once the court, our courts have said that, because it's now a domestic law, arrest this person and the executive doesn't do that, it sets a wrong precedent. It gives the impression that the executive it's allowed to defy the courts and so on. So what are the options? One of the options that I think governments should look into, I don't know what is, that's my view, the relevance of the ICC. I think it has become obsolete. The geostrategic political realignment is taking place, and this has become instrument by the West. So let's not manage things through the courts. I hear the Minister of International Relations confirmed this morning that they've sent an invitation to President Putin. But I hope she understands the ramification and how is the executive they're going to deal with that. I don't know. I thought I should say that before. I've been requested also to just look at some salient issues that came out during the last 3 days. Fortunately, I've done some details in terms of the panel that I moderated that dealt with the question of security. And of course, first was to understand the architect of our national security, that really, in terms of section 199, subsection 1, that responsibility falls squarely within the Defense Force, the police service, any other intelligence services that are established in terms of the law. That's how the architecture is. But what this panel was dealing with was this challenge of national security operating in a constitutional democracy. It's an issue that not only us are grappling with, a lot of countries around the world are grappling with the management of that. And we looked into some of the writings that academics are coming up with. There's a view that some of the academics are raising that constitutional democracy and national security are mutually exclusive, meaning that for the other one to thrive, the other one must not. And the issue here is around finding the balance. some of the issues that academics are raising, it's really the question that issues like terrorism should not make a democratic state to abandon its democratic values, meaning that national security must operate within the framework of the law. And there are cases where this is working, can be an excuse. The law, of course, and the Constitution regulates the manner in which national security ought to operate. We've had, in this country, a commission that was chaired by the late Mr. Matthews, that really made a very serious, salient observation in terms of how the abuse of national security can happen in a society, how it can be manipulated for political ends and so on. And subsequent to that, there have been a lot of commissions that are looking into, or committees that are looking into how this functions. There were some weaknesses that were observed, mainly by the commission that was dealing with corruption, that we felt there was synergies with this corruption, with this, with the panel 6D. These were weaknesses around the police services. And of course, the need to capacitate the police services. It's really worrying when you see a 3-star general, a lieutenant general, on national television saying the police will use minimum brutality. And you ask yourself, is there the understanding of what does this police officer say? The message they are conveying to the public. So those are elements, those are areas that really requires better capacity and better communication. There are government institutions that are better in communicating. And of course, it's sending a wrong message to say to people, there will be minimum brutality. I don't know if the officer really understood. It's a lieutenant general, very senior officer on national television. During a commission, I think it's 5A that was dealing with corruption, or panel that was dealing with corruption. There was a view that was raised that the SIU should become an independent entity, independent from the executive. Because the current arrangements are that for the SIU, the Special Investigation Unit, to do its work, there must be a proclamation by the president. Then what happened in a case where they need to investigate the president himself? So somebody was saying actually it's like walking a dog with a leash, and you expect this dog to go and sniff things far away and you're keeping it very close to you. So that was one issue that really came up very strongly that we thought had synergy with Panel 6D. Panel 6D, there were issues that we had hoped Panel 6D would deal with them. Issues such as the transnational crime syndicate, money laundering, and other financial crimes that are really creating a big reputational risk for the Republic. And of course, my observation as the moderator for that panel, there was no discussion between the presenters and the whole security architecture, because these things should have been canvassed, and the absence of the South African police services was quite telling in terms of really informing this conference about some of the things that we need to do in dealing with this new emerging trends of crimes. The question of the drug syndicates and heroin trafficking, that it's literally decimating our young people in society. That in my own personal view has become a national security crisis that we ought to manage as a country. Because there's a correlation between that and the crime that we're seeing in the country. Other issues that were raised that one picked up, I didn't pick up literally everything in this conference, but I want to raise things that I was able to pick up And I know other members of the panel here would raise some of these issues. There was an observation about lack of implementation of the finding of the Zondo Commission. That up to now, nothing has been done, and this observation was made in the presence of the President. But I do know in Commission 5A that was dealing with corruption, the NPA did come up to provide an explanation in terms of how they tend to deal and speed up the prosecution of some of the findings that emanated from there. There was an issue that was raised also about the question of the national security threat. A similar arrangement like the one that is done in the United States, that this assessment is then declassified. But that helps the country to start to understand and be able to participate effectively in the national security issues and really be able to be supportive to structures that are there. The panelists who were here, they were not quite firm about that, and I don't think there was a better understanding about it. But it's something that I think needs to be elevated. Many countries do that. When they compile it, it's a classified process, but once it's done, it is then declassified. And the idea there is, of course, to ensure that people know what is a threat, where does this threat come from. We did not have enough time also to discuss also in the same panel the question of cybersecurity threat assessment due to time limitation, even though these issues were raised with the panel. But of course, the panel could have been enriched by the presence of the South African Police Services. Not necessarily in the panel, even if they were on the floor, because these issues are really pertinent to their day-to-day function. We may have seen in the last few days or in the last few months that there was hacking of our Reserve Bank. It's a big concern. That's why the representative of Home Affairs who was in the panel said their biggest worry is around the protection of their database. Now, that statement on its own is quite huge, because that database at Home Affairs, it contains a host of lists, electoral lists, people who access social security and so on. So if a criminal syndicate are able to break into that, they can seriously compromise the integrity of the Republic, and there can be a huge looting from that. We may have seen also how these syndicates are working around the world. Professor is walking towards me. I know the time it's coming to an end. But there are new crimes that are there that we never had the opportunity to discuss them, like the kidnapping and the emerging mafia groups, be they construction mafia and so on. And really, the recognition here and the admission was that the law enforcement agencies they are weakened because of being unable to deal with these issues. The question of the disparity between the poor and the rich and the cost of living that is creating problem in the country is one of the issues flagged also by the World Trade Organization in terms of risks that really prevail and need to be managed and mitigated accordingly. We've seen attacks on trucks, people starting to loot food and so on. But that's an indication of the challenges that are going on. Issues related to human security were dealt with in other commission. I think other colleagues would come up. There was an issue also that came from panel 5A relating to the protection of the whistleblowers. That was very crucial also to the security panel, Because the security panel works on the basis, or the security cluster works on the basis of intelligence information and so on. We did not discuss issues of terrorism and the extent of the terrorism threat in the Republic. Those issues were not dealt with. I hope there will be a platform to deal with that. In other panel, there were issues relating to access to the justice system and how expensive it has become to a lot of people. Part of the challenges that we see in terms of the risk was also the question of service delivery and the declining infrastructure and corruption that was covered extensively by the other panel. But at the heart of all these issues is lack of political action in dealing with this malfeasance and challenges. Good things came out of some of the panels here in the plenary. I wouldn't dwell a lot in terms of them, the judiciary of the transformation of the judiciary and the pace at which it's working. Seems people are being interested. There's an issue that was raised here without any solution provided around the lack of oversight by Parliament over the executive. And what was raised is a problem. We need to find a solution to say there's a question of political parties closing ranks and in the process really preventing a better oversight by Parliament. I think Prof. Mtshekga was here, he even said there are a lot of hooligans in Parliament. I don't know why do we keep hooligans if we know they are there up to now. And the question were raised around the question of judiciary overreach. And of course, the explanation that was given is that lack of action by the legislature compels the judiciary to intervene in some of these issues. And my own observation is that a lot of people who sit in the judiciary banks, they are activists, they're involved in the struggle in one way or another. They wouldn't want to see things deteriorating if you don't find any action. The SSA, they did admit that the state security agencies, there's a need to build their capacity and fill up their posts. And that would improve their collection and so on. The border management system, Prof, there's an improvement in terms of synergies, but the big issue that came out around our security services is the synergized work and sharing of information that comes out of here. But I hope moving forward, they'll set up structures to synergize their activities. I can give you an example. I read the book by George Tennant, who was the former head of the CIA in the middle of the storm. On a daily basis, the head of what they call the Director of Central Intelligence collects intelligence from like 16 intelligence agencies within the United States. And they are synthesized and they are evaluated before they are sent to officials. We have few intelligence organizations, so the need for better coordination is still there. I would leave here, maybe some other colleagues would raise some other issues. I wanted to speak about the media panel which I attended, but I know the Prof is on my. Thanks.
Thank you, Dr. We give each panelist 10 minutes, and the sense of 10 minutes is that if you really understand boxing, it's 3 rounds plus a third of a round. And it's a lot of time if you're a boxer. It's a lot of time. Bao shapa u got that 3 rounds. So you can get the text. So that's why my apologies. 10 minutes is a lot if you have done boxing. I'm going to call Ubabu Professor Spamandla to come through. But what I wanted to also pose as a thought to the panelists when we will be discussing later is our immediate memory of a strong state, which was an apartheid one. Not a limitation for us to believe that we can have a strong state existing side by side with constitutional democracy. Because we think if we are in charge of the state, we might do what we know happened in the immediate memory. I'm just throwing it so that we think about it. Baba.
Good afternoon and good afternoon, all honorables. What we have done in the past couple of days was to conduct a reflection. A reflection is to look back in order to look forward. A reflection is to look into the past 25 years and see what you want to project to the future. And we do that because we recognize that 25 years is a long enough period for us to have worked out whether how the state was constituted 25 years ago was a correct one in relation to the need that needed to be done. But I think the message that came out of here is a recognition generally by everyone that you are in a transition. And that transition, as it happens in every society, it's a sort of an interregnum. It's sort of like an extended a period of a fluctuating movement, making progress, making reversals, doing well and not doing well in other places, advancing and retreating, and all of that. Seems to me that is a clear message about it across the range of subjects we talk about. Whether you're talking about the Constitution and what it stands for, what it is, and the tools it gives, the rights it produces, the culture it seeks to build, whether you talk about the mechanism for constitutional development, all the structures that are meant to enforce and promote democratic constitutionalism, or whether you're talking about the adjudicating tools, the judiciary, and how it has been forced to intervene in order to manage this, and how it might have overreached and stuff of that nature. The extent to which the judiciary is independent from who, or independent from what, is that independent generally positive or negative? And the idea of a resilient judiciary becomes resilient of what sort of judiciary, of what sort of judicial culture, and what sort of attitude and orientation of the judiciary. Whether you talk about the fight against the forces that seek to corrode and eat out of our democratic constitutionalism, like corruption, which is not just corruption in the manner of siphoning resources out of the state, but corruption in the sense of corroding, corrupting the institutional mechanisms that were built to assure us of a better life. Whether you talk about the effectiveness of the legislature, whether majoritarianism has risen, and whether that majoritarianism is in the interest of the majority, or is in the interest of an elite that pretends to talk on behalf of the majority. The connection between citizens and the state, whether in relation to advancing socio-economic rights, the capacity of the state to deliver good and progress in society, whether you're talking about the ability, the extent to which the Constitution enables us to conduct the transformation of the economy that was envisaged, and the transformation of the economy is not just transformation of the figures, transformation of the structures, not just the transformation of GDPs, the metrics, but it's a transformation of the very quality of lives that people have to contend with. Just as transformation of the state is not seen as merely making a beautiful stage that looks nice in pictures, but as a building a stage that is able to ensure that people have a qualitative experience of democracy. It's about experience. When I talk about equality, therefore, and issues of land reform or electoral reform, international relations we spoke about now. Seems to me there's a recognition that we are in a transition, and in this transition, there are many ways in which we've advanced forward, there are many ways in which we have retreated, there are many ways in which we have stagnated, and all of these symptoms of this transition swing us from a moment of excitement to a moment of the negative excitement, which is anger and dismay and things of that kind. It seems to me that in this whole process, we get a sense from the discussions just today, in the past couple of days, that we're reminded that there are 4 undertakings the Constitution has made, and undertakings about what we should do. One is to heal the divisions, healing the divisions of the past, and healing the divisions of the present as well. Because in many ways, the past lives in the present and stuff like that. Get a sense that those divisions, we thought we had overcome some of them and they keep coming back. It seems that people live with a thorn in their flesh and it has not been taken out, because to take out a thorn in African thought, in indigenous African thought, the best way to take a thorn is to use another thorn to prick it out. It seems we might have avoided the pricking. We might have avoided the stabbing that was necessary. The second undertaking gives to us is to build an open and a democratic society. And I get a message that there are many ways you could see how that was done. The efforts are remarkable, but the outcomes still show a mixture of good and bad. That the society, our democraticness, our openness, has certain limits, such as how do you have an open and a democratic society when some people are trapped by poverty, when some people are trapped by tribalism, when some people are trapped by racism, trapped by xenophobia, and other elements. How do you realize that to the full without that? So you get trapped between procedural change and substantive change, which is the change in the substance of the lives of the people. The third promise was to improve the quality of life of the peoples. And you get a sense that some progress has been made here. There's very good figures about how much we've done to increase access to electricity, to water, and all of that. And then we move from quality, which is great, to quality, which perhaps isn't that great. We have access to electricity that we don't have half the time. So we have access to it, but we don't have it. We do have access, but we don't have. Yeah, so then the fourth one and the last one was to build a united South Africa that takes its rightful place in the family of nations. That there are many ways in which this has been achieved, that we broadly united about who we are in the world and all that, but there's a recognition that we are also divided among ourselves on many things, including this Ukraine issue, into this summons on Putin. We divided in a number of areas and all that, but broadly united about the need to build a better South Africa, which must be in a better Africa and in a better world. But the extent to which how we exercise leadership on the continent, leadership in the world, what we do and what we do not do, where we move, where we do not move, says something about a sense of interregnum, a bit of transition in our situations. The questions of poverty, of alienation, or inefficiency, of capture of the state, not just by the political elite, by the economic elite, by other elite, forms of elite, the sense of dislocation, including the dislocation of citizens that end up on the sidelines, caught very close to despair, the sense of exclusion, stagnation, reversals, and recognition of a changing global environment. And lastly, seems to me that there is been a very strong message about a transition as about a lot of progress, but incomplete progress. A sort of like what the president said at the beginning, ongoing efforts, like it's a project in progress. And that in that progress, there are always dangers of reversals that come from corruption, come from these unresolved socio-economic issues, that come from a change of political attitudes, what Amilcar Cabral called the sins of forgetting and working. In the end, what we get is a sense that what we need at least are 5 things. 1, we need to reconnect to the dream. 2, we need to remember the promise, which is what we undertook to do. 3, we need to work a little better to act on what we have decided, implement. 3, we need to continue to refurbish and strengthen and consolidate compacts and relationships and partnerships. And lastly, we need to strengthen institutions and strengthen citizens' agency. And I think we've made a good reflection, and I hope we will act on these things. Thanks.
Thank you, Prof. Thank you. There's a book that I've read by a gentleman called Mandla Letlape. He's around here. The book is Dream Delivered. He argues in his book that our constitution, the way it is, it has delivered the dream. We might not be living the dream, but it has delivered the dream. The extent to which that it's correct, I think it's what we are reviewing today to say, is our constitution in truthful sense, has it delivered the dream? So last year in August, and I'm saying it deliberately, last year in August, I think on the 24th of August, the Department of International Relations launched a document which was defining our national interest, which tells you that for almost 24 years of our democracy, we had a public service that did not have a national interest to defend. It means our national interest was not defined as it is succinctly defined now in that document. That national interest is defined as the duty of every South African, whether in private sector, church member, business, is to protect and promote our national sovereignty, our constitutional order. That's why it's important that we show about this constitutional order if it's the right one, because our national interest now includes protecting it and promoting it. The other one is the well-being, safety and prosperity of citizens. That is a deep one. It's a much more service delivery interest. And the last one is a better Africa and a better world. Let me call Reverend Umfundisi, Dr. Frank Chikane to come and be our last panelist, and then from there we take a conversation. Thank you.
I worry when I get introduced as doctor in the presence of professors. People call you doctor for honorary degrees in an academic setting, no. But in any way, thank you very much. May I thank you, Chair, for making me speak last so I can try to beat them on time. I'm going to try my best, and I would like to also recognize the Minister I wouldn't stand here because I've seen him, not recognize him, and all the dignitaries here and colleagues. My approach, it's going to be different. I'm going to try to reflect on the issues, but not spend too much on them, restate the areas of concern, and then look at the way forward. And if I still have time, engage some of the issues that have been raised. I've gone through the summaries and reports, discussions, and I found this very interesting, listened to some of them, very interesting. I think we are real classical South Africans. This is the best of democracy. So what we are doing here, it's actually democracy. One thing sure is that we have one of the best constitutions in the world. I think we should not forget that. And I used to say the best, not one of, but the best. But academics tone my language to say one of the best. So that if there's another one, I can survive. And it guarantees our rights almost to the ultimate limit. And I'll come to that. Some say to extremes. And I just want to say, for those of us who are victims of the apartheid system, who developed, who participated in producing this constitution, wanted to make sure that no one ever violates our rights again. That was the objective. And we looked at all models and constitutions, Canada, Sweden, and many other places, and chose the best to protect the rights of people. But the complication of that is that then other people use that to fight your progress in ensuring that people have their rights. And I think we should accept that as a reality. We must recognize that it is the Constitution that saved us from state capture and slipping into dictatorship. If you were sleeping in the last few years, you wouldn't know that we nearly landed into a dictatorship. If anybody captures the intelligence services, the police, the prosecution authority, and there was an attempt to capture the judiciary. Once you get the judiciary, then you've got an Italian mafia. And we nearly arrived there. We are still under enormous pressure, and the criminals are trying to run this country on that basis. Fourth, our failures are not because of the Constitution. They are failures, our failures, government, legislatures, and the people, ourselves. I would like to restate the concerns that we have failed to inspire active citizenry. We have created dependencies where people expect government to do things for themselves. If we waited for government to do things for ourselves, we'll still be oppressed. And I always remind people that we used to sing the song, Qinisela Mandela uzozwa ngathi uma sekulungile. We didn't wait for Mandela to come out of prison to liberate us. We had to liberate him from prison. And unfortunately, the legislatures, in terms of participatory democracy, we have failed. We even had this concept of ward committees. In my ward, I've not heard it. I was there when we created those structures to make sure there's participation of the people. There isn't. And then I would like to say that the legislatures have become a forum of protecting or pursuing party interests and individuals rather than people's participation. We have failed to pursue effectively socioeconomic justice, including the land restitution question. Instead of a progressive realization of socioeconomic rights, we are beginning to regress. There's a time when the statistics showed we're making progress. When people said, no, we are worse than apartheid, I used to defend that. But in the last few years, the numbers are beginning to turn around. And with our dysfunctional municipalities, etc., I mean, to have a country with 42 dysfunctional municipalities by 2021 is just unacceptable. The way forward, I would like to say that we need to mobilize the masses of the people, the citizenry, to participate in ensuring that the provisions in the Constitution are realized. You see, the Constitution doesn't realize itself. It's the people, it's just a document, but the people need to do that. And we won't do it by waiting for government or a department or parliament. It's the people of this country who should organize themselves to make sure we get it. And then put pressure on government. Governments have other dynamics to deal with and contradictions. I've been there myself, so I know what I'm talking about. And unless there is pressure to assist them to cross the line beyond the contradictions they are dealing with, they will not be able to do so. In one of my classes, I won't tell you where, but the professor came and said, government is about mediating conflicting interests. So if you pick up any issue, there are conflicting interests on that issue. And therefore you need to deal with them, and the political parties and the people. Because I have some more minutes, I'm going to just quickly say the issue of national security, which was raised here, and one of our colleagues have raised it. I was there when we dealt with this matter. At the beginning, we had no National Security Council. But by 2002, I think, we went back to this concept and debated it amongst ourselves within government and created a national security concept that is compatible with the type of constitution we have. And I would say, let's go back. The documents are there which did this analysis. Second, on the electoral reform, I was one of those who resisted proportional representation until I got convinced between 1991 and 1996 that if we didn't do that, the minorities would have disappeared day one. We'll never have them there. But after a number of years, we realized it's not working properly. And I believe we just have to have a mixed system of constituents and proportional and balance them up to make sure we don't have the extremes. I wouldn't want to go into details about that, but I think the issue about what is called independent, candidates has complicated the issue instead of deal with the real issue. We stuck with that. I would like to say, for the putting matter, I think what the conflicting parties have done is to do a checkmate on us, so that we deal with the checkmate rather than the issue itself. It's amazing, actually. But we need to go back to the point that we shall not have peace in this world until we abandon the idea of hegemonic power, where one must have power against others, and that others will not have the rights. We need to move away, because that's the best way to create conflict. I mean, the way in which the United States deals with China, if they go ahead in 5G ahead of us, we must apply sanctions because they mustn't go ahead of us. Which means if we produce the best scientists here, which discover something that threatens their power, we're going to be victims. And I think we need to redefine that. I'm worried that we're now stuck with the they checkmate us and we get stuck with Putin's visit, but actually move away from the real issue that we need to deal with. And the last two things, I would like us to go back to the developmental state, our facilitator. A developmental state which we abandoned on the way. It's a strong state with capacity to deliver. And it's not a weak state. And I believe it's of vital importance that we just go back there to the concept that we developed, researched, and abandoned on the way. Why? Because of interests of individuals rather than the Constitution. I just want to say, sir, when we put on that Constitution, we didn't have a strategy to defend it because it was clear that you're going to have people who will make sure you fail based on self-interest, including my own comrades, because I worked together with them in government, that they are also human beings, and pursue self-interest rather than the interests of the people. And I think that's critical. Thank you.
Thank you. Democratic concepts are interesting. If you talk about redistribution of wealth, there are criminals that are busy thinking that they are deep in that function. So we need to, when we make concepts and define them, what do they actually mean in practice, so that people don't reason criminality as redistribution of wealth, as Professor Thuli Madonsela shared with us, that study about the World Bank, where there is a close relationship between corruption and the need to develop. So we need to be careful about that. I'm going to allow you to ask few questions, but please, this must be way forward questions. We don't want to hear new things being raised. That time in Julile, you were in the various sessions. You were allowed to make inputs and deal with content there. Now here we want to hear your inputs and questions about way forward as they've suggested. Just to recap, Dr. Kingsley recapped for us the national security issues, but all of them, they dealt with a number of things. And those things have more to do with, we need to take this process further than Gallagher Estate. You know, when you come to Gallagher Estates and you make decisions and you don't implement them, some people go and establish parties on your decisions, if you hear what I mean. They take your decisions, good decisions, and establish a political party with them. So we must make sure that this Gallagher comes with a process to implement what it has decided. Okay, let me see hands. I'm going to start this side. I see that orange T-shirt there. There's a mic there. I see CC here. Yeah, I've noticed you are number 2. There's no mic next to you, so you can walk there. There's a mic at the back behind you. There's a mic at the back behind you. Yes, I see Krila there. I don't see a mic there. There's a mic there, Krila. There. So that where the mic is because they want to project on you. Golden, I see you. Go behind Krila there. Where the mic is there. I see a hand there. Follow them that side. And then there's a hand with a jacket there. then I'll take that as the first round and potentially the last, depending on the time. I fortunately have that discretion to decide whether it's the last. Okay, Astrale Lapa Baba. Tell us who are you, where you are from, but don't share with us your CV. The orange guy there, you are the first. Yeah, orange t-shirt, yeah.
Thank you very much. I'm Thandolwethu Dlanga. I'm from the University of Pretoria. The way forward. One of the important things on the panels that were taking place here was the equality, gender, class, and race. And unfortunately, at this panel that is looking at the way forward, first of all, there is no female representative, but also secondly, that there is no clear direction as to how to relate to that. And the reason is that even in that panel that was dealing with the issue of gender and equality, you had about, if one were to say, about 16 people as compared to other panels which had over 30, 40 individuals. Now, my view is that going forward, the issue of gender equality must not be placed in the periphery of the conversations, but it must be at the center of the plenary. Thank you very much.
Okay. Thank you, noted. Yes, ma?
Okay, I am Kwanadi Mamabulo Letoaba from PEC Gauteng Judiciary. I'm going to state one key issue and one way forward. The first key issue is that of housekeeping. That I'm so sad because where I grew up, there are a lot of tension because of when you did this constitution, which is so beautiful, you failed to do the housekeeping. Let me give an example quickly. I have a house, I have 2 children, and I have a wife and a husband. I know who are staying in my house, but I let the relatives to come and stay in my house, but I have bread for my family alone. How am I going to feed the others? Am I not compromising my children? So you did the same. You called all these people from all African countries to come and stay here. You didn't check whether we have enough resources. You didn't even check of enough infrastructure and so forth. Now it is difficult for you to amend whatever that you did. Number 2, it's about public consultation. Now you realize the importance of public consultation. If you don't consult with your people down there, you are going to fail with whatever that you are doing.
Okay. Let there be light there. I felt like in the Genesis prophecy. I said, let there be light, and then light was there.
My name is David Musoma. I chair the CRL Rights Commission. My question has to do with the process. It's a process question. I want to know, after 3 days of hard work, what are the key things when done? All of the concerns we raised will be solved. I'm raising this question because it's not the amount of things that you identify, it's the priority of the things you identify to unlock the process and to give effect to the change you desire. So I want to know, Because if we write all of the things that we have said today, it may be difficult really to come up with something substantial. Secondly, the issue of land has not been touched there. We discussed, it was very emotive, and there was one proposal which stated that we need to have a unit that looks to the issues, the kind of claims that were made, almost 5,000, which are outstanding, to clear that up so that new claims could be opened up. Thank you so much.
Wapman,
Yeah, I take inspiration that there's a reverend on the panel, and therefore truth is not negotiable. First thing, I think the posture of this conference is incorrect. The posture of this conference is about romanticizing the Constitution instead of saying, what is it that we need to do to make sure that the Constitution does what it was supposed to do? Is it doing it? I think the Constitution, from the emotion point of view and all of that, is all fine and good. But when you go to the detail is a problem. It's a problem also because if you look at the input here by Professor Maluka came here with a very impassioned presentation. But if you go to the detail is actually, would characterize his input as actually propaganda. He comes here and he says that 1994 ushered in decoloniality, as it were. The truth of the matter is that 1994 actually brought in sophistication of colonization. That's what it did. What happened, very briefly, 1961, Verwoerd of all people, take us out of colonization and establishes RSA, South Africa, and gets out of the Commonwealth. Enza namaqabane kaThamuna figure in 1994, the very first project was to take us back into colonization, into the Commonwealth, and by so doing, colonizing us. So what has happened as a result of that, they then agreed that the cutoff date for land restitution must be 19 June 1913. That was to accommodate the land dispossession that happened all the way from 1652 up until 1913. So what we have now, we have a constitution that has sanitized the land theft, basically. This is what we have. We have a constitution that has said all the land taken from 1652 until 1913, forget about that land. This whole discussion about land now is about the few farms that were taken after 1913. So I really think we are not doing justice to the subject. Lastly, as I sit down on the Putin matter, Dr. Makubel, I think as you call out the obligations of South Africa, it's important to listen to what Russia has said. I've read somewhere that Russia has said they're not part of the Roman Statute. So how can you, what is the legality of that warrant? And I've also heard that Russia has said if you touch Putin, you would have declared war on Russia. Does South Africa need that?
Thank you, Chair. If my memory serves me well, you introduce yourself as professor. Are you a professor?
Yeah, well, they call me that, yes.
Thanks, Prof. Sorry for my indulgence. I've heard you said you read a book, and the author is here with us. And because I now suffer from self-inflicted and selective amnesia, I now forget what's the name of the author who's here. And then you said there were certain aspects that attracted your attention. You gave the bullets, you know, and whatever you said, I hope you were going to say that what we need now in this country is loyalty of fellow South Africans. You see, apartheid has gone so far and it's living its legacy, because the apartheid architects, their supporters, followers, and sympathizers were loyal to the Afrikaner bond and Afrikaner folk, and they were loyal to a land which they found here. Now, I think in the book, maybe the author must add something of loyalty of our people. You must be so loyal, but it must come with political support. You must not allow somebody coming from somewhere to come and tell us here what to do. It doesn't matter how rich or how influential that person is. When that person comes here, he must stand in the queue and he must be told, here is in South Africa. That is what we need. We need loyalty, Prof. We need to talk with our children to look after this asset, because we've got nowhere else to go if this loyalty is taken not care of. Thank you.
Thank you. I'll shy half round. Shy half boxing round. Thank you, Golden. Yes, Baba.
Greetings to the Honorable Chair and or the MC, sorry, for this session, and greetings to all the leaders that are here. A special greeting to the Honorable Dr. Frank Chakani, who is a forefather of the Christian faith. My one question to the international community or legislative is it's regarding the Anti-Semitism Act towards Israel. And here in South Africa, I think we have, according to our constitution, is that the minority is not supposed to be controlling the majority or having more say than the majority. Most of our Christian community, they look at Israel as their home, as their holy land for them to go and visit Israel. And we, through this economy, the economy draws a lot of revenue through that. My question is, I think we as South Africans should come clear, where do we stand with regards to anti-Semitism? Thank you very much.
Okay. I don't remember selecting you, did I? Are you the last one?
There's a lady behind me.
Okay. Okay, thank you. You are the last one, ma'am. Yeah, that one, yeah, please. And then Pelil.
Greetings to everyone. My comment is directed to the Minister. Minister, my name is Bongegile Msibi. As I'm standing in front of you here, I can see here on panel 6A, we talk about promotion of equality, race, gender, and class. As I'm standing here in front of you, my body is a crime scene. I was sterilized, my uterus was stolen away from me when I was 17. And I'm not the only one. As I'm standing here, I'm representing thousands and thousands of women that have experienced what I have experienced. The youngest group in my support group is 15 years old that was sterilized for no reason. It's been 18 years. If you can ask me today, why was I sterilized? I don't know. There's not even a verbal explanation. There are doctors that are implicated, that are known, that are being defended by the Department of Health. And your department is refusing to do its job. Your department is refusing to prosecute. Medical records are destroyed. It's a systematic cover-up. Our bodies are a crime scene. We know the perpetrators. We have done everything in our power to access justice, but the Department of Health and your department are gatekeepers. We are unable to access justice. Right now, as I'm standing in front of you, I was told that the department cannot take accountability of my stolen uterus that was God-given to me. They're saying they can't take accountability of my uterus. What do I need to do? What do we need to do? As I'm standing here, I can assure you there is a woman that is being sterilized out there. It has not stopped. It is still continuing. It's so sad that our democratic government took over from the apartheid legacy system and continued with this cruel and evil practice. The CGE
submitted a report that clearly states that what happened to us and what's still happening is a torture against humanity, against a woman. My right as a woman were violated as a human being. I'm coming here on behalf of every woman that has been ever sterilized in this country. We are asking you to prosecute. We are asking you to let your department do what needs to be done. I'll tell you, a previous MEC from the Department of Health said to me, a mere member of the public, we will see who's going to have the last say. A member of an executive playing a power game with a mere member of the community. Just because I'm fighting for accessing justice. There's a huge difference between law and justice, MEC. I know, Minister, I know that you know this distinction, the difference between that. We are asking you now to consider justice, not law, because law is against us as the member of the community. We are taxpayers and we are voters. We ask that our tax works for us. We ask that our vote works for us. Thank you.
Thank you, ma'am. You're the last, Sisi. No, you are the last. Lo in Temhlope, she is the last, nobody else. We switch off the light. I counted the hands, actually there are more now. She's the last, that one. Thank you.
Thank you very much, Chairperson. My name is Ethel Khadebe. I just want to raise two issues for a way forward.
Thank you, ma'am.
Yeah. We want the national security to deal with the safety of the citizens of this country in terms of the proliferation of arms in our country. We have everybody armed in our country, and that's why we have also these high murder cases, this high violence against women and children, murders. We want a way forward that perhaps a special unit must deal with this issue of high crime levels in our country. The second one is, I am not happy that we didn't deal with terrorism. How will be the way forward? But I think that I leave it to the national security, because we have had media reports that in our country there are cells of terrorists. We had a case of the ISIS twins, those twins who were arrested. So we need to be proactive about issues of terrorism. We know there's war in Mozambique, Somali, Congo, and so on. It is not far from us. And many of those people, they are also, some of them, terrorists. The last one, we want the truth. I know there are, what do you call it, ombudsmen for the media in South Africa. And there are certain professional standards for them, how they report. But the media is a critical tool to inform the citizens of this country about the truth. And in many times, we don't find the truth in the media. It cannot only be the pushing of profits at the expense of the people and the truth. The media needs, if they are here, maybe their leadership or so ever, we need a balanced reporting. There's no balanced reporting in our country. They are reporting about political parties, non-issues that affect people. Thank you.
Okay. Thank you. Can we switch off the light there? Let there be darkness. Thank you. Okay. I'm going to ask the panelists to respond, but I'm going to ask Dr. Makhubela to deal with that one of security. I'm not excluding other panelists, but I'm saying if you could deal with it extensively so that others can just quickly add on what you're saying. And then there was an issue about nicely coached, but there was an issue about housekeeping. I'm not sure who's going to deal with it. And then after that, we'll take your comments. Then I'll then do a summary, and then hand over to the program director, who will then introduce the next session. Baba Kingsley.
Prof, thank you very much. I think, excuse me, the manner in which the conference was set up, there was a recognition that the question of security is paramount to all of us as citizens. And security in a very broad sense, including food security, human security issues, and of course the physical security. And I think what came out of here with the people who represented the security establishment here was a recognition and the realization that they need to better coordinate their work to provide security. And they have admitted that part of the challenge is its lack of coordination amongst themselves, and there's going to be an improvement. And of course, there were people who shared how they can better improve. I think we'll see what comes out of that. And of course, the issue that was raised with them, this national security threat assessment, that at least citizens need to know. So they would take that back, and perhaps it will feed in some of the recommendations that are made here. Mani, you're quite correct. Putin's is not a signatory, or Russia is not a signatory, but it's a responsibility of a member state of the ICC that anyone who sets foot in their territory must be arrested. And if you remember, the Rome Statute indicates that anyone who's implicated in genocide and war crimes, they don't enjoy immunity. Even though heads of state by nature, they have immunities and privileges. But in terms of the Rome Statute, they don't enjoy that. And of course, the obligation will be on us to arrest if he arrives here. I don't know how is it going to be managed, because it's the decision of the courts, because it's a domestic law. It's our law. That warrant of arrest is South African warrant of arrest. So how would we defy our own court? So that's where the challenge is. I don't know how it's going to be managed. I hope maybe the minister here can provide some clarity on this. Thank you, Prof.
Thank you.
Yeah, I'm going to be less than 1 minute. I think under the way forward, the issue of grassroots participation in dealing with the Constitution, but from the perspective of their needs. It means you can't go there and say, here's a Constitution, let's talk about it. You must go and say, there's sewer in the street here. The Constitution doesn't want it, let's deal with that. That's the education for me should be around the issues rather than try to go to people who are victims and talk about Constitution, which becomes luxury. The other issue is this issue about anti-Semitism. I don't know what the issue is. Can I just say, South Africans are not anti-Semitic in terms of the right definition, not the definition that stops you from saying people are brutalized in Palestine, therefore you are anti-Semitic. And it takes us to this issue about Putin. The United States is not a signatory. They've victimized prosecutors in the ICC for pursuing US soldiers. And you'll never charge a president of the United States on that law. I think what we are dealing with, it's our own, as that Makubele is dealing with it. It's more about checkmate. It's what are we going to do now? I don't want to digress now, but I mean the crime against humanity of bombing Iraq when you know you've got evidence that there's no weapons of mass destruction, we know that. But nobody has been charged. So it's a power dynamic we're dealing with. That's why I'm saying for me it's a checkmate. South Africa, the government will have to sort out this technicality. But the same people who would charge Putin will not charge the president of Israel. However they kill people there, they will never do it. And the Americans say so, will not do it. So I think we've got a complex issue about power, hegemony, control. And that's where we're going to end up. in my view. Thank you.
Umfundisi, DG and Minister, the Reverend has requested that at the end of this session he is also out of time, and that's the mandate I don't have, but I'm just assuming it that I would release him. He did explain to me. But just by way of summary, all the sessions, 16 of them, there were 16 thematic areas that were designed to make this conference. I don't think anybody, including the department, hoped that they are going to exhaust everything in that thing. But those 16 thematic areas, my information is that they are going to be packaged into thinking spaces where they are going to continue having conversations about them, because this is a first bite at saying, where are we with our constitution? Are we where we wanted to be when we passed it in 1996? Are there any things that we need? It's a mid-course evaluation of our constitutional democracy. So one author, one scholar says that our constitution gave us the ability to be democratic. It put us into a process to be democratic, and this is one part of being democratic. So we should then say, how do we move forward? The second thing which Vali Musa stressed was that we need to make sure that we educate the generation, the younger generation that is coming behind us, especially between 34 up to 10 or so, because those are the people that will defend this constitution when it gets threats from other people. The last one is that we need to talk about, do we need to talk about the Second Republic Constitution, or do we need to talk about this Constitution 2.0 and take this one to be 1.0? When it's 2.0, it means we don't change the essence of it, but we look at what do we need to do, how do we need to adapt it to our conditions so that it starts to communicate to our people. So this is what the way forward that has emerged, and it came out of all the sessions. There was also a big concern on the accountability and oversight ecosystem, to say, how do you, I think Mam Muchangu Gumbi spoke about it, how do you have a constitution that says you constitute a parliament, and out of that parliament you get an executive, and you can only get an executive out of that parliament? So it means the parliamentarians of any governing party cannot do to the executive what they don't want to be done to them when they are there. So she said, how do we deal with that? So that's looking at the oversight and accountability ecosystem, how do we revise it? These are all work in process, but my information is that there will be thinking spaces, there will be a process of massive education of society about the Constitution, and there will be a rollout of this conversation to other spaces in society. DG, thank you for the opportunity as we close this session and hand over to you. Ladies and gentlemen, thank you for your attention. And sorry. Thank you.
Thank you very much, Prof, and to the members of the panel. Ladies and gentlemen, we won't take much time. We'll take this opportunity to invite the minister to make some closing remarks. We see time is against us. Thereafter, Mr. Chilwane will come and do a vote of thanks and give the announcements. Minister, we invite you to address us. Thank you. We can welcome the minister to the stage.
Thank you very much, DG. Mine is not is a lot. It's just to say that from the way forward discussions and from all the inputs that we have received, in the conference. It's clear that for us, as a department charged with constitutional development, we have to renew and reawaken the branch on constitutional development. As you will have heard when the president was here, that most of the constitutional development that has happened beyond the adoption of the constitution and after it was adopted has been through the courts declaring these statutes to be unconstitutional and that law and that, and then we had to amend certain laws. But it has not been out of active state development of the constitution to develop it to respond to the society that has been evolving. And that means that from the outcomes of this conference, we'll be able to channel the inputs through our constitutional development unit, and hopefully we'll be able to find resources somewhere so that it's able to do its job of the development of the constitution, so that we don't have to wait for the Concord to tell us that this law and that is what we need to develop. We should do it as a duty. And secondly, that may also help us to yearly and from time to time, at regular intervals, make inputs to the Constitutional Review Committee, which has got a duty to review the law, the Constitution, in terms of Section 45C, the committee chaired by Prof. Mutseka in Parliament, and make inputs on the development of the Constitution. So I do think that this conference has been very helpful to us in pointing some of the challenges where we need to iron out certain issues and where we need to strengthen. So we have learned in the past 25 years, and those lessons have come through in these 3 days of the conference. It is what we believe is the value of this conference to help us re-energize that constitutional development function that has been given to the Department of Justice as an executive arm of the state, that the constitutional development did not end when the Constitution was adopted. It should be a continuous process. So for that, we are very grateful to all the participants for all the inputs, and we will channel that process as the DG and some of the issues raised in the way forward, that some of them, the discussions may need to be concretized through papers from the presenters. I hope they will find time to help with papers and also to channel them through some of the relevant departments with engagements with them as to how do we take the processes forward. And one of them, which came through very clearly, is on the land question, which already the Constitutional Review ad hoc committee dealt with it, but it's clear that we need to do more to move towards implementation. And there are also various issues related to security, the rights of victims and the rights of offenders. How do we balance that in this period going into the future where society feels unsafe? And a number of issues that has been raised. So we have taken note of this, and hopefully from the resolutions, we will then be able to have come up with a clear implementable program responding to how do we continue to develop the Constitution in an effective way, which is coming out clear that the key issue is not whether we have the law or not, it's how we execute and implement it so that we have a simplified and implementable program. So that is my few closing remarks to say that we have heard all the issues and we will carry them through, and we'll also ensure that the executive is aware. And we're also glad that all the arms of the state also participated in some of the discussions, and where they also have to participate to develop the Constitution on their own, they will continue to do so, also informed by these discussions. Thank you very much, DG.
Mr. Chilwane, please. So part of what we'll do, Minister, we'll ask the speakers that were here and facilitators to, in the next 2 months, to prepare papers, the notes that they utilize to convert them into papers,
and we'll do a compilation of a journal. And even some of the participants that may not have necessarily led the discussions, they can also be given an opportunity to develop papers. Mr. Chulon.
Thank you, DG. Thank you, Minister. Maya Angelou once said, "Be present in all things and grateful for all things." We are grateful to all of you for having made this conference a success. Firstly, let me thank the Minister for your wise leadership. When we came to you, Minister, with the idea of organizing this conference, you encouraged us to go all the way and organize what has become a successful conference. DG, we thank you. You have been DG, we thank you. You have been with us in this journey. It was a really tough journey, but we are happy that today we are here and we have made it. Thank you, DG. And to the most important people, you colleagues that are here today, the facilitators, the speakers, and all the organizers who were part of the organizing team, we say thank you. Your views as participants, as the Minister has already indicated, are going to be included in what is going to be regarded as a historic conference. Thank you, and thank you once more. I thank you. Oh, sorry, the last item, we are going to have our performers who are going to join us on stage and render a cultural performance. Thank you.
Thobela bana ba mma re a lo tšha bana ba mogalabe ke re tsamaya kgoma ke yo pele naka gobane tšešo tsona ke dikolo eupša yona taba ke tlo lefa yona seroka phatla ke re bapedi ba tokwa le bagatla ba ntseba ba ntšhaba ke senatla ke na le maatla go mea go aša ke go na le digwatla ke go fe tsona go tlala seatla se fele pelo sa mma go wena ke satla re sa tlo ipsina ka todi ya polelo lebebe ra jela dikgopolo ka madimabe ga ke a swara selepe bjale re tla rema ka dika le diema ra go tša molwa go bediša pitša tša bana go khumutša leleme ra hlwekiša polelo e re polelo a ke mabarrebare a lemela bogale bjalo ka legare la go senola la mohlagare go bipolola tša ka gare a re a le rare ke la mosegare le rwele diphiša mare ke tšona polelo tša setho ke tsela tša badimo tše di le ga maoto na khunyela molete mohlaela thupa ke tša bomantšhege le bomatwetwe ga o na o re nka dingala di re se thobe matswalo bjale ka thothotho thathe thiba thala bodiba ka mathading thako thaka gapa thoko re thuše thakadu e se rage dingwatha meratha ratha tladi ratha pelo ya maratha thago gare thagale thubagale thabathupana thuthupa bjelo ka dithuthupe thethegeta thinya le melethanye thaga sethaga nka di be mangware ke gwarinye lefoko theletša thibola tsebe thithibane ye ke theto e theile mothalading tetero thapiša polelo ka mathaithai thwithwi ke re thobela bana ba mma re a lotšha bana ba mogalabe ke re tsamaya go mario pele naka gobane tšešo tsona ke dikolo eupša yona taba ke tlo lefa yona seroka phatla ke re bapedi ba tokwa le bagatla ba ntseba ba ntšhaba ke senatla ke na le maatla go mea go aša ke go na le digwatla ke go fe tsona go tlala seatla ke re se fele pelo sa mma go wena ke satla
my creatives, Rutla no jang tlhakole mama rutla, ka re ba ro ngaka, he ngaka bolela. Ba ro ngaka, he ngaka bolela, kgosi e rile. Ba ro ngaka.